Krishna Kumar Saab being spoken to memo madle pata I put a very correction. ಅದು ಎಡಕ್ಕೆ ಕನ್ಕ್ಲೂಷನ್ ಏನು
ಅಂದ್ರ
ಬಂದಿಲ್ಲ ನೋಡ್ರಿ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಬರ್ತಾರ ಹೌದ್ರಿ ಇಲ್ಲ ಇಲ್ಲ ಹೇಳಿ ಇರ್ಲಿ
Move for posting election of Gram Panchayat at the end of the list. Yes.
Move for being spoken to typical error 2B del previous
230 my lordship. One tax matter attachment is 230 ಏನಕ್ಕೆ? Tax matter.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಒಂದ್ ಪಾರ್ಟಿ.
ಹಾ?
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್
ಆಯ್ತು, ಒಂದು ವಾರ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಬರುತ್ತೆ ಬಿಡಿ.
ಇಲ್ಲ ಮಂಡೇಗೆ ಹಾಕಿದ್ರೆ.
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ಏನಿದೆ?
One B group matter, my lords, 2019 B group matter, my lords.
Huh?
2019 B group matter.
Being
spoken to, my lord. Being spoken to, my lord. Please.
What is it?
B group matter.
Confidence matter,
Madam.
end of the list. Gram Panchayat, no confidence matter, end of the list.
B group matter. Submission. Monday.
ಅದು
Submission. matter.
ಯಾವತ್ತು ಬರುತ್ತೆ? ಮಂಡೇನಾ?
Service matter, end of the list, my lord.
ಏನು
Petitioner was appointed as an assistant in the Krishi Vignana Kendra. Later, he has been promoted as a senior assistant. Later, respondent number 125 issued seniority list. Without considering the seniority issued by themselves, they have ordered to take charge in the place of respondent number 7 to the respondent number 6 without considering the seniority list, my lord. Therefore, till today, they have not taken respondent number 6.
ಕಮ್ ಆನ್, ಯಾವತ್ತಿರೋದು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವತ್ತು? ಬುಧವಾರ.
My lord, the 2 days back, it was listed due to technical error, the lordship adjourned the matter,
ಬುಧವಾರ ಬರುತ್ತೆ.
at least Monday.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಆನ್ ವೆನ್ಸ್ಡೇ.
Signing with end of the list, I am seeking, my lord.
ನಮ್ಗೆ ಹಾಕಿದ್ message.
37.
52 you. Short account next week it may kind of. That's my,
ಆನಂದ್ ಜಾಗೀರ್ದ.
yes, my sir.
ಯಾವ್ದು?
ಯಾಕೆ 2019 petition?
Yes, sir. Earlier it was heard your partly.
ಅಲ್ಲ, ಆಯ್ತು,
They were
ನಾನು-
to respondent were out to file the statement of objections. Till today they have not filed. They are appearing by video conference from Dharwad, your lordship, not local.
Counsel for the petition seeks time as the last chance list on.
ಇಲ್ಲ ಅವ್ರ ಏರಿಯಾಗೆ ಹೋಗ್ಯಾರ.
Much. your lordship.
Serial number 60, this tax matter kindly next week will also.
ಯಾಕೆ ಟ್ಯಾಕ್ಸ್?
ಇದು 16/4 issue ಭಾಳ ಪೆಂಡಿಂಗ್ ಇದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದಕ್ಕೆ ಒಂದು ವಾರ ಟೈಮ್.
Serial.
There is interim order.
Counsel for the petition seeks time list on.
Serial number 56, 57, 58, my lordship. Earlier Amit Kumar Deshpande is appearing for the department. Now he is them, not there. We undertake.
Who appears for the
No.
department?
Tirumalesh is appearing for the
C.
department.
Tirumalesh.
Tirumalesh.
I have informed them, your lordship.
Is directed to accept notice for the respondent. Counsel for the petition is directed to serve a copy of the writ petition
Please.
along with all enclosures to Mr. G. Tirumalesh.
Interim order.
Is directed to show his name in the cause list. Interim order granted.
M.
again
Tirumalesh.
is Yamma.
M.
M. Tirumalesh is G na.
Tirumalesh ಅಂತಿದೆ ಅಷ್ಟೇ.
Only Tirumalesh things.
Office is directed to show his name in the cause list.
56 to 59.
56 to 59.
Interim order is there, my lordship.
I
Kindly.
extend ಆಗಿದೆ.
Please.
52 to 60.
My lord, serial number 66, I appear for respondent number 2 to 4. I have misplaced the file, my lord. I'll collect the file and next week it may be taken, my lord.
Counsel for the response 2 to 4 seeks time. Are Siddhapur
I inform, my lord.
list on.
My lord, serial number 67.
Serial number?
67, my lord. Kindly have it next week, any date, my lord.
ನೀವು ಯಾರಿಗೆ?
Sudarshan. Appearing for petition.
Counsel for the petition seeks time. List on date.
My lord, 73, I'm for petitioner, my lord. Yeah, 1 week's time, my lord. Other side already intimation, my lord.
ವಿನಾಯಕ್ ಆಪ್ಟೆ.
Yes, my lord. Interim order extension.
ಸೂಟ್ ಎಷ್ಟನೇ ಇದು?
2024 ಇದೆ, my lord.
ಸೂಟ್ ಅಂದ್ರೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗ್ತಾರಲ್ಲ.
Yes, yes, madam.
ಎಷ್ಟನೇ ಇಸ್ವಿ?
ಇದು ಗೊತ್ತಿಲ್ಲ, I'm prosecution, my lord, this one.
ಪ್ಲೀಸ್ ಯಾವತ್ತು ಎಷ್ಟನೇ ಇಸ್ವಿ ಅಂತ ಹೇಳಿ. If it's a old suit, I will not grant adjournment.
Have it on Monday, my lord.
Have it to illa, give it to illa. If it is a old suit, no adjournment. Interim order ಇದೆಯಾ?
Yes, my lord, interim order ಇದೆ, my lord.
Therefore, you don't want to argue.
Yes,
ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್ ಹೇಳಿ. If it's a new suit, fresh suit, I grant adjournment. If it's a 2008, 9, 10, 11 suit, no adjournment.
yes, yes. Yes, my lord.
Lordship, serial number 70.
Serial
So
number?
state wants to file the objection, that is the Kokaka related case, 70, 70.1. So on 29th one, kindly grant the date, 29.
Learned SCGP seeks time list on 29.
Please, list
29.
out, please.
Serial number 69, undertaken to file wakalatnama for 124-629, my lord. Short time may please begin. 16, serial number 16,
DP Ambekar.
1616.
Please wait.
Okay, okay. Okay.
Annaraya,
2 weeks time.
2 weeks time is granted to do the need. Both Tirupati, after recalling, there is no representation for the petitioner. The petition was dismissed earlier for non-compliance of office objection. However, till date, it is not complied. As a last chance, 1 week time is granted to do the needful, failing which the petition shall again stand dismissed for non-compliance of office objections. Sanjay Patil, ನೀವಲ್ವಾ ಸಂಜಯ್ ಪಾಟೀಲ್ ಇಲ್ಲಿ
ಇಲ್ಲ ಅವ್ರು ಹಿಂಗೆ ಹೇಳಿದ್ರು ಪ್ರತ್ಯಕ್ಷ ಅಂತ ಹೇಳಿದ್ರು.
ಮಿಸ್ಟರ್
ಸಂಗಮಸೋ ಬಿ ಪಾಟೀಲ್ ಮೇಡಮ್.
Sangana Basava B. Patil, appearing for Mr. Sanjay A. Patil, submits that the writ petition has become infructuous. The submission is noted and the petition is dismissed as having become infructuous.
Week time will be granted use.
1 week, the same order. Same order,
20?
same order.
ये देखिए.
Gopal Rao, 1 week time is granted to do the needful, failing which the petition shall stand dismissed for non-compliance. Same order. Manjunath V. Rayappa. Bhimaraya.
Yes, ma'am.
ಏನ್ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಏನ್ ಮ್ಯಾಟ್ರ್ ಕೇಸ್ ಹೇಳ್ರಿ ಭೀಮರಾಯ ಕೇಸ್ ಹೇಳ್ರಿ
ವಿಷಯದಲ್ಲಿ ಬರ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು
ಯಾರು
ಮಂಜುನಾಥ್ ರಾಯ್.
ಮಂಜುನಾಥ್ ವಿ ರಾಯಪ್ಪ
ಸೇಲ್ ಡೇಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸೇಲ್ ಡೇಟ್ ಕಾಪಿ ಸಬ್ಮಿಟ್ ಮಾಡೋದು.
ಅಲ್ಲ ಏನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಯಾರು ಹೇಳ್ಬೇಕಲ್ಲ. ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟು ಎಷ್ಟನೇ ಇಸ್ವಿದು ಭೀಮರಾಯ?
ಮಂಜುನಾಥ್ ರಾಯಪ್ಪ ಅವ್ರೆ
2017.
ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮಂಜುನಾಥ್
Yes, pass over.
Kind of. But then 2 days accommodation.
Please do it in the course of the day.
Please, sir.
Petitioner undertakes to pay the process during the course of the day. Office is directed to issue notice if the process is in order.
Please.
It is made clear that if the process is not paid during the course of the day, the petition shall stand dismissed.
Your lordship, in the trial court, the suit has already been disposed, my lord. This has become infructuous.
The Learned Counsel for the petitioner submits that the writ petition, that this writ petition which arises out of OS number
44 of 2013, my lord.
44 of 2013
Before
has
the-
become infructuous in view of the disposal of
Maybe in view of disposal of on 10th April 2024.
disposal of the suit on
10th of April 2024, my lord.
10th April 2024. The submission is noted and the
May be
petition
granted liberty to urge in the
is
regular appeal.
dismissed- Is dismissed as having become infructuous. It is needless to mention that any grounds urged in this writ petition is available, is reserved for the petitioner to be raised in an appeal that may be filed against the judgment and decree passed.
Please, my lord, much appreciated.
Kindly grant week's time.
1 week time is granted to do the needful, failing which the petition shall stand dismissed. ಯಾರು ಇದು ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ಡಿಸೀಸ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್?
Within week we'll comply, my lord.
Huh?
Within a week we'll comply.
ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿ ಇದು? Suit is filed in which year? 2016. ಏನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ರಿ ರಾಮಚಂದ್ರ ಅವ್ರೆ?
File
Facts.
kindly pass or my kindly file ಕೆಳಗೆ ಕಳಿಸಿದ್ದೀನಿ PF ಕಟ್ಲಿ.
Stay the further proceedings. Stay ಕೇಳಿದಿರಾ? Pass over.
Please.
Kumar Kallur,
A week time may be granted by law.
suit is filed in which year? Zul. Yes, yes, okay.
Was 26 of 2012.
2012 suit. ಏನ್ facts ಹೇಳಿ? What are the facts?
This is
Facts.
amendment to the Order 6 Rule 17 has been rejected, my lord.
Suit is filed for what? Suit is
Suit
for
for
injunction.
injunction.
You are the defendant or plaintiff?
And for the plaintiff, my lord.
What is the application that you have filed?
Order 6 Rule 17, my lord, amendment of plaint. That has been rejected, my lord.
You have filed an amendment application in the appeal.
Yes, my lord. Already that got rejected, my lord. Kindly
Yes,
have
yes.
it, kindly may have it on next week, my lord. Senior has some personal inconvenience, is out of station, my lord.
Yes.
Your Lordship, the IA has been filed in the appeal, Your Lordship.
I too, suit is for injunction. Now he wants to seek for declaration.
Kindly have it on next week, Your Lordship. So I'll take instructions.
Let the appeal be allowed and remanded for fresh consideration.
Kindly have it next week. I'll seek instruction.
The learned counsel for the petitioner seeks time to comply the office objections. 1 week time is granted to do the needful.
Grateful.
During course of the day, I'll pay the PF.
Same order during course of the day, madam. Failing which it will be dismissed, yes. Mantesh Patil,
Well, 2 days time will be granted, my lord.
ಎಷ್ಟನೇ ಇಸ್ವಿ suit?
2022
Suit ಎಷ್ಟನೇ ಇಸ್ವಿದಪ್ಪ?
2022 year, man. 22 suit.
What is the suit for?
Money decrease suit.
What is the application?
My lord, application.
What is the application?
Kindly pass over, my lord. Lord, 38 rule 5 of CPC.
5.
38 rule 5 CPC.
What does the defendant say in the written statement?
My lord, kindly pass over, my lord.
What is wrong with the impugned order?
Property is situated outside the jurisdiction of the court, my lord.
Then,
Kindly,
and property is already mortgaged to another bank.
that is why, kindly pass over, my lord, one.
No, Mr. There's nothing but put
One,
the petition, the plaintiff invoice number so-and-so on the file of so-and-so has filed this writ petition challenging the correctness of an order dated so-and-so by which an application filed by him and order 38-5 of CPC was rejected. Next para. This suit invoice number so-and-so was filed for recovery of ₹32,41,045, being the amounts allegedly payable by the defendant arising out of such certain commercial transactions between the plaintiff and the defendants. Full stop. The plaintiff also filed an application under order 38-5 of CPC to attach a property belonging to the defendant and situated Coimbatore. Full stop. The trial court, after considering the trial court registered the trial court, after considering the contentions urged, held that the application is not maintainable since the property sought to be attached was outside its jurisdiction, and also since the property was already mortgaged in favor of Indian Overseas Bank towards a loan raised by the defendant. Full stop. Being agreed with the said order, plaintiff is before this court. Next, the learned counsel for the plaintiff contends that that mere mortgage of the property in favor of Indian Overseas Bank does not come in the way of the defendant, that does not come in the way of the property being attached. He submits that the claim of the plaintiff shall always be treated as the second charge over the property, insofar as the order refusing to attach the property on the ground that it lay outside the jurisdiction of the court. He submitted that the defendant has already appeared before the court, and therefore the court can pass an order to attach the property. Next part. Order sheet there. Where is the order sheet?
sheet is, well, page number 37,
Order sheet, order sheet there.
order sheet is. No.
The plaintiff sought for attachment of the property belonging to the defendant on the ground that the defendant was likely to dispose of the properties and dispose of the properties and avoid the creditors. Full stop. The IA there. Where is the IA?
IA, page number 32, my lord. Lecture C.
Madam, dispose of the property. Trying to dispose of the properties to avoid the creditors. Full stop. Except this, comma, there is not even an averment. So the defendant is attempting to wind up business and dispose of the properties. The defendant is a going concern, and there's nothing to show that the defendant had indulged in any act of insolvency. Besides this, comma, the trial court has noted that the property sought to be attached was already mortgaged in favor of Indian Overseas Bank. It also noted that the property lay beyond its jurisdiction and hence the same could not be attached. Full stop. There is no error committed by the trial court in doing so, warranting interference in this petition. Hence, the petition lacks merit and is dismissed. A memo is filed for dismissal.
No, Mercy. I challenging the compromise decree before the local.
ಯಾರು ಹಾಕಿರೋದು?
ಅದನ್ನ PF ಪರ್ಮಿಷನ್ ಕರೆಕ್ಟ್ ಅಡ್ರೆಸ್ ಫರ್ನಿಶ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕಂಡೀಷನಲ್ ಆರ್ಡರ್
ಏನ್ ಮಾಡ್ತೀರಾ?
ಅವರು ಅಂಡರ್ಟೇಕ್ ತಗೋತಾ
I
ಇದ್ದಾರೆ.
undertake to file the wakalatnama of 1, 2, 3, 4 and 6 to 10 and short date.
Naganna, Sangolli Naganna
Yes, please.
undertakes to enter appearance for respondents.
1, 2, 3, 4, 6 to 10.
1, 2, 3, 4, 6
6
to
to
10.
10.
What about R5?
5, I don't know myself.
ಅವ್ರ ಬ್ರದರ್ಸ್ ಅವರೇ ಇದ್ದಾರೆ, ಒಬ್ಬರೇ ಇದ್ದಾರೆ. 1 to 10 ಆರ್ ದಿ ಸಿಸ್ಟರ್ ಅಂಡ್ ಬ್ರದರ್ಸ್.
R5 again, Rajeshwari.
I have no idea. Only these people have given me.
One counsel for the petitioner is directed to take out process 2, respondent number 5 during the course of the day, failing which the petition shall stand dismissed against respondent number 5. It's next. Sachin Mahajan,
For the
entry
petition.
order idea.
Needful has been done.
Allowing counsel for the petitioner submits that the process is paid. Office is directed to check and verify and proceed to issue notice to the respondent.
Much.
List out the
For the
service of
petitioner.
notice to the respondents. Interim order idea.
It is.
Interim order granted early extend till the next date.
Much.
Ratna Shivayogi Mutt. R3 necessary party na?
Yes, my lords. Because
It is necessary.
yes, my lords, you have filed the impleading application before the MSCT.
Big time is granted to do the needful, failing which the petition against respondent number 3 shall stand dismissed.
Interim order.
Interim order granted early extend till the next date. Chaitanya Kumar. Office objections raised on IA 1 of 24 is overruled. Yes, mister, what is a caste certificate? What have you challenged?
Lord, the annexure K and L,
Annexa?
K and L.
A and L.
Uh,
Ah,
Order passed by the Assistant Commissioner, my lord, where the petitioner caste certificate is cancelled earlier issued by the respondent number 4. my lord. Petitioner has contested the election CMC Humnabad.
ನೀವು ಯಾವ ಜೊತೆಗೆ ಸೇರಿದ್ದು?
My lord, earlier before marriage she was
Reddy, 3A.
house.
On marriage, how can you caste change? ಮದ್ವೆ ಆದ್ಮೇಲೆ ನಿಮ್ casting change ಆಗುತ್ತೆ. That is the law declared by the Supreme Court.
Yes.
ಮದ್ವೆ ಆದ್ಮೇಲೆ ನಿಮ್ ಜಾತಿ ಹೆಂಗ್ ಬದಲಾವಣೆ ಆಗುತ್ತೆ? Caste is by birth ಅಲ್ವಾ? ಹಾ?
Yes, my lord.
ಮತ್ತೆ?
Is it
What is
decide-
wrong? Yes, Jagdish.
C. Jagdish.
After contesting the election, the certificate was issued. The complaint has to be considered within 30 days from the date of.
That is okay. On merits, he'll read. On merits, how can you acquire a caste? You can't acquire a caste. You can't change your caste. ಅಷ್ಟೇ ಅಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದಾ ಹಾ
Yes.
Workful. The petitioner has challenged the order dated 28/6/2020, order bearing number so and so dated 28/6/2024, passed by the respondent number 2, cancelling the caste certificate granted to her on 15/5/2019 by the respondent number 3. The petition is also agreed by the order passed by the respondent number 1, bearing number so and so dated so and so, confirming the order of cancellation. Next paragraph. The petitioner claims that she had contested the elections to the post of councillor of town municipality Humnaba as a person belonging to scheduled caste, huh?
Okay.
Scheduled caste. Full stop. She was declared as a return candidate. Full stop. The respondent number 4 lodged a complaint before the respondent number 2 and 3, claiming that the petitioner, petitioner had obtained a false caste certificate from the respondent number 3, and therefore sought to declare the election of the petitioner as void. Full stop. The petitioner contends that she belonged to Yellam Reddy caste, which was categorized under 3A. Full stop. Later, she married a person belonging to scheduled caste on 10/4/2014. Full stop. She had obtained a caste certificate on 26/3/2015. As belonging to category 3A, and that in the year 2016, she adopted the Buddhist religion. She claimed that in the year 2019, when she filed her nomination, she declared that she belonged to Buddhist category A and obtained a verification certificate as a Buddhist A issued by the respondent number 3. Full stop. Again, in the year 2020, she obtained a fresh caste certificate from the respondent number 3 as belonging to category 3A. Full stop. The respondent number 2 directed the respondent number 3 to conduct an inquiry regarding the complaint lodged by the respondent number 4. Full stop. The respondent number 3 conducted an inquiry and submitted a report. Based on the report of the respondent number 3, the respondent number 2 directed the respondent number 3 to take action in accordance with the Karnataka Scheduled Caste and Scheduled Tribes and other backward classes, Reservation of Appointment, etc. Act 1990. Full stop. Based on the said directions, The respondent number 3 initiated proceedings by issuing a notice dated 20/12/2021. The petitioner uh, 2021 and passed an order dated 13/10/2020 cancelling the caste certificate granted to the petitioner. The petitioner challenged the said order before this court in WP number 202937/22. Full stop. This court in terms of the order dated 17/11/22 allowed the petition and set aside the order dated 13/10/2021 passed by the respondent number 2 and directed him to consider the complaint lodged by the respondent number 4 under section 4B of the Act 1990. Thereafter, the respondent number 2 considered the issue and passed the impugned order setting aside the caste certificate issued by the respondent number 3. Full stop. The petitioner thereafter challenged it before the respondent number 1, who also dismissed the appeal in terms of the order impugned in this petition. The petitioner therefore is before this court challenging the said orders. Next para. Yeah, what are your contentions?
Lord,
What are your contentions?
once the certificate is issued, that has to be challenged within 30 days from the
Stop.
date of
The
issue.
learned counsel for the petitioner contends that under the Act of 1990, if a caste certificate is issued by the competent authority, and if any person is aggrieved by the issuance of such caste certificate, they are bound to challenge it in the manner provided under section 4B. now,
4B.
4B of Act 1990 within 30 days. He contends that since the caste certificate is not challenged, the respondent number 2 would not have entertained the complaint of the respondent number 4. Besides this, he contends that the petitioner on marriage acquired the caste of her husband and therefore was entitled to claim as belonging to Buddhista A caste. He therefore contends that the respondent number 3, after verifying the facts, had issued the caste certificate, which was improperly cancelled by the respondent number 2. Next para. The petitioner has not disputed the fact that she belonged to category 3A. Full stop. The petitioner cannot contend that on her marriage with a person belonging to Buddhista A category caste, she acquired the caste of her husband. As is oftenly stated, a caste is acquired by a person by birth, and there cannot be any vertical movement in matters of caste, particularly when it relates to reservation. Full stop. The apex court in the case of Archana MG and others versus Abhilasha and others has considered the very same question and has held that children born out of an intercaste marriage would acquire the caste of their father, but the wife cannot change her caste and continues to hold on to that caste during her lifetime. Therefore, in the admitted Therefore, comma, in view of the admitted case, in view of the admitted fact that the petitioner earlier belonged to category 3A and that this caste certificate in question was issued on the marriage of the petitioner with a person belonging to Baudista A caste, comma, the petitioner is not entitled to the benefit of the said caste. Therefore, comma, the respondent 1 and 2 had rightly held that the petitioner is not entitled for the caste, entitled for a caste certificate, declaring that she belongs to Baudista A caste, and were right in cancelling the caste certificate already issued to the petitioner by the respondent number 3. Hence, there is no merit in this petition. The same is dismissed. Venkatesh C. Mallabadi.
My lords, I appear for the petitioner in this matter.
Yes. Suit is filed in which year?
My lord, this is an execution petition, my lord, that was filed in 2022. The impugned order was passed on the 27th of June 24. We have filed this writ petition, my lord, essentially against the order rejecting our execution petition. This execution petition was filed, my lord, for executing a foreign decree passed by a court in Abu Dhabi. And my lord, the learned executing court, my lord, has dismissed or rejected the execution petition on 3 grounds primarily. The first ground being, my lord, that the certificate as required under 44A of the CPC was not produced, number 1. Number 2, my lord, is the ground that the execution had to take place, or that is what the trial court says, that the execution had to take place against the other co-guarantors before approaching the respondent's properties. Number 3, my lord, the claim is that before the Abu Dhabi court, there was no opportunity given to cross-examine the expert witness that was called, and therefore there was a violation of national justice. These are the 3 grounds primarily on the basis of which, my lord, the executing court has dismissed our execution petition.
What is the office objection?
My lord, the office objection, there are 2 office objections, my lord. One is, my lord, that the execution petition number is not mentioned in the document. My lord, that execution petition is numbered in Annexure H and Annexure K. It is 484 of 17. This is the execution petition filed in Abu Dhabi.
That is right. Annexure J. What is Annexure J?
Annexure J, my lord, is the execution petition, my lord. If my lords can see execution petition number blank 2017. Now the number, my lord, this was at the time of filing. Number is not given at the time of filing. This number can be found, my lord, at Annexure H and Annexure K.
The office objection at seal number 1 is overruled by accepting the submission of the learned counsel for the petitioner that the execution petition number is found at Annexure
H and Annexure K, my lord.
H and K. What about translation?
484 of 2017.
Translation of Annexure H.
My lord, we are not relying on those documents, my lord.
But how will you understand
documents from pages 2? No, my lord, there are the Annexure H, my lord, has 2 components to it. One is the execution certificate itself, my lord, which is what we're relying on. Following which, my lord, are documents that are not concerned, that we're not concerned with insofar as the certificate is concerned.
Now, where is Annexure H? Page number?
My lord, Annexure H is 222, my lord. And we're only relying on 222 and 223, which are English documents.
H.
These are the certificates issued by my lord, under 44A.
Where is Annexure J?
My lord, J is a 246, my lord.
What is that?
Annexure J, my lord, is the execution petition that was filed. Annexure H, my lord, is the certificate issued by the competent authority in relation to the
There is something in our page number 250. What is that? Is it part of annexure J?
250, my lord?
Yes, 250,
250, my
251.
lord, is a translation, my lord. Is the Arabic version of it. The translation, my lord, can be found on top.
Where's the translation?
So what they've done is translation starts at 246, my lord.
Cool. The office objection serial number 2 is overruled by accepting the submission of the petitioner, learned counsel for the petitioner, that pages 246 to 249 are the translation of pages 250, 251 and 252. Yes, issue emergent notice to the respondent. Vipash Mallapur.
Right.
This objection is annexure.
Yeah, office objection serial number 14 and
Annexure C, Manors, at page 27. ಅಲ್ಲಿ IA1 ಅಂತ ಬರೆದಿದ್ದಾರೆ, but it is IA2 Manors, typographical error.
page 27.
27.
Ah,
ಅಲ್ಲಿ IA, order on IA1 ಇದೆಯಲ್ಲ, it should be IA2 Manors. In the operative portion, it is mentioned as IA2 at page 32.
the office objection.
This is challenging the limitation, bar of limitation.
Objection at serial number 14 is overruled by accepting the submission of the learned counsel for the petitioner. Yes, what is challenged?
Manors, bar of limitation in every act, Manors. 166(3).
Issue emergent notice.
Needful is done.
Counsel for the petitioner submits that. Needful in awaiting antide.
Maybe in the other matter, my lord,
List after service of notice to response 1 and 2.
interim order may kindly be extended.
A memo is filed seeking dispensation notice to respondents 3 to 9. In view of the memo, notice to response 3 to 9 is dispensed at the request and risk of the petitioner. Interim order granted early is extended till the next date of hearing. Same,
Identical.
same order. 25. List after service of notice to R1, interim order idea. Interim order granted is extended to the next date. VK Nayak.
Needful has been done, man.
Counsel for the petition submits a needful is done. Office director to check, verify, and proceed to issue notice to the respondents. Interim order idea. Interim order granted is extended till the next date. List after service of notice to response 1 to 4.
Interim.
Interim order is extended till the next date of hearing.
Obvious.
Sachin,
I am filing the memo with the paper.
you want to withdraw?
The stay order has been given before the trial court by giving the respondent advocate evaluation. And by 50% amount has been already deposited.
So what do you want?
Evaluation service has been taken as a sufficient evaluation. We have already served the copy to the other side. There was a direction to serve the copy to the advocate who is appearing before the trial court.
Madam, serial number 28 is the one. 203890 is what is listed before the court. That in the Upanishad Upadhyay. Please take out notice again. Hopefully 1 week time is granted to do the needful. Wapas put.
Your Lordship, the address which has been given before the trial court, same address that we have been.
Take out fresh process, madam, again. Yes, next.
Lordship, in this matter, already interim stay granted by this honorable court and regular date is 23/1. I think wrongly it is listed. ಹೌದಾ? Move ಮಾಡಿದ್ರ?
Lordship, password board.
There are some AGS directed to secure information to that.
Yes, your lordship. He instructed me that that case was listed on 23, but petitioner counsel moved the application before this court. So today it is listed. ಯಾಕಂತ ಏನ್ reason move ಮಾಡಿದ್ರು?
Impleading the applicants.
Implead ಮಾಡ.
List on 23.
Yes, impleading in the.
In view of the order dated 15/1/25, list this petition on 23/1.
Lordship, password matter, senior ಬರ್ತಾರೆ. Or senior is irrelevant.
In main matter, respondents have moved the matter today. As such, it is, in main matter, respondents have moved the matter as such, it is listed before today. It
Yeah.
is listed today.
Who has moved this petition?
In WP 931.
ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಇದು?
Lordship, vacating stay and implead application has been.
It was listed on 23/1.
23.
Why did you move it?
Or senior is irrelevant, please password board.
Why did you move the petition when the matter is listed on 23/1? Government advocate was supposed to get some information.
For vacating stay warrants.
23/1 ಸರ್ಕಾರಿ ವಕೀಲರಿಗೆ ಏನೋ ಇನ್ಫಾರ್ಮೇಶನ್ ತರಕ್ ನಾವು ಹೇಳಿದ್ವಿ. ಮುಂಚೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ? Why did you move it?
For vacating stay warrants.
ಬರ್ಕೊಳ್ಳಿ. We'll impose cost on you for moving this. ಏನಾಯ್ತು? Since the respondent number, ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದು? ನೀವೇನೋ ಪದಶೆಟ್ಟಿನ?
Yes, sir. Yes, madam.
The respondent number 12 in WP number 203931 of 24 and has moved the petition for posting, even though he was aware that the petition is listed on 23/1/2025, cost of rupees 2,000
Please, Lordship.
is payable by the petition respondents, proposed respondents 5 to 12, which shall be deposited before the deposited with the advocates library fund, High Court of Karnataka, Kalaburagi unit. ಸುಮ್ನೆ ಮೂವ್ ಮಾಡಿದ್ರೆ ಹಿಂಗೆ ಆಗೋದು. 2,000 rupees ಕಾಸ್ಟ್ ಕಟ್ರಿ ಈಗ. 1,000 ಕಾಸ್ಟ್. Why do you move it, mister? You knew that it is listed on 23/1. ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ? Why did you move it? 23 ತನಕ ಕಾಯಕ್ ಆಗ್ತಿರ್ಲಿಲ್ಲ. Another 5 days you couldn't wait. ಕಟ್ಟಿ 2,000. Yes, next. Acceptance of note below the cost rate.
And it's two.
In view of the note appended to the cost rate is perused and is accepted at the request and risk of the petitioner. Yes.
In this matter, my lord, these respondents 1 to 6 filer had earlier filed OS 57 of 2013 against their father for suit for partition and separate position. That suit came to be dismissed on, apart from several grounds, on one prime ground, that they are the illegitimate children of the said person. So they cannot claim partition. Now what they file another suit now against the purchases from the father, plots from the father, telling that, that those sale deeds be declared as null and void. Now my submission here is, until unless there is a decision in the earlier suit, which is already pending in the RFA number here, the second suit makes no sense in being continued.
So what is the application that you have filed?
I have filed actually a stay of suit. Stay of the subsequent suit. That your lordship will find it at page number 132, my lord, and actually, so application under section 151 of Bardere, but the court has considered it as an application under section 10 of the CPC and consider ಮಾಡಿದ್ದಾರೆ. Until unless their right is declared that they are entitled for a share or they have a title over the property, they cannot maintain the second suit. So let that be first decided whether they have got a right or not.
Were you parties in that suit?
Only, these two petitioners were parties. The rest others were not parties. These two petitioners were parties.
Issue emergent notice, yes.
Interim order.
ಹೋಗ್ ಬರ್ಲಿ, notice ಹೋಗು.
ಅಲ್ಲ interim order because ಮತ್ತೆ ಸೂಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋ conflicting decisions.
ಏನಾಗುತ್ತೆ?
Conflicting decisions.
ಒಂದ್ ವಾರದಲ್ಲಿ ಏನಾಗುತ್ತೆ? ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತಾ?
ಹಾ?
ಒಂದ್ ವಾರದಲ್ಲಿ. ಒಂದ್ ವಾರ, 2 ವಾರದಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತಾ ಸೂಟು?
ಆಗಬಹುದು ಅಂತ.
ಎಲ್ಲ ಆಗುತ್ತೆ.
ಕ್ವಿಕ್ ಮಾಡಿ ನಡೆಸಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೊಟ್ಟು ತಮ್ಮ ಆರ್ಡರ್ಸ್ ಮೇಲೆ ಎಲ್ಲ ಕ್ವಿಕ್ ನಡೆಸಿದ್ದಾರೆ.
List on date for issue emergent notice. In addition, the learned counsel for the petition is directed to serve the learned counsel who represented the respondents before the trial court. List on 24/1. Yes. Mr. Gate.
Yes.
Acceptance of.
For dispensation notice to the respondent 2 to 6.
The note below the cost title is perused and is accepted at the request and risk of the petitioner. Yes, what is the suit for?
It was an execution petition filed before the district court, my lord, based upon the award passed in EAT. And in that EAT award, my lord, the property which was owned by the petitioner society is already attachable. So after attachment, they are supposed to go for auction of the proceedings and get the proceeds, my lord. But instead of that, they have filed application under order 21 rule 37. My lord. Respondent number 1 has filed as a decree holder and sought for issue of arrest warrant against the petitioner herein, my lord. There is no averment that the sale proceedings, if any, have been taken place that were objected by the petitioner herein, my lord.
Where is the order?
My lord, they admits that there is already an order in the affidavit filed by them, my lord, page 51.
Proclamation issue ಮಾಡಿದಾರಲ್ಲ.
Yes, my lord. Thereafter, they should go for auction and all those things. So we are not coming in the way of the auction proceedings, whatever they are taking, my lord.
ಆಯ್ತು, what is the order passed on order 21 rule 37? ಎಲ್ಲ
That is, that application is at page 51, my lord.
So where is the order passed on that application?
Order, my lord, annexure A, page 17, my lord. On 8/7/2024, the affidavit of DHR in support of IN number 3 under section 151 CPC 19(4) perused the contents of affidavit and the affidavit resistance offered for execution of warrant of attachment movables mentioned that today, one of the JDR, there is no report of belief regarding that, hence the consideration of IN number 3 is deferred. Then, my lord, since the DHR has not responded to cause notice issued, maybe typing mistake, my lord, it should be JDR.
JDR.
Under order 21 rule 37, towards execution of the decree, I issue arrest warrant of JDR 2 and he shall be brought up with all convenient speed on execution of the warrant of arrest. So my respectful submission, my lord, when already the properties have been attached and the procedure is under the sale proclamation, the DHR is at liberty to get recovered his whatever arrears from the property of the petitioner society, my lord.
ಎಲ್ಲಿದೆ attachment ಆಗಿರೋದಕ್ಕೆ?
It is, they have mentioned in their affidavit itself, my lord. Page 52, my lord. That the JDR number 1 is having sufficient source of income, having immovable property at Bhalki bearing TMC number 4270/2 and new TMC number 4297 situated at Bhalki in the connected case EP number so and so. I have taken attachment of the above said property, and in this case, I am requesting to issue arrest warrant. My respectful submission would be, my lord, when already the property is being attached. And to that attachment, my lord, there is no resistance as such by the present petitioner, my lord.
Sorry, from 21 to till date ಏನಾಗಿದೆ?
No, what happened here, my lord, there is one more development has taken place.
15 to 21 ಆದ್ಮೇಲೆ
Yes.
ಏನೇನಾಗಿದೆ?
They are not taking the steps for auction of the properties.
16 to 21 ಆದ್ಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
The detail entire order sheet I have filed, my lord, at annexure
16/2/21 ಆದ್ಮೇಲೆ ಆರ್ಡರ್
Please.
ಶೀಟ್ ಎಲ್ಲಿದೆ?
Please, my lord. Page no, my lord, ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲ.
ಹಾ?
ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲ.
Produce ಮಾಡಿ. Learned counsel for the petitioner's director produce the entire order sheet,
Monday it may be taken.
the execution petition. List on.
Monday, my lord, I have got to file it in the registry.
ಕೊಡಿ ಇದ್ರೆ ಕೊಡಿ, ಇಲ್ಲೇ ನೋಡ್ಬಿಡ್ತೀನಿ.
My lord, 21 order sheet. my lord.
ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. ಸಿಕ್ಸ್ಟೀನ್ ಟು 21 ಆದ್ಮೇಲೆ ಏನೇನಾಗಿದೆ?
21 ಆದ್ಮೇಲೆ
ಇಶ್ಯೂ ಸೇಲ್ ವಾರಂಟ್ ಎಲ್ಲ ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ, ಎಲ್ಲ ಆಗಿದೆ.
Sale
ಅದೆಲ್ಲ
warrant.
ಆದ್ಮೇಲೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಅರೆಸ್ಟ್ ವಾರಂಟ್ ಕೊಡ್ತಾರ. ದಟ್ ಈಸ್
Then you file an application under order 151 to recall the order dated 19/8/21.
yes, that was recalled, my lord. That was recalled. I was given an opportunity to say objection regarding valuation of the property, my lord. That is also over now. Even ಇದರಲ್ಲಿ ಮ್ಯಾಟರ್ ಟು ಬಿ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಬಾಲ್ಕಿ ಕೋರ್ಟ್ ಅಂತ ಅವರೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ದೇರ್, my lord. Jurisdiction ಮೇಲೆ property is located within the jurisdiction of senior civil judge Balki. They only made a submission. Order dated 26/8/2019, my lord, page 35 of my paper book. Heard counsel for the DHR in view of the properties within the limits of Balki court issue precept as prayed. In fact, it should have been transferred under order 21 rule 5 and 6 of CPC. Precept, of course, it was not. After this order, my respective submission will be, my lord, the district judge will lose the jurisdiction to proceed with the execution. Again, some application is filed and the proceedings are being continued before the said court only, my lord.
You come the way, attachment you're not allowing the property to be sold.
No, but there is no resistance by me, my lord.
You filed an application, first sale second sale third sale, you file an application. Then you don't appear. Then you say that this, your lawyer appears and says, I've retired. Then somebody appears and says, I become the president, seeks time.
Please.
Then some secretary appears, seeks time. Then when sale proclamation notice is issued, you say, I'm out of the country. You try to prolong the matter.
Now that is entirely over, my lord. Now property is attached already.
No,
So
you
they are
give an
at liberty
undertaking-
to.
You give an undertaking that you will not obstruct the attached sale of the property.
Please, my lord.
Give an undertaking. We will also fix the date of sale.
Please, my lord. Please, please,
Anyway, the valuation slip is accepted
please,
by
my
the
lord.
court.
Please.
The valuation is accepted by the court.
Yes, my lord.
So don't obstruct the sale.
I will
Only-
give that undertaking.
Huh?
I will give that undertaking.
Purple. The learned counsel for the petitioner submits that the petitioners ಎಷ್ಟು ಜನಕ್ಕೆ ಹಾಕಿದ್ದೀರಾ ನೀವು? All the petitioners or
No, only one. He is the secretary of the institution, my lord.
what about this president then?
President, he is a formal party to the present writ petition. Only arrest warrant is issued against the secretary. So secretary is before the honorable court, my lord. And therefore, respondents 2 to 6 herein. It is the benefit is going to be given to the respondent number 1, who is the decree holder, my lord. Respondents 3 to 6, they are the government authorities.
The learned counsel for the petitioner submits that the petitioner has no objection for the respondent number 1 decree holder to proceed against the property which is attached. He also submits that the petitioner would have no objection if the property is brought to sale. Full stop. Leave here.
Now respondent number
Res-
3 to 6.
3 to
my lord.
6, my lord.
Government.
They are the formal parties.
Department.
In view of the aforesaid submission, interim stay as prayed for is granted. Full stop. Learned counsel for the petitioner is directed to serve. The learned counsel represented the respondent number 1 in EP number 49/2018 on the file of the Principal District and Sessions Judge Bidar. List down on date code.
Please, much obliged.
List down on date code to finalize the sale of the auction attached property.
Yes.
Yes. Office objection 27 in
Petitioner, Lord, the suit for a declaration in injunction.
Annexure B.
Lord, the petitioner herein has filed an application under Order 1, Rule 10, my lord, to impede respondent as a defendant number 4 to one. My lord, he is a purchaser, my lord, of the property during the pendency of the suit, my lord. Lord,
What is the suit for?
suit for declaration injunction, my lord.
Ah,
In respect of same suit property, my lord, defendant has filed one more suit for partition and separate possession.
ah.
That suit came to be dismissed. That I have produced, my lord, at annexure
The
3, my lord.
office objection at serial number 27 is overruled by accepting the submission of the petitioner of the learned counsel for the petitioner. Yes, suit is for declaration.
Yes, no.
Then what is the application now filed?
Application under Order 1, Rule 10 for, to implead, Lord, party who has purchased the property during the pendency of the suit. Lord, simultaneously, the defendant here, the respondent here in has filed suit, one more suit for partition and separate possession in respect of same property. That suit came to be dismissed. Soon after disposal of that, dismissal of that suit, my lord, he has sold that property in 2022. That sale deed, that was not in my knowledge. Soon after that has came to my knowledge, my lord, I have filed an application. I have produced that agreement, my lord, at annexure, at ink page 43, my lord. he has sold property to one Vinod Savalgi.
So you
And-
want these people to be impleaded, is
Yes,
it?
my lord, that.
What does the trial court say?
Trial court says that, my lord, you have filed the, there is only a half page order, my lord, wherein trial court has, without assigning any proper reasons, just simply dismissed the suit, application. Uh, it is filed on fag end of the case when the case is posted for arguments. Now the plaintiff intended to implement the proposed defendant number 5. The agreement for sale is not, it cannot be create any title. Not, my submission is not that, that agreement was not in my knowledge. Soon after it came to my knowledge, my lord, because he want to defraud the plaintiff, my lord, by selling that property. When the suit came to be dismissed, then only he has sold the property.
Correct, but it's only an agreement of sale.
Agreement of sale, but my lord, it again, it will multiplicity of proceeding.
Multiplicity, Allah. What is the stage of the suit?
Now it is for argument, my lord.
Please argue the matter.
My lord,
Please
Lord,
argue the
if he is
matter.
not implemented, my lord, again, he may sell property to other persons.
Opposite will go back to the written statement, tirga evidence, tirga issues. It will go back. That is not the
No,
purpose.
no, my lord, for a particular purpose, my lord, that may be.
You raise this as a ground.
Lord.
Case gedre,
Lord.
you'll get the benefit.
Well, since, my lord, the conduct of the parties, my lord, he has filed suit for partition.
Who has executed the agreement?
Agreement is executed by the respondent, who is defendant before the trial court.
Defendant and they are.
His name is what? Abdul Sattar.
Sattar.
Yes, my lord. He himself has filed the suit for partition in respect of same property.
That's okay, Mr. Now, this agreement is executed by Abdul Sattar or all the
Abdul
different?
Sattar, Mr.
Only Abdul Sattar.
Abdul Sattar.
What about Muhammad Jahangir and Nazreen Begum?
They have not, made.
They are not executed.
They have not.
Wonderful. The plaintiff in OS number 53 of 2016 on the file of so-and-so
Date is fixed tomorrow, my lord.
is before this court. I'll release the copy to evening. I'll release my thing.
Yes, I mean, I
Dated
can say.
9th January 2000. I'll protect your interest. 9th January 2025, by which an application filed by him to implead the respondent number. Or no, party whatever.
Because he was not a party before the trial, for impleading him as defendant number 5, he has filed.
To implead an agreement, implead
One Dr. Savalgi.
Mr. Dr. Vinod Savalge. Savalge, na?
Savalgi.
D5 ಅಂತ ಮಾಡಿದ್ರೆ D, who is defendant number 4 then? Tahsildar. ಆಯ್ತು. To implead Dr. Vinod Savalge as defendant number 5 was rejected. Next para. The suit in OS number 53 of 2016 was filed for declaration that the plaintiff is the lawful owner of the suit property bearing survey number 10/1E, situated Auro,
Bidar mein.
huh?
Bidar mein.
ಊರು ಯಾವುದು?
Situated at Bage Karanja in Bidar Taluk.
Bage Karanja in Bidar Taluk. And for perpetual injunction to restrain the defendants from interfering with the peaceful possession and enjoyment of the plaintiff. Full stop. The suit was contested by the defendant number
1.
Defendants, suit was contested with the defendants 1 to 3, who denied the claim of the plaintiff. Full stop. Based on these contentions, the trial court framed issues and recorded the evidence of the parties and listed the suit for final arguments. At that stage, the plaintiff filed an application to implead Dr. Vinod Savalge as defendant number 5 on the ground that the defendant number 1 had executed an agreement of sale conveying land bearing survey number 10/2 full stop. The trial court rejected the application in terms of the impugned order on the ground that the property sought to be sold by the defendant number 1 was not survey number 10/1E, but was survey number 10/2, which was not the subject matter of the suit. It also held that the agreement of sale was executed on 29/4/2021, and the application is filed after nearly 3 years, 7 months. It held that the agreement of sale in favor of Dr. Vinod Savalge does not confer any title and therefore is not liable to be impleaded in the suit. It also held that the application was filed at the fag end of the proceedings and therefore held that the application and therefore rejected the application in terms of the impugned order. Being agreed with the said order, the plaintiff is before this court. Next paragraph. The learned counsel for the plaintiff contended that the defendant number 1 had earlier filed OS number 16/2016 for partition and separate possession in respect of the suit scheduled property, and that the said suit after contest was dismissed on 18/2/2021. He submits that notwithstanding such dismissal, he executed a sale agreement on 29/4/2021, agreeing to convey the suit property to Dr. Vinod Savalge. He therefore contends that if the defendant number 1, if Dr. Vinod Savalge is not impleaded in the present suit, there is every likelihood of multiplicity of proceedings, and the defendant number 1 may execute a sale deed in favor of Dr. Vinod Savalge and keep the litigation alive. Full stop. Next para. The agreement in question, allegedly executed by defendant number 1 in favor of Dr. Vinod Savalge, was on 29/4/2021. Full stop. The plaintiff did not take any steps to implead the said Dr. Vinod Savalge in the suit. From the year 2021, there is no transaction in favor of Dr. Vinod Savalge. Therefore, the suit filed by the plaintiff for declaration of his title and for consequential injunction cannot remain undecided by entertaining an application to implead Dr. Vinod Savalge. Full stop. Doing this would roll back the suit to the stage of filing a fresh written statement and leading fresh evidence, etc. Therefore, the application filed by the trial court was rightly rejected by the application filed before the trial court was rightly rejected by it, as no title was conferred upon Dr. Vinod Savalge, and he thus was neither a proper nor a necessary party to the suit. Hence, the trial court was right in not entertaining the application filed by the defendant, by the plaintiff. Full stop. Since the suit is now filed, since the suit filed is now listed for final arguments, comma, the defendants in the suit shall not encumber or transfer or alienate the suit property or any portion thereof until the conclusion of the suit. Yes. Not to alienate ilva suit alli.
ಇಲ್ಲ.
Not to alienate illa. Syed Kamaruddin.
My lord, I'm appearing on behalf of the petitioner.
Look to be mentioned, local address and engage local counsel.
My lord, we
Office
seek,
objection is overruled.
Yes.
Office objection serial number 31 is overruled. Yes, what is the petition about?
my lord, this petition is to set aside the order dated 16/12/2021, passed in OS 129 of 2017. My lord, the defendants in this case had filed an application under section 125 of the Cooperative Societies Acts for want of notice under the said act. My lord, we had filed our objection stating that the acts of the defendant in defrauding the plaintiff had no way in connection. 125 is required in cases where the issue touches upon the constitution, management, or business of the cooperative society.
So what is the relief sought for against the society?
My lord, what's happened is that the defendants, the plaintiff had engaged the service of defendant number 1, which is a stockbroking company. Now, employees of the defendant had misrepresented themselves to be, had approached the plaintiff, obtained checks, and had deposited with the cooperative society. This was not in the knowledge of the plaintiff. Later, only when he had seen that his code number had changed, he became aware that he had inquired into the matter, and he's realized that these amounts were deposited in the District Credit Cooperative Societies Bank, which acts as a clearinghouse agent of the cooperative society.
No, but why is the cooperative society a party in the suit? I don't understand. No relief is sought for against
My
the
lord,
cooperative
the
society.
amounts were deposited before the cooperative society. The relief is sought for against all defendants for recovery. The initial suit is
Why?
filed for recovery.
No, what is the relief against the cooperative society? What is the mistake that the cooperative society has done?
My lord, so defendant number 7 to 9, which is the chairman, vice chairman of the CEO, have deposited in the bank account of the cooperative society.
So?
And then thereafter defendant number 7 and 8 had filed an application for want of notice, which for return of plain for want of notice under section 125 of the Cooperative Societies Act.
Yes. Take out notice, issue emergent notice.
My lord, if a stay may be granted, my lord, on the
It's already rejected. What stay has to be granted?
just on the order, my lords.
What stay? It's already rejected. Yes, issue emergent notice.
Your order passed in the writ petition, my lord, sought to be reviewed. Order passed in the writ petition where, my lord, the impleading application came to be allowed, is sought to be reviewed. Not on the merits of the application, my lord, there is one observation which has come in paragraph number 8 of the order not passed by your lordship. Where, my lord, the issue, my lord, which is already settled, my lord, in the previous round of litigation, which has, my lord, ended in a regular second appeal, where, my lord.
Please read, which is that sentence?
My lord, paragraph number 8, my lord, page number 17. Consequently, the writ petition is allowed. The impugned order dated 28/5/2024 passed by the so-and-so on IA number so-and-so is set aside. The application filed by the petitioners on IA number 4 is allowed, and they are permitted to be brought on record in FDP number 3/2022. However, the final decree court may consider whether the parties are entitled for an independent share in the suit properties as if, and if pass appropriate orders in this regard. Now, this portion, my lord, this is, my lord, already laid to rest, my lord, in the earlier round of litigation, where, my lord, the civil court, my lord, in a suit for partition, which has, my lord, ended, my lord, in second appeal, which is confirmed by this honorable court, has, my lord, categorically held that the petitioners, my lord, who sought to be impleaded themselves, they are, my lord, the children of the second wife, who, my lord, married during the subsistence of marriage, my lord, of the first wife. Now, this will, my lord, give scope for another round of litigation. In what happened, my lord, OS number 256 of 2015 came to be filed, my lord, by the review petitioner against his brother Anil, my lord.
Please read the order if you want.
Please, my lord.
Please read from paragraph number 6.
Paragraph number?
Para 6 in the.
Para 16, my lord, of the.
Para 6 of the order.
Please, my lord.
Para 2 in the Odbudi.
I'll just start from the beginning, my lord. The respondent number 1 filed a suit in OS number 256/2015 against the respondent number 2 for partition and separate possession of certain properties. The suit was decreed and it was declared that the respondent number 1 was entitled for half share in the suit properties. An appeal preferred by the respondent number 2 in RA number 24/2021 was rejected. RSA number 20027 of 2023 was also dismissed. Following this, the respondent number 1 filed FDP number 3/2022, claiming his half share in the suit properties. In the meanwhile, the petitioners filed OS number 53/2023. Therefore, the petitioners filed an application in FDP number 3/2022 to implead on the ground that they too were interested in the suit properties and they were not deliberately added as parties in a suit for partition. The final decree court rejected the application in terms of the impugned order on the ground that the petitioners could very well claim their share in OS number 53/2023. Being agreed by the said order, the petitioners are before this court. Learned counsel for the petitioners contend that the trial court in OS number 256/2015 has categorically held that the plaintiff and the defendant in this suit constitute members of the joint family and that the suit properties are the joint family property. He contends that the petitioners are none other than the sisters of respondent number 2, and therefore they too were interested in joint family property. Learned counsel relied upon the judgment of the apex court in the case of Revan Siddhappa and another versus Mallikarjun and another, and contended that even if the petitioners were considered to be illegitimate children of Shanmukappa, they too were entitled for a share out of the share of Shanmukappa in the suit properties. Therefore, he contended that the petitioners are also proper and necessary parties, and hence the impugned order be set aside. Per contra, the learned counsel for the respondent number 1 contended that the trial court decreed the suit for partition. The trial court specifically answered an issue regarding non-joinder of necessary parties and held that the suit cannot be dismissed on this ground. He therefore contended that the petitioners have no interest in the suit properties as at most they can claim share out of the share of that may fall to the respondent number 2. It is, I have considered the submissions made by the learned counsel for the petitioner and the learned counsel for the respondent number 1. A perusal of the impugned order shows that the final decree court has rejected the application on the following grounds. The trial court has already answered the issues and held that the suit is not bad for non-jointer of necessary parties. The judgment of the trial court discloses that the grandfather of the plaintiff has divided the property between the plaintiff and the defendant. Hence, OS number 256 of 2015 was filed to partition only those properties. The preliminary decree passed in OS number 256 of 2015 has attained finality in RSA number 20027. Petitioners can claim their lawful share in OS number so and so. The petitioners claim to be full blood sisters of respondent number 2. They have also filed a suit claiming their share in suit properties in OS number 53/2023. The question was that the petitioners were entitled for share in the suit properties or not, and whether the petitioners had to work out their share from out of the share of respondent number 2. All are required, all questions that the final decree court should have to work out before passing the final decree. A final decree proceedings are merely continuation of the original suit, and therefore nothing prevents the final decree court from considering the application of the petitioner on merits. In that view of the matter, the impugned order passed by the final decree court warrants interference. Consequently, the writ petition is allowed. The impugned order dated 28/5/2024 passed by the additional civil judge so and so in FDP number so and so on IA number so and so is set aside. The application filed by the petitioners on IA number 4 is allowed. They are permitted to be brought on record in FDP number 3/2022. However, the decree, final decree court may consider whether the petitioners are entitled to any independent share in the suit properties, and if yes, pass appropriate orders in that regard. If it is found that the petitioners are only entitled to claim a share from the share of the respondent number 2, then the court may pass appropriate orders. In view of the orders, so and so and so. My respectful submission, Mulad. In the earlier round, what is only in a nutshell, Mulad, I'll explain the relationship. The Shanmukappa propositors, Mulad, had 2 wives, Siddhamma and Lakshmi. Siddhamma's son, Mulad, is Anil, who is the review petitioner, Mulad, who was the plaintiff in the original suit. His second wife, Mulad, whom he married during the subsistence of the marriage with Siddhamma, he is Mulad Sharan. He was the defendant in that suit. Now, in that suit, Mulad, both the Mulad, the trial court, the first appellate court, and Mulad, this honorable court have categorically held that Lakshmi, who, my lord, is now the mother of the persons who are seeking themselves to be impleaded, who are now rightly impleaded, my lord, in the FDP proceedings. They are the daughters of Lakshmi, who is, my lord, admittedly the second wife. So therefore, I'll only, my lord, read small portion of the judgment of the appellate court in this regard, where it is, my lord, the discussion, my lord, in the RA. I would like to draw my attention towards the cross-examination of DW1. ನನ್ನ ಹೆಸರು ಷಣ್ಮುಖ ಹೊರಪೇಟಿ. ನನ್ನ ತಂದೆಗೆ ಇಬ್ಬರು ಹೆಂಡತಿಂದರು. ಮೊದಲನೆಯ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಸಿದ್ದಮ್ಮ ಹೊರಪೇಟಿ, ಇನ್ನೊಬ್ಬ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಿ. ಲಕ್ಷ್ಮಿ ಅವರು ನನ್ನ ತಾಯಿ. ವಾದಿಯ ಮೊದಲನೇ ಹೆಂಡತಿ ಸಿದ್ದಮ್ಮ ಅವರು ಮಗ. ತನ್ನ very categorically, my lord, it is admitted, and this is taken into consideration, my lord, by the first appellate court, my lord, where it's observed that from this one thing is clear, that the father of the plaintiff by name Shanmukh had two wives. First wife is the mother of the plaintiff by name Siddhamma, and second wife is Lakshmi. From this, one thing is clear, that during the existence of first marriage, the Shanmukh was married to Lakshmi. This aspect of the matter is admitted by the PW1 in his cross-examination. Further, it would so on and so forth. So this, my lord, the trial.
What is wrong in the order?
My lord, now what would happen, my lord, when it is already held, my lord, that they are, my lord, the sons of Lakshmi, who is, my lord, the second wife, they would be entitled, my lord, to carve out their share from the share, my lord, of the respondent number 2 hearing.
Yaru?
My lord,
Father.
Sharan Horpeti.
Father.
No, my lord, my other brother.
Other brother, you know.
Siddhamma's son, my lord, is Anil. If I may, my lord, invite your lordship's attention to
Who is the
my lord, the
propositors?
cross title.
Who is the propositors?
Propositors, my lord, is one Shanmukappa.
Shanmugappa.
Shanmukappa's first wife, my lord, is Siddhamma.
So therefore, the question whether the second wife was taken during the lifetime of the first wife. The question whether second wife was taken in the lifetime of first wife. Has it been decided?
It has been decided. My lord, I was reading, my lord, that portion of the order
Both.
in the regular appeal, my lord. Page number 42, my lord, in the writ petition papers.
Both, yeah.
I'll, my lord. This is, my lord, the discussion, my lord, in the RA judgment. I would like to draw my attention towards the cross-examination of DW1. ನನ್ನ ಹೆಸರು ಷಣ್ಮುಖ ಹೊರಪೇಟ್. ನನ್ನ ಹೆಸರು ಷಣ್ಮುಖ ಹೊರಪೇಟ್. ನನ್ನ ತಂದೆ ಇಬ್ಬರು ಹೆಂಡತಿಯರು. ಮೊದಲನೇ ಹೆಂಡತಿ ಶ್ರೀಮತಿ ಸಿದ್ದವ್ವ ಹೊರಪೇಟ್. ಇನ್ನೊಬ್ಬ ಹೆಂಡತಿ ಹೆಸರು ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಿ. ಲಕ್ಷ್ಮಿ ಅವರು ನನ್ನ ತಾಯಿ. ಲಕ್ಷ್ಮಿ ಅವರು ನನ್ನ ತಾಯಿ. ವಾದಿಯ ಮೊದಲನೇ ಹೆಂಡತಿಯು ಸಿದ್ದಮ್ಮ ಅವರು ಮಗ. ತಂಟೆ ಜಮೀನುಗಳು ತುಂಬಾ ಗ್ರಾಮದಲ್ಲಿ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿ. From this thing, one thing is clear, that father of the plaintiff named Shanmukh had two wives. First wife is mother of the plaintiff by name Siddhamma, and the second wife is Lakshmi. Now they
Sattaga, where is the finding that Lakshmi was taken during the lifetime of Siddhamma?
From this, one thing is clear, that father of the plaintiff Shanmukh had two wives. First wife is the mother of the plaintiff by name Siddhamma, and second wife is Lakshmi. From this, one thing is clear, that during the existence of first marriage, Shanmukh was married to one Lakshmi.
What is the evidence for that?
My lord, these are admissions, my lord, in the cross-examination which were relied upon.
This is only an assumption, Mr. The court assumes from this one thing, it is clear that during the existence of first marriage, Shanmukh was married to one Lakshmi. Adike evidence ಏನಿದೆ?
The portion of the evidence which I read earlier, my lord.
Sir, ಲಕ್ಷ್ಮಿ ಅವರು ನನ್ನ ತಾಯಿ, ವಾದಿಯ ಮೊದಲನೇ ಹೆಂಡತಿಯಾದ ಸಿದ್ದಮ್ಮ ಮಗ, ತಂಟೆ ಜಮಿ ತುಂಬಾ ಸರಿ. ಇಬ್ಬರು ಹೆಂಡತಿದ್ರು ಇದ್ರು ಕರೆಕ್ಟು. ಫಸ್ಟ್ ಹೆಂಡತಿ ಮದುವೆ ಆಗಿದ್ದಾಗ ಬದುಕಿದ್ದಾಗ ಸೆಕೆಂಡ್ ಹೆಂಡತಿ ಮದುವೆ ಆಗಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ? What is the evidence?
That is an admitted.
Court has jumped to the conclusion.
My lord, that is, my lord, is an.
And the daughters were not parties to this.
They were not parties.
Then how is this judgment binding upon them? ಈ ಸೂಟ್ ಅದಕ್ಕೆ ನಾನು 53 of 2023 withdraw ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
Idರಲ್ಲಿ difficulty what has happened now, my lord, is even, my lord, I am not entitled, my lord, for more than 1.5 share. My lord, I have for I don't know for what reasons have shown magnanimity, my lord, in admitting that, my lord, the other brother, my lord, is entitled for half share in the property. Now, half share they should have taken, my lord, he could have accommodated, my lord, his sisters. Now the situation has come, my lord, my magnanimity, my lord, is being misused. And, my lord, there will be another round of litigation, my lord.
This
If I may, my lord, may take the endeavor, my lord, or seeks, my lord, gentlemen, to rely on the portion of the evidence, which is, my lord, to clarify the fact.
But these people were not parties in that suit.
It is their own brother, my lord.
It doesn't matter. If these people are not parties, they can still contest. They can still contest.
Can they go beyond, my lord, what is admitted, my lord, by their brother, their own brother?
Like idre torsi evidence alli. That is not.
My only fear, my lord, is there will be another round of litigation.
No. The petitioner, another round of litigation agogittagle, 53 of 2023. I have said, if you want to contest final decree, withdraw that suit. They have said they'll withdraw. So therefore, I recorded and said that you go and withdraw that suit so that everything is decided in final decree.
Now, the finding, my lord, will be open to challenge again. Whether it is the second wife or first wife, that, my lord.
Obviously. Everything will have to be decided in final decree. Illandre OS 53 of 2023, ಯಾವ ಕಾಲಕ್ಕೆ ಮುಗಿಯೋದು ಅದು? ನಿಮಗೆ ಶೇರೇ ಬರೋದಿಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ, the petitioner has challenged, the petitioner has sought review of the order dated so and so passed in WP number 201705 of 2024. Full stop. The prime contention of the learned counsel for the petitioner is that while this court allowed the writ petition, it also directed the final decree court to consider whether the petitioners are entitled to any independent share in the suit property, and if yes, pass appropriate orders in that regard. He contends that the entitlement of the petitioner's brother for a share in the suit property was considered in OS number 256 of 2015. And therefore, the petitioners cannot now seek for their share in the suit properties. If they are so interested, they can only claim a share in the share of their brother. Next para.
One submission.
The review petition.
But I'm not for a minute, my lord, challenging the very order itself. My
You're
limited
not challenging the order, you're only seeking for review.
That limited portion where, my lord.
Yes, next para. The review petition is liable to be dismissed on more than one ground, namely that small Roman one, that there is no error apparent on the face of record. Number two, the petitioners were not parties to the decree in OS number 256 of 2015, but had filed an independent suit in OS number 53 of 2023 to claim their share in the suit properties. Number three, that this court had directed the petitioners to withdraw OS number 53 of 2023 and so 23, so that all questions are finally considered by the final decree court in FDP number 3 of 22. Full stop. Hence, in view of the aforesaid, this petition lacks merit and is dismissed. Shyam Harindra.
Lords, I appear for the petitioner, my lord. This is that entry tax issue, my lord, that your lordships have decided, my lord, in another matter. It's the same issue between the two notifications, the 2000 and 2010 notifications.
You're also, this is similar.
My lord, it is identical, my lord. The issue is identical. May I only request 2 days time to complete instructions, my lord. Possibly the same order would have to be passed, but would your lordships please have it on Wednesday?
For the petitioner seeks time. List on yavat beku.
My lord, could it be on Wednesday, my lord?
Wednesday. List on Wednesday.
Have
you challenged this before the division bench?
No, my lord. The other party in that matter, my lord, they are attempting to comply. So they've filed that application. But of course, here this is a separate party, my lord. So therefore,
yes.
Obliged.
Next. 36.
Lordship, I have filed Wakalat, Lordship. Lordship, I have filed Wakalat, Lordship, just now, Lordship.
I need 2 weeks adjournment, Lordship.
Leave here again.
R4A, R43, R5A to R5E, Lordship.
But to learn counsel for the respondent number
R4A, Lordship.
R4A seeks time to file statement of objections.
Please, Lordship.
List on date put. Land reforms matter note here. Arun Kumar Amargundappa.
After previous occasion, Lordship has heard for some time and directed me to file copies of ROR. I received today, my lord. I'll examine and I'll.
Learn counsel for the
Next
petitioner
week it-
seeks time to comply the order dated, not the previous order I have not. So and so, list on.
Next week.
Kumar Kallu.
There is interim order.
Interim
Interim
order.
order is extended till the next date. Huh?
In
ಯಾವ್ದಲ್ಲಿ ರತ್ನ
main matter ಅಲ್ಲಿ interim order. ಇದೆ.
36 ಅಲ್ಲಿ interim order is extended till the next date. ಸಂಗನ ಬಸವ ಪಾಟೀಲ್ ಅದರಲ್ಲೂ ಇದೆಯಾ? 36 ಅಲ್ಲಿ ಮಾತ್ರ. 37 interim order ಇದೆಯಾ?
Yes.
Interim order is extended till the next date. 38 ಶಿವಕುಮಾರ್ ಕಳ್ಳೂರ್.
36 ನಲ್ಲಿ my name may be deleted, madam. 36 ನಲ್ಲಿ. Because one Mr. Ravi Anur is appearing on my.
Office is directed to delete the name of Mr. Shivanand Patil from as the counsel representing the deceased LRs of deceased respondent number 5. See number 36.
Lordship. Lordship, kindly be council name to be taken in record, Lordship, for R4A, Lordship. Raja Raghavendra Naik, Lordship.
Yaru.
In serial number 36 and 36-1, Lordship.
Yeah, who is the advocate?
Lordship, I have filed wakalat right now, 2 days of.
I don't know your name. You should tell me your
Lordship,
name.
I will give.
What's your name?
Raja Raghavendra Naik, Lordship.
Raja?
Raghavendra Naik.
Raja Raghavendra Naik.
Please, Lordship, for R4A, Lordship.
R4A na?
Please, Lordship.
Submits that is entered appearance for R4A. Office is directed to show his name in the. Yeah, Ravi K. Anur antide. Ravi K. Anur.
Lordship, I have filed wakalat for the R4A, R3E, Lordship. R4.
Correct, Mr. There's somebody called Ravi K. Anur. Who is Ravi K. Anur?
No, Lordship. I will verify, Lordship.
Yes, next. Shivkumar Kallur.
For the petition in this case, my lord, kindly may have it on next week, my lord. Senior has some personal inconvenience, my lord, is out of station.
Business with
My lord, 2015, my lord.
Yeah, what is?
For a filed application under sections order 6 rule 17, my lord.
What is suit for?
Eviction.
For
Eviction of
adjustment
tenant. Suit for eviction of tenant.
Eviction of tenant.
The eviction of tenant. Landlord is a trust.
Ah.
The property is agricultural land. It was. Suit was filed by this thing for eviction.
The tenancy is admitted.
They admit, but they challenge the.
It is disputed.
This thing, that is disputed.
How did you come into possession? Have you mentioned how you came into possession?
They admit I am for the plaintiff.
No, how did you come into possession?
Lord, through lease deed, my lord.
Executed by whom?
Executed by
Managing trustee.
one of the managing directors.
Then managing
the-
trustee.
Trustee.
Then managing trustee of the
Therefore,
public.
What are you concerned about the infighting of the trustees?
They want to plead that now.
ಅವ್ರವ್ರೇನೋ ಕಚ್ಚಾಡ್ಕೋತಾರೆ ನಿಮ್ಗೇನಾಗಬೇಕು? You are a tenant under the trust. What they do in the trust is you are not concerned.
I built a school in that property, my lord.
Yeah?
I built a school in that property, my lord.
So whatever it is. Now what is it you want to amend and incorporate? ಓದಿ
That is the only facts, my lord.
ಓದಿ ಏನ್ ಹೇಳ್ತೀರಾ? Plaintiff who filed the suit is not recognized by law and the trustee dated so and so, which is a created document and is a fraud on the Janta trust and also on the defendants and also on the general public and also on the court. Plaintiff in his plaint did not state about in what manner they are representing the suit. They simply state that they are the trustees of plaintiff trust. Sole trustee of the trust is one Kollur Mallappa, who created and got appointed new trustees in this said trust under the trustee, and one Kariyappa being appointed as managing trustee. The deed that the plaintiff claiming right as managing trustee is totally fraud and created one. Plaintiff who filed the suit is not recognized by law and the trustees is not so.
Trustees created names of one new trustees of one. Suit is filed in the name of the trust.
Trust.
Trust me.
Then
Lease deed also is the name of the trust.
Only may have it on next week.
ಹಂಗೆಲ್ಲ next week ಅಲ್ಲಿ ಆಗಲ್ಲ. Stay ಇದೆಯಾ?
Stay.
Supreme order is there, my lord. Senior has some personal inconvenience. He is out of station, my lord.
Oh, sorry.
In fact, I moved the matter.
Lord, senior has some personal inconvenience, my lord.
You can only pass over. ಓದ್ಕೊಂಡು ನೋಡಂಗಿದ್ರೆ ನೋಡಿ ಹೇಳಿ.
My lord, he is out of station, my lord. He instructed me to.
Argue, mister.
He instructed me to
No,
take
no,
the.
your senior is broad-minded. He will allow his colleagues to argue, don't worry. But ನೀವು opportunity ತಗೊಂಡು argument ಮಾಡ್ಬೇಕು ನೀವು.
Here for the petitioner. Order 39 rule 1 and 2, my lord, application. My lord, admittedly, my lord, I am the owner of agricultural land measuring more than 39 rule.
A suit is for
Suit is, my lord, for injunction.
redemption,
Injunction.
injunction.
Now, it so happens, my lord, the land is situated, my lord, in a village, agricultural land. It is not in dispute that I am the owner of the property. About 3 decades back, my lord, taking into consideration the need and requirements of the village, my lord, a small portion of the land probably, I am making this submission out of the record, my lord. A portion of the land, my lord, was given to the government. There was no deed or writing for, my lord, establishing a school. Now, the school is established, my lord, it is running, there is absolutely no problem. Now, over a period of time, my lord, as the strength increases, they want to now, my lord, expand the school area. They also should take into consideration, my lord, the rights of the owner of the land, not and take appropriate steps, my lord, for either acquisition of the land or, my lord, some arrangement with the owner. Now, all of a sudden, my lord, they go on a spree, my lord, to spread the work of construction, including the area, my lord, which is owned and possessed by me. Though I have not stated so, my lord, specifically in my plaint, but that is, my lord, it's a state of affairs on the ground, my lord, that I can, my lord, ascertain from the record that is placed on the record. Now, my lord, when they take up this construction, my lord, it is objected by the plaintiff on the ground, my lord, that he is the owner of the property. The defendant number 3, my lord, files a categorical written statement, my lord, contending that I am the owner of the agricultural land measuring so and so, and I have gifted, my lord, a portion of the property to the government. There is no gift, there is no deed or anything to reflect that. And, my lord, the PDO also files, my lord, written statement stating that, my lord, no doubt the plaintiff is the owner of the property, but 1 acre of that land is Port Kharab. So therefore, the government is well within its right, my lord, to put up construction. My lord, is the stand taken by the PDO. If I may, my lord, take your lordship, my lord, to those relevant portions, my lord, of the written statement. Page number 24, my lord, is the written statement of the defendant number 3. Actually, if I may, my lord, annexure C. Actually, plaintiff is the owner and possessor of land survey number 195/1, measuring 7 acre 14 guntas only. It is clearly shown that from the revenue records that out of 8 acre 14 guntas, there is Port Kharab of 1 acre, my lord. This is the stand taken by, my lord, the PDO. And, my lord, the defendant number 3, he files written statement stating that, my lord, it is submitted that the plaintiff himself voluntarily donated the portion of the above suit land to the government for the construction of government school about 30 years back. And accordingly, the government have constructed the school. The plaintiff has voluntarily gifted the portion of his land in favor of the government. And accordingly, the government, by acquiring the portion of the suit land with due process of law, have constructed the school building over this one. There is no gift deed, there is no, my lord, anything to show.
Have they enclosed the property by a compound wall or something like that?
They are, my lord, putting up the construction, my lord. If I may, my lord, show the photographs. What they say, my lord, is they are, my lord, demolishing the old structure and they are putting up construction. But the photographs on the contrary would show, my lord, that old building remains intact. It is very much in use. And beyond that, my lord, they are putting up, my lord, the construction. ಹಳೆಯ ಕೋಣೆಗಳು ಹಾಗೆ ಇದೆ. It is not being, my lord, it is not out of use, it is not dilapidated.
New construction.
ಏನ್ ಮಾಡ್ತೀವಿ?
My lord, I have, my lord, given my land. The government, my lord, cannot, my lord, in this manner, my lord, now, if the stand of, my lord, one stand of the respondent, my lord, that it is.
Evidence ಏನಾಗಿದೆಯಾ ಕೇಸಲ್ಲಿ?
My lord,
Whether evidence is started?
evidence, my lord, is not yet started.
Ian, what is the construction that you are putting up?
No.
Construction ಮಾಡ್ತಿದ್ದೀರಾ?
Pillars, my lord, are being erected.
Pillars, they put the pillars here, your
ಆ
lordship. And
construction pillars ಏನಕ್ಕೆ? Tank ಗ?
No.
that is
It is for the
for
school rooms only.
rooms only.
What is the area in which you constructed the building?
Lord, that as per this photo, it is just attached to the Lord.
Main building.
Main building only, not
So what is the area?
Lord
See, the
area and
total extent of this building is some 8 acres.
it is
ದಾನ
just,
ನಿಮ್ಗೆ?
I think Lord already compound ಎಲ್ಲ ಇದೆ ಇದ್ರ ನಮ್ಮ school within the limits of our school only it is construction is going on.
He says 8 acres, 14 guntas is the total extent. Full compound ಇದೆಯಾ?
Ide, compound. Compound is available, your lordship. Only room is building by the state.
Compound gate ಎಲ್ಲ
ಎಲ್ಲ ಇದೆ.
gate ಇದೆ ಇಲ್ಲಿ but ಈ side left side ಇದೆ.
Left side, only classrooms are.
If you have put up compound, then
Instruction to me, my lord, is that they are encroaching, my lord, the
compound ಹಾಕಿದ್ರೆ encroachment ಏನ್ ಬಂತು?
Gate ಇದೆ ಎಲ್ಲ ಇದೆ.
they can survey, my lord, fix, my lord, what is their extent, how much they hold, how much they can.
If there's a compound, I produce a photograph. Produce ಮಾಡಿ photograph.
Yes,
Compound gate ಎಲ್ಲ ಇದ್ರೆ, if you are enclosed the entire 8 acres, 14 guntas.
Entire 8 acres ಅಂತ ನಾವು ತಗೋತಾನೆ ಇಲ್ಲ. ನಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲದೆ within the actually it is a renovation and ಇದು ಅಂತ ನಮ್ಮ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
They're not interested in the entire 8 acres.
not entire 8 acres.
ಮತ್ತೆ ಎಷ್ಟು?
ಇದು ಓನ್ಲಿ 1 acre ಅಷ್ಟು ಅವ್ರ ಪ್ರಕಾರ ಐ ಆಮ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಓನ್ಲಿ ಮಿಲಾಡ್.
So we will say that you are putting up
Contractor.
the school in that 1 acre foot
Now,
cutoff.
one submission, my lord. What is that basis for 1 acre, my lord? There is absolutely no clarity.
So you allowed them to construct a school.
This
Lord, small portion, my lord, taking into consideration,
ಆಯ್ತ್ರಿ,
can,
ಎಷ್ಟು
my lord,
ಅಂತ-
take one spreading, my lord, and
How
expanding
much
is
you
fine.
allowed, how much, have you mentioned in the plaint
No.
as to how much you allowed them to put up construction? What is the area which you allowed? Admittedly, there's a school.
My lord, I'll make one submission, my lord, and I'll take instructions, and if the need be so, my lord, I'll file an additional affidavit.
For the Learned Counsel for the petition seeks time to secure instructions
Yeah, they use this one and two.
about the area within which the school is constructed and the place where the defendants are trying to put up additional construction, and also whether the entire area measuring 8 acres, 4 guntas, 14 guntas is enclosed by the school. Full stop. List on yavat ಬೇಕು ಹೇಳಿ.
8 acre, 14 guntas is not enclosed, my lord. That is my submission on them.
Whatever it is, file an affidavit.
Yes,
Some
yes.
portion.
29.
31st. Interim order may kindly be extended.
Interim order ಏನು?
Interim order, my lord,
Initially it was granted.
not to go beyond, my lord, that portion of,
Beyond 1 acre.
Yes.
No,
that may be
interim
continued, my lord.
Interim order dated in 11/2023 is extended till the next date of hearing. This Naveen Jain.
I appear for the petition.
Hmm.
If IA number 2, 3, 4 and 5 are filed by
Sadashiva. C. Sadashiva.
Yes.
Gaurish Kashampur.
I appear for the, I appear for the fourth respondent counsel, my lord. Your
Yes,
lordships
Naveen
were
Jain.
pleased to grant an interim order in favor of the petitioner, directing the maintenance of status quo. Thereafter, my lord, the corporation which is a party to the petition the corporation which is a party to the petition right royally gets a road laid in my land. When I pointed out there is interim order, please don't take up. Corporation sits silently and the contractor says, I am not a party to the petition, therefore I will do the work. Then, my lord, on the last day of earlier sitting,
Yes, Gaurish
court
Kashampur.
said you remove all those machinery, etc. Remove all those machinery, etc. Order was made and the application to take action was kept pending.
You are for Gaurish Kashampur?
No, no.
Huh?
Jaikumar S. Patil.
Who appears? Mr. Gaurish Kashampur. Huh?
And corporation till today has not even filed a statement.
ನಿನ್ನೆ ಅಲ್ರಿ ಹಂಗಿದ್ರೆ 3 ದಿನ ಹಿಂದೆ ಸತ್ತೋಗಿದ್ಯಾರ ಹಂಗಿದ್ರೆ 3 ದಿನದ ಹಿಂದೆನೆ 3 ದಿನದಿಂದ ಬರ್ತಾ ಇಲ್ಲ ಅವರು 3 ದಿನದಿಂದನೇ ಯಾರನ್ನ ಸಾಯಿಸಿದ್ರು ಅವರು. From the last 3 days he is not coming saying that somebody has expired. No, you say ನಿನ್ನೆ ಯಾರೋ ಒಬ್ರು ತೀರೋದ್ರು ಅಂತ. Yes, but what are your instructions, whether they have removed the equipment or not?
Equipment is removed. Now they are now allowing the public to use that as a road. In my land, right, royally it is being done and corporation has not even taken care to file a statement.
Now that they have completed the order dated 5/12/24, will take up the petition for final disposal.
ಅಲ್ಲಲ್ಲ ಈ ಕಾರ್ಪೊರೇಷನ್ ಮೇಲೆ ಆ ರೋಡ್ ಅನ್ನ ಕ್ಲೋಸ್ ಮಾಡಿಸ್ಬೇಕು. ದೇ ಇಂಟೆನ್ಷನಲಿ ದೇ ವಾಂಟ್ ಟು ಎಸ್ಟೇಪ್ put up the public.
Gaurish Kashampur is not
disturb
here
my
today.
profession.
Not here today. We'll list it on some other day. ಯಾರೋ ತೀರೋಗಿದಾರಂತ ಅವ್ರ ಮನೆ.
Please, my lord, kindly give a date. Let them file at least a statement. I was expecting them to say, we are sorry something has happened.
Yes.
They don't even care for that.
The request is made by the Land Council for the respondent number 5 for an adjournment on the ground that there is a bereavement in the family of the respondent, counsel for the respondent number 5. Hence list on date put.
Interim order to be continued.
Interim order granted as late extent till the next day. Yes. Ravi B. Patil.
Here.
Gaurish Kashampur. Answering respondent here, proposed amendment anything?
Lords should recollect, my lord, this is a matter, my lords, where, my lords, the Honorable KAT on the Honorable High Court has directed the respondent number 4 and 3, my lords, to hold an inquiry. There appear to be some interdepartmental communication that have now been challenged. Because as a respondent, I made a submission that the petition may be allowed, Z and Z1 may be quashed. I may be permitted, my lords, to comply with the directions issued by the Honorable KAT and the Honorable High Court, my lords. At that juncture, my lords, are kindly pleased to raise a question, my lords. In fact, my lords, a submission was made that because that Mantraya road has been set up, the other road becomes otious or redundant. My lords, may kindly recollect, my lord, that is a road which leads the station to some other village. That road has got nothing to do, my lords, with the Mantraya road. And secondly, my lords, are also kindly pleased to ask if that road could be shifted towards the periphery of the lake. But what has been granted or alleged to have been granted is two different portions or pockets of parcels of land. The road, my lords, is in the middle of that. So the road is not a subject matter of the alleged grant, my lords. The road was a village, my lord, as per the village map, my lord, the road was a car track. It continues to be so. So the contention is that because I have permitted them to use the other portion of the land for Mantralaya road, I have been permitted to use this road in the middle of the lake. And you will also kindly.
The last year there was some direction.
Survey agide swami. Survey agbitu
Survey has been done without, my lord, giving, my lord, clear measurements. My lord, I have filed, my lord, objection.
Please read the order dated 1912.
1912, my lord, this writ petition is, this writ petition is filed by the petitioners claiming to be the owner of land forming part of survey number 1233 measuring 10 acres 11 guntas and survey number 1234 measuring 3 acre 33 guntas. Totally measuring 14 acre 4 guntas situated at Raichur. In view of certain proceedings initiated by respondent authorities resulting in withdrawal of the change of land usage that was earlier issued by the Deputy Commissioner with order dated 11/1/1983 and withdrawal of the development plan that was issued by the Raichur City Planning Authority, Raichur, the petitioner had approached the appellate tribunal on 2 occasions on this court on 1 occasion. It is necessary to refer to the order passed by the Karnataka appellate tribunal dated 14/12/2018 by which while remitting the matter, the tribunal had directed the Deputy Commissioner to measure the disputed land, tank bed area, public road, government land situated in and surrounding to the disputed land, trace out the encroachment in the tank bed area, public road, damage to public property, etc. by recording measurement in the video on mobile preserved in the disk, providing opportunity to the applicants and the persons who are having interest in the disputed land in accordance with law. This court by order dated 19/3/2024 passed in writ petition number 201953 of 21 had directed the respondent number 4 Raichur Development Authority to take action against the petitioners if there was a violation of the sanctioned plan, layout plan. Pursuant to thereof, the Taluka surveyor Raichur had issued a notice dated 21/11/2024 to the petitioner intending to conduct the survey and seek their cooperation in the matter. This court by order dated 29/11/2024 had granted the interim order of stay staying the proceedings wide annexures Z to Z2, reserving liberty to respondent to seek modification, vacation of the interim order. Today, Shri Mahantesh Patil and Shri Gaurish Kashampur, learned counsel for the respondent authority, submit that in view of the interim order, the concerned authorities are not able to proceed and comply with the directions issued by the appellate tribunal, and this court, therefore, they seek permission, leave of this court to conduct the survey as directed. In response, Shri Ravi B. Patil, learned counsel for the petitioner, submit that while the petitioners have no objection in respondent authorities conducting the survey as directed by the appellate tribunal, the only apprehension is that under the guise of a conducting survey, the respondent authorities may change the nature of the property, which would put the situation in an irreversible condition. He further submit that respondent authorities be directed to conduct the survey without changing the nature of the land. The submission is taken on record. In that view of the matter, the respondent authorities are directed to conduct the survey of the land as directed by the Karnataka Appellate Tribunal, while its order dated 14/12/2018 as noted above. The petitioner shall extend necessary cooperation to the respondent authorities in conducting the survey. The respondent authorities shall conduct the survey on 30/12/2024 in the presence of the petitioner and any other person who is interested in the subject property, and shall furnish the report to this court on next date of hearing, that is on 10/1/2025. The survey authority shall also specifically identify the lake buffer zone which is required to be maintained as per the statute. It is made clear that while carrying out the process of measurement and survey and identifying the boundaries and buffer zone as directed here and above, the respondent authority shall not take any action which would result in change of the nature of the subject land. This is matter on 10/1.
Please wait one minute. You please come to the survey report.
Please, my lord.
Please.
Please, my lord.
Go to the sketch.
Please, my lord.
The existing water level in the yellow portion is there.
Please, my lord.
Number 2.
Please, my lord.
Both that is the buffer zone.
Please, my lord.
So there also it must be water covered,
Please, my lord.
covered by water.
Please, my lord.
Which does it mean to say that the entire portion, including the buffer zone, forms part of survey number 1233?
Lords, we have mentioned the buffer zone, my lords. My lords, can you take the first one, my lords, in the pink color, my lords? That is as per the revenue records. Because there's now a confusion, my lords, as to whether it's the FTL, with a full tank level, my lords, or whether, my lords, it is the revenue records. So, my lords, the ADLR in their wisdom, my lords, have chosen not to be judgmental about it as to what forms the buffer zone. Okay, they said, my lord, buffer zone as per the revenue records.
No, that's okay. Does it mean to say that the property bearing survey number 1233 extends up to the buffer zone?
Yes.
If it extends, then what will you do with the water? Existing lake water level in the yellow color is the number 2.
Please, my lord.
What will you do with that water?
That's my lord. That's my lord. I'm going to understand that the minor irrigation department, my lords, will have to, in consultation with the revenue, mark the FTL, my lord. Because, my lord, the water level of the body, my lords, depending upon the rains and the monsoons, would either decrease or increase or shrink. So, as on the date, my lords, the survey was conducted. The pink one is the one, my lord, which is the buffer zone as per the revenue records maintained by the revenue department. Nevertheless, my lord, there is a standing water. So whether, my lords, it would be the full tank level, my lords, or whether, my lords, it would be during the inquiry that conduct.
If that is so,
my lord,
assuming, I don't know what is the buffer that you have given.
15 meters, my lord, as per the circular, my lords.
Is it 15 meters?
Please, my lord, for the, my lords, the depending upon the size of the lake, my lord. How the circular
size of the lake, if it's a water body, if it's a tank.
Circular is this one.
ಎಷ್ಟಿದೆ ಮಂತ್ರಿ?
I'll submit, my lords.
So what prevents you from restricting the plan that is sanctioned and the commercial?
I'm sorry, no, stand corrected. 30 minutes, no, I stand corrected. 30 meters, my lord.
30 minutes change ಆಯ್ತಲ್ಲ.
I'll submit the document, my lord.
ಕೊಡಿ ಮಂತ್ರಿ ಜಡ್ಜ್ಮೆಂಟ್ ತಂದ್ರ? What does it say?
That order of my lord, Rabdhan, my lord, green belt.
My lords, may kindly take my lords, page number 4, my lords. My lords, may kindly take my page number 4. If I'm permitted to read, my lords, the unnumbered paragraph 2, my lords. ಈ ಮೇಲ್ ಕಾಣಿಸಿದ ಅನುಸಾರ ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯೂ ಸೇರಿದಂತೆ ರಾಜ್ಯದ ಎಲ್ಲಾ ಮಹಾನಗರ ಪಾಲಿಕೆಗಳ, ನಗರಸಭೆಗಳ, ಪುರಸಭೆಗಳ, ಪಟ್ಟಣ ಪಂಚಾಯತ್ಗಳ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಕೆರೆ, ಕಟ್ಟೆ ಮೊದಲಾದ ಜಲಾಶಯಗಳ ಅಕ್ರಮವಾಗಿ ನಿರ್ಮಾಣ ಮಾಡಿರುವ ಕಟ್ಟಡ ಸಂಚರಣೆಗಳನ್ನು ತೆರವುಗೊಳಿಸಿ ಜಲ ಕಾಯ್ದೆಗಳ ಸಂರಕ್ಷಣೆ ಬೇಕಾಗಿರುತ್ತದೆ. ಮಾತ್ರವಲ್ಲದೆ ಸೋ ಅಂಡ್ ಸೋ ಜಲಾಶಯ ಅಂಚಿನಿಂದ 30 ಮೀಟರ್ ವರೆಗಿನ ನಿರ್ಬಂಧಿತ ಪ್ರದೇಶದಲ್ಲಿ ಸಹ ಯಾವುದೇ ಅಕ್ರಮ ಕಟ್ಟಡ ಸಂಚಲನವನ್ನು ತೆರವುಗೊಳಿಸಬೇಕಾಗಿರುತ್ತದೆ. So the circular, my lords, which categorically says that the 30-meter buffer zone will.
The Supreme Court say.
No, in the monthly judgment, my lords, it went from, my lords, the Honorable NGT, where, my lords, the buffer zones were increased, my lords. That order has been set aside, and there is no specific mention. My brother will correct me if I'm wrong, my lords. There's no specific mention as to what would be the buffer zone in this, my lords.
Para 62, my lord, last operating portion, where, my lord, the general guidelines which were
Para
issued by the.
24.
Please, 24. It was also argued buffer. It was also argued that buffer zone laid down by NGT is substantially higher as compared to buffer zone which is required to be maintained as per the revised master plan 2015 issued on 22/6/2007. This is contrary to Karnataka Town and Country Planning Act 1961. Shri Neeraj Kishan Kaul and Shri Venkata Leonard Senior Counsel appearing for the appellants in this case have also made similar submissions. It was argued that the direction imposing penalty compensation is illegal on the ground that the applicants did not allege that the construction work of a project has caused environmental wrong. No wrong or injury either to Belandur Lake water body or Belandur Lake area has been alleged and established. As such, there is no question of any inquiry relating to imposition of penalty or any compensation. Shri Maninder Singh, Leonard Senior Counsel, appearing for the appellant's application number so and so, and while supporting the submission made by Shri Rotagi, had submitted that the appellant has obtained sanction and approvals for the project from the competent authorities. It could not start construction despite grant of all permissions, including environmental clearance as early as possible, that is 39/2013. Hence, imposing penalty compensation is entirely unsustainable. Then Advocate General Shri Udayala, appearing for the appellant state Karnataka and so has submitted that state of Karnataka is also aggrieved by the order of the NGT to extend setting aside the buffer zone in respect of water bodies and drain specified in revised master plan 2015 and enlargement of the buffer zone in respect of lakes and Rajakalways. It is also agreed by the order of NGT directing the authorities to demolish all the offending constructions raised built in the buffer zone, which will result in demolition of 95% of the buildings in Bengaluru. It is submitted that a revised master plan is statutory in nature and NGT has no power, competence or jurisdiction to consider the validity or virus of any statutory provisions regulation. Therefore, the order of NGT to that extent is liable to be set aside. Learned Senior Counsel appearing for the appellant in other cases have also supported the arguments of Learned Advocate General. It was contended that the revised master plan provides for 30 meters buffer zone around the lakes and buffer zone of 50 meters, 25 meters and 15 meters from the primary, secondary and territory drains, respectively to the measured from the center of the drain. While the impugned judgment, the NGT has revised these buffer zone and has directed that the buffer zone be maintained for 75 meters around the lake and 50 35 and 25 meters respectively from primary, secondary and tertiary drains respectively. Variation of buffer zone as directed by NGT is without any legal and scientific basis and has effect of amending the revised master plan 2015 without there being any challenge to the same or any relief sought with respect to the said revised master plan. On the other hand, Shri Sajjan Puaya, learned senior counsel appearing for the appellants, has fairly submitted that the applications were filed only against the appellants, that is, and he has no objection to set aside the order insofar as the applications, appellants in other appeals, including the state of Karnataka, are concerned. He has also no objection to set aside the general conditions and directions of NGT in paragraph number 1 of the order dated 4/5/2016, except the directions issued against the respondent number 9 and 10. In view of the above, it is not necessary to examine the contentions of learned Advocate General in civil appeal number so and so. It is also not necessary to consider the contentions urged in the other civil appeals except the appeals filed by the respondent number 9 and 10. Shri Puya has strongly opposed the submission made by the learned senior counsel appearing for the appellants. And so it is submitted that tribunal is a specialized body for effective and expeditious disposal of the cases relating to the environmental protection and the conservation of forest and other natural resources, including enforcement of any legal right relating to environment. The jurisdiction of the tribunal is provided under section 14, 15 and 16 of the NGT Act. Section 14 provides for a jurisdiction over all civil cases where the substantial question relating to environment is involved. However, such questions should arise out of implementation of the enactment specified in Schedule 1. The tribunal has the jurisdiction under section 15(1)(a) of NGT Act to provide the relief and compensation to victims of pollution and other environmental damage arising under the enactment specified in Schedule 1 under section 15(1)(b) and 15(1). The tribunal can provide for restitution of property damaged and for restitution of environmental for such area or areas as the tribunal may think fit. Section 15(1)(b) and 51(c) have not been made relatable to enactment specified in Schedule 1 of the Act. Section 15(1)(c) is an entire island of a power and jurisdiction read with Section 21 of the Act. He submits that
It's
whenever
a lake under the Lake Development Authority.
it's a tank, it's a tank.
ಅಲ್ಲ, Lake Development Authority ಇದೆಯಾ ಇದು? ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ sir. But my lords, now the confusion, my lords, is whether, my lords, when the buffer zone, my lords, is being identified and determined, whether would that be as per, my lords, the revenue records, or, my lords, the concept of the full tank level, my lords. So that, my lords, that's not a subject matter of the instant survey. So the ADLR, my lord, in her wisdom, has thought fit, my lords, to mention as the revenue, standing revenue records, this would be the buffer zone, and has also indicated that there is a standing water. But now the question of facts, my lord, one more question, your lordship, kindly please raise, my lord, whether there could be a shifting of that road to the periphery. Because this road not having at all been granted, this road not having been a part of the plan because it continued to be so. The assertion of the petitioners that because that road has been made the Mantala road, I have chosen to use this, but it's dehorsed any merit and there are no documents to sustain the same. So even as per the admission of the petitioners themselves, Lord, there is an encroachment of that government road, please, my lord. So these are the disputed questions, my lord. It's in view of these disputed questions that your lordships, my lord, have felt it appropriate, and the KAT has felt it appropriate that let there be, my lords, an inquiry giving them an opportunity in a very transparent manner, and then, my lords, records, after appreciating the records, findings be given. It's at this stage, my lord, that the petitioners are before this court challenging the interdepartmental correspondence, which may, in my humble submission, be quashed.
No, correct, but there should be end to litigation. He has been litigating from so many years. There's some way of.
That's the reason we want to put an end. We want to put a quietus by holding an inquiry, my lord.
No. First of all, you please tell us,
my lord,
what is the area which is available for the petitioner in survey number 1230? Iದೇನು grey color paint ಮಾಡಿದಿರಲ್ಲ?
Please, my lord.
What is the total extent of that land? Number 1.
Please, my lord.
Number 2, what is the total extent of the yellow portion? Number 3, what is the total extent of the pink portion?
Please, my lord, kindly permit me to take instructions, my lord.
Told.
They have provided it, my lord, at page number 5, my lord. Next page.
The legend, my lord.
Next page, my lord. The pink portion, they say, my lord, it covers, my lord, 4 acre 1 gunta. And my lord, the yellow portion, they say, my lord, it covers 1 acre 5 guntas. purple, my lord, portion, they do not provide any measurement. And then, my lord, the green portion, what they claim is the encroachment of the road. They claim, my lord, it is a 37 gunta.
Not that I'm claiming not, it's his justification.
So therefore, you don't pay compensation for him for the buffer.
But if in law he's entitled.
He is entitled to.
Because.
See, under the Town and Country Planning Act,
My lords.
whatever roads which are set apart in the RMP, if you want that roads to be relinquished, you are bound to pay compensation. That is the law declared by this court.
My lords.
Time and again we have declared.
My lords.
Now, you say out of 14 acres, you say you set apart 4 acres, 1 gunta for a buffer. Page number 6 ಅಲ್ಲಿ.
Please, my lord.
4 acres, 1 gunta buffer ಬಿಡು ಅಂತ ಹೇಳ್ತಿದ್ರಿ. ಅವಂದು ಜಮೀನ್ ಅದು.
That's what
ಖಾಲಿ ಬಿಡು ಅಂತ ಹೇಳ್ತಿದ್ರಿ.
My submission is this. Once we hold an inquiry, if it is found that the land belongs to him and it has to be used as a buffer zone, all the provisions of law will be meticulously met. But I am not my lords Brutus. I'll not take anybody's pound of flesh without my lords giving the dues.
Right, but there should be end to litigation.
So there are directions. My lords will kindly appreciate this. The honorable order of the honorable KAT and your lordship's order have attained finality. Now, my lords, save for this order, I will be in contempt. It is not the case of the petitioner.
4 ಎಕರೆ 1 ಗುಂಟೆ plus 1 ಎಕರೆ
5 gunta.
5 ಗುಂಟೆಗೆ compensation ಕೊಡಿ.
If he's entitled in law, my lords, let me hold an inquiry.
They are saying that he is entitled to because
It's a buffer, my lords. Kindly appreciate, my lord. If at all I am acquiring that land, then I have to pay compensation. Buffer, he continues to be the owner. The buffer land, he continues to be the owner. He can use it for purposes which are permitted.
Yeah,
Only thing is he cannot put up construction. Or he can have a garden, he can have a park and any other things that permitted under, my lords, the extant law. But my lords, if at all is entitled, my lords will kindly observe. If he is entitled in the extant law, my lords, I am a state, I have to pay. But my humble submission is, since the land is not being taken away, he continues to be the owner. Only the utility is regulated. It is not that.
What is the ಉಪಯೋಗ? ನನ್ನ ಮೂಗಿನ ಮೇಲೆ ಬೆಣ್ಣೆ ಇಟ್ರೆ ವಾಸನೆ ಕುಡ್ಕೊಂಡು ಇರ್ಲಿ ಅಂತ ಅಂದ್ರೆ.
That's the law, my lords.
What is the use?
My lords may kindly hold that if at all I'm liable to pay under the law, under the provisions of law. Because my submission, my lord, my understanding also, my lords, is that since the land is not being taken away from him, he continues to be the owner. The use is regulated. So if at all, my lords, under law or in law, I'm liable, my lords.
Use is regulated and then no construction.
No construction.
Full stop.
No construction.
How will you use it?
Because, my lords, when a layout, my lords, is approved, my lord, there has to be, my lords, allotment of land. Only 30 to 40% of the entire land, my lords, is permitted for the purpose of construction. The remaining portion of the land, my lord, shall have either to be a CA or, my lord, the lung space or the green, but so that it may be utilized. So the use, my lords, is only regulated. My submission is that, but having said that, my lord, if under the extant provisions of law, if he's entitled, I'll indeed, my lords. But as of now, so what exactly is the buffer zone also has to be the scope of inquiry. Whether encroachment is there. He himself says that I have been using this road because that part of the road has been given to Mantralayam. I have nothing to do with that road, please, my lord.
Yes.
So these are my submissions, my lord. So my submission, my lord, would be, my lord, that I am open, my lords. I'll produce all the necessary documents before this court, but only, my lords, in view of the directions, my lord, staring at me. My submission is I may be permitted, my lords, to hold an inquiry, my lords, and the provisions.
Whether this orange color portion is also part of the survey number 1234?
No, it is the 1234 where is development. That is
Orange color portion.
Please, my lord.
Southern side ಇರೋದು buildings ಅಂತ ಇದೆಯಲ್ಲ.
Building
1234.
1234.
Also part of 1234.
My layout.
It's his layout, and we are not
There
having.
are two survey numbers, sir. 1233 measuring 10 acre 11 guntas, 1234 measuring 3 acre 33 guntas.
So 1234 is developed, my lords. 1234, there are standing buildings, I'm going to understand. So that is not as much a dispute, as much, my lords, is the.
So 1233 ಎಷ್ಟಿದೆ? Total extent ಎಷ್ಟು?
10 acre 11 guntas.
10 acres?
11
11
guntas.
ಇದ್ರೊಳಗೆ 4 ಎಕರೆ 1 ಗುಂಟೆ 1 ಎಕರೆ 5 ಗುಂಟೆ ನೀರಲ್ಲಿ ಹೋಗಿದೆ.
ಹೌದು.
5 ಎಕರೆ 6 ಗುಂಟೆ ಹೋಯ್ತು. So 5 acres, 5 guntas is what remains.
Yes.
May I make one humble submission, Lord? My lords may dispose of the petitions, directing me After holding an inquiry, if it is found that for buffer zone, money has to be paid, compensation has to be paid, I will pay, my lord, because ultimately, my lord, I am a state, I will not deny anybody the benefit. The only thing because I'm staring at a contempt, my lords, my submission is that I may be permitted to pass the orders. And kindly see, my lord, annexes Z and Z1 that are in challenge before your lordships, my lord. This annexes Z, please, my lord, is that page type copy 144, 144, one Z, page number.
Yes, Ravi B. Patil, what have you challenged?
I have challenged initially, my lord, Z1, Z2, and my lord, now
Z1.
application seeking for, my lord, amendment. Wherein, my lord,
Z-
I also challenged, my lord,
Z and Z1 is what is challenged initially.
initially.
ಆಯ್ತು ZD ಏನಿರುತ್ತೆ ಓದಿ. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ 1ರ ಪತ್ರ ದಿನಾಂಕ ಕೇಳಿದ ಹೆಚ್ಚೂರು ತಾಲೂಕು ರಾಯಚೂರು ಗ್ರಾಮದ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ ಅನುಕ್ರಮ 10 ಎಕರೆ ವಾಣಿಜ್ಯ ಮತ್ತು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ಚಾಲ್ತಿಯಲ್ಲಿರುತ್ತದೆಯೇ, ರದ್ದುಪಡಿಸಲಾಗಿದೆಯೇ ಅಥವಾ ನವೀಕರಿಸಲಾಗಿದೆಯೇ ಎಂಬುದರ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ಕೋರಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖಿತ ಭೂಮಿಯನ್ನು ವಾಣಿಜ್ಯ ಮತ್ತು ರದ್ದುಪಡಿಸಲಾಗಿದೆ ಎಂದು ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಯಪಡಿಸಲಾಗಿದೆ. Then
Then, my lord, Z1 is passed by, my lord, the Rajasthan Development Authority.
What is Z1?
Z1 is the
Z1, my lords, is a communication issued by me, my lords, to the office of the DC, my lord, the Deputy Commissioner,
ಏನಂತ?
seeking instructions as to how to proceed. My lords, at 146, my lords, the last paragraph may kindly be appreciated.
Read from the portion, order portion.
The order portion is only extract, my lord. It has been extracted.
ಉಲ್ಲೇಖ 7.
ಮುಂದುವರೆದು ಉಲ್ಲೇಖ
7 ಪ್ರಕಾರ ಮಾನ್ಯ ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ಕೋಶ ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಾರ್ಯಾಲಯ ರಾಯಚೂರು ಅವರ ದಿನಾಂಕ 22/5/2024 ಸಭೆಯಲ್ಲಿ ಮಾವಿನಕೆರೆ ಅಭಿವೃದ್ಧಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಗತ್ಯ ಕ್ರಮ ವಹಿಸಲು ಸೂಚಿಸುತ್ತಾರೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 8ರ ಪ್ರಕಾರ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಅತಿ ತುರ್ತಾಗಿ ವರದಿ ಸಲ್ಲಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಪ್ರಸ್ತುತ ಸದರಿ ಜಮೀನಿನ ಭೂ ಪರಿವರ್ತಿತ ಆದೇಶವು ಚಾಲ್ತಿಯಲ್ಲಿರುತ್ತದೆಯೇ, ರದ್ದುಪಡಿಸಲಾಗಿದೆಯೇ ಅಥವಾ ನವೀಕರಿಸಲಾಗಿದೆಯೇ ಎಂಬುದರ ಬಗ್ಗೆ ಮಾಹಿತಿಯನ್ನು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಕಳಿಸಿಕೊಡುವಂತೆ ಕೋರಲಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 9ರ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ರಾಯಚೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 1233 ಅನುಕ್ರಮವಾಗಿ 10 ಎಕರೆ 11 ಗುಂಟೆ ಮತ್ತು 3 ಎಕರೆ 33 ಗುಂಟೆ ಭೂಮಿಗೆ ವಾಣಿಜ್ಯ ಮತ್ತು ವಾಸಕ್ಕಾಗಿ ಮಂಜೂರಿಯಾದ ಆದೇಶವನ್ನು ಈ ಕಾರ್ಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ ದಿನಾಂಕ 16/1/2012 ರದ್ದುಪಡಿಸಲಾಗಿದೆ ಎಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಮೀನಿನ ಭೂ ಮಾಲೀಕರಾದ ಶ್ರೀ ಆರ್ ನಾರಾಯಣರಾವ್ ತಂದೆ ವೆಂಕೋಬಾ ರಾಯಚೂರ್ ಇವರು ಮನವಿಯ ಮೇರೆಗೆ ಉಲ್ಲೇಖ 10ರ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿ ಪೀಠ ಕಲಬುರಗಿ ಅವರ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 2019/3 ರಲ್ಲಿನ ತೀರ್ಪಿನ ಪ್ರತಿವಾದಿ ಕ್ರಮ ಸಂಖ್ಯೆ 4ರಲ್ಲಿ ಆಯುಕ್ತರು ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ರಾಯಚೂರು ಇವರಿಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಪ್ರಕಾರ ಸಂಬಂಧಿಸಿದ ಇಲಾಖೆಗೆ ಸಂಪರ್ಕಿಸಿ ಮನವಿ ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 11ರಲ್ಲಿ ಶ್ರೀ ಆರ್ ನಾರಾಯಣರಾವ್ ತಂದೆ ವೆಂಕೋಬಾ ರಾಯಚೂರು ಇವರು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ರಾಯಚೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 1233, 1234 ಅನುಕ್ರಮವಾಗಿ 10 ಎಕರೆ 11 ಗುಂಟೆ ಮತ್ತು 3 ಎಕರೆ 33 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡಲು ಅನುಮತಿ ನೀಡುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಪರಿಶೀಲನಾಗಿ ಸದರಿ ಜಮೀನಿಗೆ ಉಲ್ಲೇಖ 9ರಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶ ರದ್ದಾಗಿದ್ದು, ಉಲ್ಲೇಖ 2ರ ಪ್ರಕಾರ ಈಗಾಗಲೇ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯನ್ನು ಸಹ ರದ್ದುಪಡಿಸಿರುವುದರಿಂದ ಭೂ ಮಾಲೀಕರ ಕೋರಿಕೆಯ ಮೇರೆಗೆ ನಿಯಮಾನುಸಾರ ಸದರಿ ಜಮೀನಿನಲ್ಲಿ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಮಾಡುವುದು ತಾಂತ್ರಿಕ ಅಭಿಪ್ರಾಯ ನೀಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂಬ ಮಾಹಿತಿಯನ್ನು ತಮ್ಮ ದಯಪರ ಅವಗಾಹನಕ್ಕಾಗಿ ಸಲ್ಲಿಸುತ್ತಾ ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಅವರ ರಿಟ್ ಪಿಟಿಷನ್ 2019/5/3 ಆದೇಶದ ಪ್ರಕಾರ ಕ್ರಮ ವಹಿಸಲು ಸೂಕ್ತ ಮಾರ್ಗದರ್ಶನ ನೀಡಬೇಕೆಂದು ಈ ಮೂಲಕ ಮಾನ್ಯರಲ್ಲಿ
WP 201953 order.
Page number 125 onwards. The order starts from page number 127. First, Learned Counsel for petitioner Mantesh Patil, Learned Counsel for the respondent, so High Court Government Advocate 134. The writ petition is filed with the following prayer: issue writ of session to quash the impugned order bearing number dated 23/2017 as at annexure T passed by the fourth respondent authority as illegal and arbitrary and without jurisdiction. Issue writ of mandamus directing respondents 1 to 7 to comply direction issued by the in appeal number so and so issued by the Honorable Karnataka Appellate Tribunal, Bangalore, void annexure Q within such stipulated time as this one court deems fit in the circumstances of the case in the interest of justice. Pass any orders out. The grievance of the petition, writ petitioner is that they have applied for conversion of agricultural land for non-agriculture purpose, which was approved by the Deputy Commissioner. However, without proper reasons, the conversion order was cancelled by the Deputy Commissioner, which was challenged before the Karnataka Appellate Tribunal. Entertaining the appeal of the writ petitioners, the matter was again remanded to the Deputy Commissioner for holding the fresh inquiry with regard to the cancellation of the permission. Again, Deputy Commissioner passed an order confirming the cancellation of the approval. Again, the writ petitioner approached the Karnataka Appellate Tribunal in appeal number 138 of 2012 by order dated 14/12/2018. The KAT set aside the order of the Deputy Commissioner and whereby the permission granted to the writ petitioner become confirmed. In the meantime, without any notice whatsoever to the petitioners, the respondent number 4 said to have cancelled the approval of the layout. This action, according to writ petitioner, is high-handed action and is intended to harass the writ petitioner. Per contra, Shri Mantesh Patil, Learned Counsel for the respondent number 4 submits that what has been cancelled by the respondent number 4 is the approval of the layout plan given to the writ petitioners as it has occupied tank area. Shri Gaurish Kashampur and Learned High Court government leaders support the argument put forth on behalf of the respondent number 4. In reply, Ravi Patil submits that report has already been there on the record, which would go to show that there was no encroachment of a tank property by the writ petitioners while forming the layout. This court, having heard the learned counsel for the parties peruse the material on record meticulously on such perusal of the material on record, it is crystal clear that the lands belonging to the writ petitioners were sought to be converted for non-agriculture purpose and therefore necessary applications has been filed before the Deputy Commissioner. The permission which was granted earlier has been cancelled on 2 occasions, which were challenged by the writ petitioner before the KAT, and the KAT has come to rescue of the writ petitioners in restoring the permission for conversion of the lands. Later on, respondent number 4 said to have passed the order at annexure T, cancelling the approval of a layout formed by the petitioners. The said order is on pretext that there an encroachment of a tank property. Admittedly, no inquiry has been held by the respondent number 4 before passing the order at annexure T. Therefore, annexure T needs to be quashed and the matter is to be re-adjudicated by the respondent number 4 after notifying the writ petitioner in accordance with law. Hence, following the writ petition is allowed. The order at annexure T stands quashed. However, respondent number 4 is at liberty to take fresh action against the writ petitioner if there is a violation of condition for approval of the layout plan. In that regard, the matter is remitted to respondent number 4. Respondent number 4 shall notify the petitioner and pass appropriate orders in accordance with law within a period of 3 months from the today.
Is it this stage,
My
my
lord,
lord?
this being the fact, KAT twice or set aside the order of Deputy Commissioner, cancelling the conversion order. This honorable court, my lord, set aside the order of cancellation of layout. Again, my lord, under Z1, my lord, they say the layout, the order of conversion is already been cancelled, and my lord, the layout is also cancelled. This approach of my lord, the authority is only to see that my lord, petitioner is deprived of an benefit. And my lord, what they wanted to hold, my lord, why I was compelled to approach this honorable court. By observing all these facts, my lord, they issued us a notice for measurement of a road.
Own country plan. ನಿಮ್ಮಲ್ಲಿ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಇಲ್ಲ.
ಇದೆ ಸ್ವಾಮಿ. I have produced the copy of the approved CDP map.
Who is the planning authority?
Urban Raichur Urban Development.
Now it's me, my lords. Now it is me, my lords.
Now it is?
Me, my RDM, the Raichur Development Authority.
I have enclosed the copy of the CDP map pertaining, which reflects this portion of the land.
No, he says that he is willing to give up the entire survey number
That is because may make one submission.
1233.
How?
My lord.
He is willing to give up the entire 1233 if you acquire it.
How?
If not, I'm not liable for acquiring the land is my humble submission.
Yes.
But may take 1 minute of the court to complete, my lord, why I made that submission, my lord. May take, my lord, along with, my lord, the objection to survey report filed on, my lord, 13th January 2025. My lord, we being the landowners, my lord, were called for a meeting by the deputy commissioner. My lord, the page number 48. On 11/1/2024.
48 of what?
Of, my lord, the objections filed to, my lord, survey report on, my lord, 13th January 2025.
By 13 January ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. ಇದೇನ್ ನೋಡ್ರಿ ಅಲ್ಲೆಲ್ಲದು.
May pass.
Peaceful.
Page number 48, my lord. This is a notice issued to us, my lord. ರಾಯಚೂರು ನಗರ ಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಮಾವಿನಕೆರೆಯಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸುವ ಕುರಿತು ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಯಚೂರು ನಗರಸಭೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಮಾವಿನಕೆರೆಯಲ್ಲಿ ಅಭಿವೃದ್ಧಿಪಡಿಸುವ ಕುರಿತು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ರಾಯಚೂರು ಅವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 11/1/2024 ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಾರ್ಯಾಲಯ ರಾಯಚೂರಿನಲ್ಲಿ ಸಭೆಯನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಸದರಿ ಸಭೆಗೆ ಅಗತ್ಯ ಮಾಹಿತಿಯೊಂದಿಗೆ ಹಾಜರಾಗುವಂತೆ ತಿಳಿಸಲು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನಿರ್ದೇಶಿಸಲ್ಪಟ್ಟಿರುತ್ತೇನೆ. This was discussed in the meeting. And then, my lord, may I take your lordship, my lord, I am referring to, my lord, page number 51. My lord, I have, my lord, the entire recording of this proceedings also, my lord, which was also a subject matter of local news, my lord. This, my lord, page number 51. Nagara, we were also sitting, we could also be seen, my lord, in the photograph. ನಗರ ಮಾವಿನಕೆರೆ ಅಭಿವೃದ್ಧಿ ಕುರಿತಂತೆ ಕೆರೆಯ ಭೂಮಿಯ ಮಾಲೀಕರೊಂದಿಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ಚಂದ್ರಶೇಖರ್ ನಾಯಕರವರು ಇಂದು ಚರ್ಚಿಸಿ ಅಭಿವೃದ್ಧಿಗೆ ಸಹಕರಿಸಲು ಮನವಿ ಮಾಡಿದರು. ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಚೇರಿ ಸಭಾಂಗಣದಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರು ಗುರುವಾರದಂದು ಭೂ ಮಾಲೀಕರೊಂದಿಗೆ ಈ ಕುರಿತು ಸಭೆ ನಡೆಸಿ ಚರ್ಚಿಸಿದರು. ಮಾವಿನಕೆರೆಗೆ ಒಳಪಡುವ ಖಾಸಗಿ ಭೂಮಿಯನ್ನು ಕೊಟ್ಟು ಮಾವಿನಕೆರೆ ಅಭಿವೃದ್ಧಿಗೆ ಸಹಕರಿಸಬೇಕೆಂದು ಹೇಳಿದರು. ಮಾವಿನಕೆರೆ ಅಭಿವೃದ್ಧಿಗೆ ಸಹಕರಿಸುತ್ತೇವೆ, ಆದರೆ ಭೂಮಿ ಬಿಟ್ಟು ಕೊಡುವ ಕಷ್ಟವಾಗುತ್ತದೆ ಎಂದು ಭೂ ಮಾಲೀಕರು ಅಭಿಪ್ರಾಯ ವ್ಯಕ್ತಪಡಿಸಿದರು. ನಗರದ ಮಾವಿನಕೆರೆ ಪುರಾತನ ಕೆರೆಯಾಗಿದೆ. ಜನರು ಬೆಳಿಗ್ಗೆ ಮತ್ತು ಸಂಜೆ ವಾಕಿಂಗ್ ಬರುತ್ತಾರೆ. ಮಾವಿನಕೆರೆ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಲು ಸಿದ್ಧತೆ ನಡೆಸಲಾಗುತ್ತಿದೆ. ಸುತ್ತಲೂ ಒತ್ತುವರಿಯಾಗಿದ್ದು ಅದನ್ನು ತೆರವುಗೊಳಿಸುವುದರ ಜೊತೆಗೆ ಮಾವಿನಕೆರೆಯಲ್ಲಿ ಖಾಸಗಿ ಜಮೀನುಗಳಿವೆ. ಹೀಗಾಗಿ ಕೆರೆ ಅಭಿವೃದ್ಧಿಗೆ ಬಿಟ್ಟು ಕೊಡುವಂತೆ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ತಿಳಿಸಿದರು. He, my lord, suggested, my lord,
ನೀರೊಳಗೆ ಮುಳುಗೋಗಿರೋ ಜಮೀನ್ ಹೆಂಗ್ ಬಿಟ್ಕೊಡೋದು?
ಬೇಡ ಕೊಡೋದು ಬೇಡ ಅಂದ್ರೆ ಬೇಡ. We have made a request. We have made a, but in fact, the request also unreasonable. Request also is unreasonable.
ನೀರೊಳಗೆ ಮುಳುಗೋಗಿರೋ ಜಮೀನ್ ಹೆಂಗ್ ಬಿಟ್ಕೊಡ್ತಾರೆ ಬಫರ್ನ?
ಬಫರ್ ಬಿಟ್ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ. In fact, other lands, it is a very unreasonable. As for personally, unreasonable. But not even, my lords, an inch of land can be asked to be given to the government free of cost, unless somebody is very charitable. My lords.
Please tell us, how will you identify the buffer? Now the buffer is underwater.
Please, my lord.
How will you identify
We
the
have
buffer?
identified, my lords. We have identified. In fact, my lord, the petitioners.
You have identified, but can it be used as a buffer is what I am asking you.
They cannot use it, please, my lord.
Huh?
They cannot use it. No, this map must be kindly see, my lord, that the water level is much before, as of now, much before the buffer zone. So, my lord, the buffer zone has been identified, keeping in mind, my lord, the revenue records, because the revenue records would mention what is the boundaries, what is the extent of land. So, my lord, the request made by the DC, I'm not too sure under what provisions of law, my lords, he could make a demand. I understand it's only a request. because I have scanned through all the documents available in the office. We have not had the minutes of meeting or any official document to that effect. But at the same time, I will not disbelieve my learned friend. If at all a request has been made by the DC, it has been made, but there has been no compulsion to say that you necessarily will have to give the land. Kodi, bit kodi, ಎಲ್ಲರಿಗೂ help ಆಗುತ್ತೆ ಅಂತ ಕೇಳಿರ್ಬಹುದು. Unreasonable. What is unreasonable?
ಆ ಗ್ರೇ ಕಲರ್ ಎಷ್ಟಿದೆ ಅಂತ ಹೇಳಿ. ಗ್ರೇ ಕಲರ್, ವಾಟ್ ಇಸ್ ದ ಮೆಷರ್ಮೆಂಟ್ ಆಫ್ ದಟ್ ಗ್ರೇ ಕಲರ್ ಪೋರ್ಷನ್? ಗ್ರೇ ಕಲರ್ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ ತೋರಿಸಿ ಹೇಳಿ.
Gray means purple means?
The gray color one, the gray or blue, whatever you call it.
Please.
What is the area of that gray portion?
But what is marked in 3 millards would be 5 acres, 5 guntas. What is marked as 3 millard?
5 acres, 5 guntas ಅಂತ ಇದೆಯಾ?
5 acres, 5 guntas.
ಎಲ್ಲಿದೆ?
ಬರ್ದಿಲ್ಲ ಸರ್ 10 acres 11 gunta total.
Out of 10 acres, 11 guntas.
I want you to measure this green, this blue, whatever you call this, blue na gray na idu.
The
gray.
Purple. All the portions have been measured, my lord, but the.
ಎಲ್ಲಿದೆ? 3 ಎಲ್ಲಿ measure ಮಾಡಿ?
Really mentioned, my lord.
3 and 5.
10 11 remaining.
So out of 10, 11, what is the remaining land I'm given to understand, but it's not mentioned here. Measurement has been done. Survey has been done.
3 and 5 measurement ಕೊಡಿ.
3 and 5.
3 and 5. Therefore, 3 and 5. One acre, 5.
My lords, I'm going to understand, my lords, what is 5? My lords, is 1 acre and 5 guntas, my lord.
1 acre, 5.
This one?
This one, 5 acre, 5 gunta.
And the one is in 3 millards, 5 acres and 5 guntas, please, my lord.
It can't be.
It is not exactly there.
It is not 6 acres, 10 guntas ಆಗೋಯ್ತು ಅಲ್ಲಿಗೆ.
This road ಬಿಟ್ಟಿದ್ದಾರೆ. This road has not been added to either of the properties. That road that passes through.
Therefore, I'm asking you, what is the measurement of this gray portion?
But
3 and 5.
Please, my lord, 5 acres, 5 guntas plus, my lord.
1 acre,
1 acre, 5 guntas, my lord.
Measurement ಮಾಡಿ ಹೇಳ್ತೀರಾ?
Please, my lord.
Sir, it is already measured.
ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳಿ?
ಇದೆ already measured and calculated.
ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳಿ?
ಅದೇ sir 1 acre total e measurement sir. E measurement already it is scale is put sir 1 inch is equal to 5 cm.
5 plus 0.5 plus
total.
1 point.
ಮತ್ತೆ ಯಾಕೆ ನೀವು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಬರೀಲಿಲ್ಲ?
610.
So 6.10, my lords.
ನೀವು ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಬರೀಲಿಲ್ಲ?
Lords, since there was no specific direction to mention each one of that, my lords, but the measurement has been done. The measurement has been done.
Need to know where exactly is the land gone? How much is the land?
The land
under water?
Land ಇದೆ.
Underwater ಎಷ್ಟಿದೆ? Underwater ಎಷ್ಟಿದೆ?
Underwater.
My lord, what is in yellow, please? As of now, what is in yellow, please, my lord? That is 1 acre and 5
Buffer
guntas.
zone is also in water. Buffer is also in water.
Buffer also is underwater.
As much it is water. It is out of water.
No, buffer zone is not in water. As of now, buffer.
ಹೆಂಗಾಗುತ್ತೆ
buffer zone is not in water.
ಮಿತ್ತದಲ್ಲಿ ಹಂಗೆ ಬರುತ್ತೆ.
ಮಧ್ಯದಲ್ಲಿ ಹೆಂಗ್ರಿ ಇರುತ್ತೆ? ನೆಲ ಇರುತ್ತೇನ್ರಿ? This is not ಧನುಷ್ಕೋಡಿ.
But this buffer zone, my lords, is only as per the revenue records. This water standing, my lords, is what is as per the yellow.
ಇವಾಗ ಯೆಲ್ಲೋ ಕಲರ್ ನೀರಿದ್ಯಾ?
ನೀರಿದೆ ಸರ್.
ಬ್ಲೂ ಕಲರ್ ನೀರಿಲ್ವಾ?
ಇಲ್ಲ, blue color.
ಪಿಂಕ್ ಕಲರ್ ಅಲ್ಲಿ ನೆಲ ಹೆಂಗಿರುತ್ತೆ? If 1 is land, 2 is water.
It also in water sir.
But the pink also is in water, my lord. The buffer zone also is in water.
So pink also is under water ಅಂದ್ರೆ ಪಿಂಕುನು ಇವ್ರದೇ ಪ್ರಾಪರ್ಟಿ.
The buffer zone, ಹೌದು.
ಅಲ್ವಾ?
ಹೌದು.
ಈಗ ನೀವು ಬಫರ್ ಎಲ್ಲಿ ಬಿಡ್ಬೇಕು ಅವ್ರು ಇವಾಗ?
As per the
it should be 30 meters from the yellow portion or.
But that, my lords, that's not the question, my lords. Whether my lords, the question is, my lord, whether it is from the FTL or the revenue records. But now what has been marked, my lords, is as per the revenue records. We have not taken into consideration.
Therefore,
Buffer ಇರೋದು.
who will pay for this?
But my submission is this, my lord. If under the law he is entitled for him to leave the buffer zone, my lord, he will have to be paid by the competent authority.
Yes.
That's my submission.
ಈ yellow color ಆಯ್ತು, ಬಫರ್ ಝೋನ್ ಬಿಟ್ಬಿಡೋಣ.
My lords.
ಬಫರ್ ಝೋನ್ ಬಿಡೋಣ. ಈ yellow color portion ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ದುಡ್ಡು ಯಾರು ಕೊಡ್ತಾರೆ?
Lord, it is, Lord, Mother Nature, my lords, the water.
Mother Nature did not put up a dam.
Lord, that's the reason.
It is humans who put up a dam.
That's the reason, my lord. In fact, I have been able to find out the documents, whether at all there has been actual grant, because as per the Akar Band, As per the Akar Band, everything, my lords, is my lords Karab land, a Karab land. So if it is a Karab A land which could not have
Now
been
you
used for-
cannot say that. Plan sanction ಮಾಡಿದ್ರಿ, conversion ಮಾಡಿದ್ರಿ, you cannot say a Karab land.
That means, for the time being, my lords, I'm not going to that. For the time being, I'm not going.
Point out, please point out, what is the exact extent of this gray color portion?
For 6 acres, 10 guntas, please, my lord.
6 acres, 10 guntas, including
One,
the road.
three, excluding the road.
Excluding the road, ಅಂದ್ರೆ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? ಲೆಕ್ಕ ಮಾಡ್ರಿ.
ಅಲ್ಲ, road ಬರೋದಲ್ಲ ಸ್ವಾಮಿ, ಅದು road ಅವ್ರದ್ದು ಅಲ್ವೇ ಅಲ್ಲ.
Total extent of 1233 is 10 acres, 11 guntas.
Please, my lord.
Correct?
Please, my lord.
The pink portion is 4 acres, 1 gunta.
Please, my lord.
4 acres, 1 gunta. Yellow color portion is 1 acre, 5 gunta. So it is 5 acres, 5 guntas.
Well, this, including the buffer zone, that yellow, my lords, that land. that
ಹೌದು
is-
ಸರ್. ನಾನು ಅದಕ್ಕೆ ಕೇಳ್ತೀನಿ, ಗ್ರೇ ಪೋರ್ಷನ್ ಎಷ್ಟಿದೆ ಅಂತ.
I'm going to understand.
Yellow portion ನಮ್ಗೆ ಸಿಕ್ಕಿದೆ.
Please, my lord.
1 acre, 5 guntas. The pink portion is 4 acres, 1 gunta.
Please, my lord.
So total is 5 acres, 5 guntas.
Please, my lord.
5 acres, 6 guntas.
Of 3, Roman 3, my lord.
Roman 1, Roman 2
Please, my lord.
is 5 acres, 6 guntas.
Please, my lord.
Correct?
I'll calculate, please, my lord.
ನೋಡಿ ಲೆಕ್ಕ ಮಾಡಿ.
Please, my lord. One ಎಷ್ಟಿದೆ ಹೇಳಿ? One ಎಷ್ಟಿದೆ?
4 acre, 1 gunta.
Okay, 1 is 4 acre.
4 acre.
2.
2 acre, 1 acre.
Total extent is 10 acres, 11 guntas. 1 acre, 1 acre, 5 guntas is yellow portion.
Please, my lord.
4 acres, 1 gunta is pink portion.
Lord, pink one, that's Roman 1, my lord, is
Ah.
4 acres, 0.1 guntas, please, my
Correct.
lord. Lord, 2, but as yellow, my lords, there's submerged land, it's 1 acre, 5 guntas, please, my lord.
ಎಷ್ಟಾಯ್ತು? 5 acres, 6
6
guntas.
guntas, my lords.
Minus that in 10 acres, 11 guntas.
5
It should be 5 acres, 5
ಅದು
guntas.
ಬರುತ್ತೆ ಸ್ವಾಮಿ.
Then 6 acres, 10 guntas ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ನೀವು.
ಇಲ್ಲ, 5 acres, my lords. I'm sorry if I said that. I'm sorry, my lords. Maybe
It's 6 acres.
I'm sorry if I said that, my lord.
Therefore, I want to know whether this gray portion was really measured.
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮಾಡಿದ್ಯಾ?
ಅವ್ರಿದ್ರು. ಅವ್ರು ಕೂಡ ಇದ್ರು. ಬೋಟಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದೀವಿ ಸರ್.
ಇದರಲ್ಲಿ ನಿಮ್ಮ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
But that's not, they have mentioned, my lords, as read in the legend, my lords, the pink one is 4 acres, 1 guntas, please, my lord. And one that's submerged in yellow, my lords, is 1 acres, 5 guntas, my lord. And that's the purple or the gray, my lords, as 3, my lord. Third point, ಈ ಬಣ್ಣದಿಂದ ತೋರಿಸಿದ ಪ್ರದೇಶವು ಸರ್ವೆ ನಂಬರ್ 1, 2, 3 ತರ ಉಳಿದ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. ಈ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ ಯಾವುದೇ ಅಭಿವೃದ್ಧಿ ಕಾರ್ಯಗಳು ಮತ್ತು ಕಟ್ಟಡಗಳು ನಿರ್ಮಾಣ ಆಗಿರೋದಿಲ್ಲ.
ಎಷ್ಟು ಅದು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್?
My lord, that is 3 is 5.05. It's not mentioned here, my lord, but it is 5.05. The remaining portion, my lords.
ಇಲ್ಲಿ ಯಾಕೆ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ?
ಅಂದ್ರೆ they have mentioned the remaining portion ಅಂತ. The remaining portion of that land ಅಂತ ಮಾಡಿದ್ದಾರೆ. My lord, it should have been ideally mentioned, my lords, but the ADLR, my lords, what they thought, my lords, is that it's no dispute that.
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ measurement.
Please, my lord.
What is there to show that this gray portion measures 5 acres, 5 guntas?
The video is, because in fact, Akar Band would give, my lords, the.
ಬಿಡಿ ಸರ್, ನಿಮ್ ಮೆಷರ್ಮೆಂಟ್ ಮಾಡೋದು ಕೊಡಿ ಸರ್.
Measurement ಮಾಡಿ.
5 ಎಕರೆ 6 ಗುಂಟೆ ಅಂತ ತೋರ್ಸೋದಿಕ್ಕೆ ಮೆಷರ್ಮೆಂಟ್ ಏನೋ ಇದ್ರೆ ಕೊಡಿ. 5 ಎಕರೆ 5 ಗುಂಟೆ ಅಂತ. ಬ್ಲೂ ಕಲರ್ ಪೋರ್ಷನ್.
It's in video, my lord, that everything was.
ಮೆಷರ್ಮೆಂಟ್ ವಿಡಿಯೋ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ? ಎಷ್ಟು ಚೈನ್ ಇದೆ, ಎಷ್ಟಿದೆ ಅದೆಲ್ಲ ಮಾಡಿರ್ತಿರಲ್ವ ಲೆಕ್ಕ? ಪ್ಲಾಟಿಂಗ್ ಮಾಡಿರಲ್ವಾ? ಟ್ರಯಾಂಗಲ್, ಕ್ವಾಡ್ರಿಲ್ಯಾಟರಲ್ ಪ್ಲಾಟಿಂಗ್ ಮಾಡಲ್ವಾ? ಹೂ ಇಸ್ ದ ಸರ್ವೇಯರ್ ಹೂ ಡಿಡ್ ಇಟ್? ಸರ್ವೇಯರ್ ಯಾರು?
But 130 produce the printout, please, my lord. I understand, my lord. My lord would like to have a look at the actual measurements, what has been taken, and that.
What is the exact measurement? Whether,
Please, sir.
see, then we can deal with the problem. Whether
Please.
buffer zone ಇವಾಗ ಎಲ್ಲ ಐಡೆಂಟಿಫೈ ಮಾಡಬೇಕು.
And for the first time, the buffer zone is described under the provisions of Karnataka Tank Conservation and Development Authority Act 2014. Where the 30 meters, which is a restriction for prohibition in the tanks, acts prohibited in the tanks. If I may permitted, make any irregular or unauthorized construction, any commercial, recreational or industrial complexes or houses or carry on any industrial activity within 30 meters from the outer boundary of the tank. Outer boundary of the tank, my lord, from where, my lord, buffer zone starts. My lord, the map which is being provided, my learned friend is repeatedly saying, my lord, it is as per the revenue records. It is not the revenue records which show, my lord, the buffer zone. It is the buffer zone which is at from the outer limit of the tank, 30 meters, what they have described under this act should be, my lord, the buffer zone. Now, my lord, what they want to restrict, my lord, the layout was approved way back in the year 1987. This portion of the property is already been earmarked for plots. Roads were formed. Now, my lord, after, my lord, that discussion, my lord, in 2024 January, my lord, there was no water in this part of, my lord, land. That is the reason I have produced, my lord, the photographs also to show that there was no waters, and there are boundary marks bifurcating, my lord, the land, survey number 1233 specifically, my lord, by putting a poles. My lord, those poles were also found during this inquiry.
Conversion order boundaries ನೋಡಿ ಏನಿದೆ?
Please, the order of conversion, my lord,
ಓದಿ.
page number 50. Operating portion at 51. Srimati Anjana Bai, daughter of Venkoba, Vivigiri Road, a resident of Raichur, is hereby permitted to convert the agricultural land bearing survey number 1234, measuring 3 acres 33 guntas, acres 33 guntas of acres of Raichur for non-agriculture commercial use as per the condition laid down by the town planning authority, and the land bearing survey number 1233 measuring 10 acre 11 guntas into non-agriculture for residential purpose, subject to following conditions as noted below. The layout plans of development in survey number 1233-34 of Raichur should be get approval by the town planning authority Raichur. The applicant should utilize the land solely for the purpose only for surrender. These are the conditions which have been incorporated. But thereafter, this layout at
Annexure H ಗೆ ಬನ್ನಿ.
Manad?
Come to annexure H.
Annexure
H.
Please.
Your property abuts the tank.
Manad?
Your property abuts the tank.
How?
So therefore, you cannot now say that your property is away from the tank.
No, we are not saying, Manod, it is away from tank. What we are saying, Manod, this buffer zone, what is being restricted now pursuant to 2014 enactment, Manod, this was not into the water, Manod. That is what I wanted to, Manod, convey my contention before this court. Manod, that after discussion, Manod, on January 2024, they have blocked the outflow of this tank, which has raised the water level. That is the reason, Manod, I have enclosed the copy of the photographs which, Manod, blocks the outflow.
Blocks the outflow ಅಂದ್ರೆ?
Water tank, Manod, ಅದು ನೀರ್ ಏನಿರುತ್ತೆ, that will lead to, Manod, a lake which is, Manod, about, Manod, 3 kilometers away from this.
Excess water, runoff water ಒಂದು exit ಇರುತ್ತೆ.
ಹೌದು, ಆ ಲೆವೆಲ್ ಏನಿದೆ ಅದು ಹೊರಗಡೆ ಹೋಗ್ಬೇಕು. I have produced, Manod, the copy of, Manod, along with the statement of objection to survey report, Manod. May I take lordship to
ಆಯ್ತು, now the fact of the matter is, Ravi,
yes,
fact of the matter is the buffer zone which they have identified is under water.
ಹೌದು.
It is underwater.
Only towards, Manod, the northern area.
Yes, only towards the
not
northern.
Towards, Manod, left and right. ಅದು ಇಲ್ಲ. ಅದನ್ನ ಈಗ
Towards the northern area.
ಹೌದು.
Now, the yellow portion is also underwater. ಸ್ವಲ್ಪ ತಗೊಳ್ಳಿ, let me, something is running in my mind, let me tell you.
Please.
1.05 acres is underwater.
Yes.
We do not know what is the measurement of that road. What is the width of measurement, we do not know. We do not know whether the road is still in use.
Please.
We do not know whether the road is still in use. If the road is not in use, can the government not consider compensating you 1.05 acres, which is the yellow portion, against the road? Whether the road can be appropriate towards that yellow portion. So we do not know what is the measurement of that road. Number one. Number two, question is whether you are entitled for compensation for the buffer area. Idu nan manassal odtare, so that we can put an end to the issue once and for all.
as per my instructions, this road area which they are claiming 37 guntas, that was shifted way back in the year 1972 while formation of Raichur Mantralaya Road, which was a totally new road. It was not in existence road. Your lordship could see-
station.
ಇಲ್ಲ that is a station road towards left hand side. ಅದು station road ಅಂತಾರೆ ಅದರ ಹೆಸರು station road ಅಷ್ಟೇ.
Lost permission.
But it is a Raichur Mantralaya main road.
Lost permission.
And let me
He's
complete
not
my
disputing,
submission.
he's not disputing that there was a road. My lord, my learned is saying.
I'll show.
that Since the Mantralaya road came up, we gave up that land. We ourselves voluntarily swapped the land is what my learned brother is saying.
ಹಾಗಿದ್ರೆ then they
My
have to
submission
acquire.
could not have been done like that, my lords.
ಇಲ್ಲ, let me
Please,
complete
I'm sorry,
my
I'm sorry,
submission,
please.
My lord, what happened, my lord, in the year 1972, since my lord Raichur Mantralaya road was formulated, my lord, the entire extent of my lord approach within the lands, my lord, 1233 and 1234 is 630 feet in length and 100 feet in width. My lord, width of the road, my lord, was 100 feet and 630 feet, my lord, at the length. My lord, they acquired only, my lord, 26 guntas of land in the year 1972. Which comes to, my lord, I have given, my lord, I have prepared, my lord, a detailed calculation, what is the extent, my lord, utilized and
In
what.
1, 2, 3, 4.
My lord,
In 1, 2, 3, 4. Survey number 1, 2, 3, 4.
1, 2, 3, 4 ದಲ್ಲಿ acquire ಮಾಡಿದ್ದಾರೆ 26 ಗುಂಟ ಮಾತ್ರ.
That is for the-
remaining 30 guntas of land which was, my lord, a part of that road which was leading inside, my lord, which is leading to the tank. ಅದು ಒಳಗಡೆ ಹೋಗುತ್ತೆ. ಅದು ಎಲ್ಲೂ ಮುಂದೆ ಎಲ್ಲೂ ಹೋಗೋದಿಲ್ಲ. That portion of land which was never in utilization since 1965, my lord, even as per their own notice, my lord, which is issued to us at the initial stage, ಅದನ್ನ ಇದರಲ್ಲಿ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Therefore, my lord, that 37 guntas is already been utilized by the government for formation of the road. If now, my lord, if they want to form this road also, my lord, I'll go a further step ahead, my lord. Now, my lord, the portion of land which is utilized for formation of road is 63,000 square feet in my land, 1233 and 1234. And portion acquired is only 28,000 or, my lord, 824 square feet. If, my lord, they want to form this road now, again, my lord, they have to again acquire, my lord, 30,000 of, my lord, square feet of land in my property. Admittedly, my lord, there is no either side of the road, it is my property.
Yes.
My lord, now they cannot, my lord, blow hot and cold, my lord, for their convenience. They have not purposely not provided, my lord, the measurement of the road. Which
road is it still in use?
No, he's encroached it. It's not in use as of now. He's encroached it.
Is it in use or not?
As of now, my lords, it is not in use. It's not in use because he has blocked it. He's encroached, and the villagers who were earlier hitherto using that road are now taking the circuitous route.
ಹೋಗುತ್ತಾ road ಅದು?
ಅಲ್ಲಿ ಬೇರೆ ಹಳ್ಳಿಗಳಲ್ಲಿ ಸ್ವಾಮಿ, ನಾನು ತೋರಿಸ್ತೀನಿ ತಮ್ಗೆ. I have got a certified copy.
Then we'll appoint one commissioner, let him go and see.
That was the purpose for, my lord, appointment
go
of,
and
my lord,
see.
allowing
My lord,
them to, my
we
lord,
have
hold
done the
the-
survey. If your lordship, my lord, if it falls in the holy mouth of your lordship that an independent commissioner be appointed, my lords, we have no difficulty.
Let
We'll
the
have
commis-
absolutely no
Yeah,
difficulty.
Contempt ಏನಿದೆ? Who has filed?
Contempt ಹಾಕ್ತಾರೆ ಅಂತ ಅಲ್ಲಲ್ಲ.
ಹಾಕೇ ಇಲ್ಲ.
Who has filed the contempt?
Contempt ಹಾಕಿಲ್ಲ. I'm exposing myself, my lords. Now the direction to pass an order in a time-bound manner, only because it is stayed
Okay,
here
there's
and
no
not in
contempt
contempt.
petition.
No.
ಇನ್ನ ಆಗಿಲ್ಲ. I'm exposing myself is what I'm submitting. And those two orders having attained finality, my lords, ultimately I have to pass the orders is my humble submission.
Yes.
And kindly see what is in challenge me. Annexure Z and Annexure Z1 are two interdepartmental correspondence by virtue of which one says it's actually wrong. I should, my lord, confess, my lord, that Annexure Z is actually wrong because of the order of the Honorable KAT, my lords. There is no cancellation of the conversion order as of now. So both those documents, the petition may be allowed in toto.
Forget it. I will put a quietus to this whole dispute.
But, my lords, may
But we
kindly.
can't, ಇದೆಲ್ಲ ಮುಗಿಯೋದೇ ಕಾಣಲ್ಲ ಇದು.
The point is well taken. The point is well taken. But the only concern, my lord, my learned brother was saying that to suit my convenience, I am doing this, my lord. None of these officers are going to stay there forever. It is the convenience of the general public, which I am bounden duty to protect, that I am doing so. So let an allegation that it is my convenience not be made. But my lord, I bow down. If your lordship, my lord, were to appoint a court commissioner, my lord,
None of the officials will take the risk of giving up a land.
please.
None of the officials will take the risk of giving up this portion of the road. So therefore, they'll hang on. So we have to find a solution for this problem.
Kindly appreciate this, my lord. That road was never his. That road was not granted. The road, my lords, always has been, my lords, the cartwright, even as per the village map. It is his contention, my lords, that I have swapped it. Lord, if at all he's barking up a wrong tree, if at all somebody has
ಸ್ವಾಪ್ ಬಿಟ್ಬಿಡಿ, ನಾನ್ ಕೇಳ್ತಿರೋದು ಈ ಎಲ್ಲೋ ಪೋರ್ಷನ್ ಲ್ಯಾಂಡು ನೀರಲ್ಲಿ ಮುಳುಗಡೆ ಆಗೋಗಿದೆ. ಅದಕ್ಕೆ ಯು ನಾಟ್ ಪೇಡ್ ಎನಿ ಕಾಂಪನ್ಸೇಷನ್. assuming that he has to be compensated and assuming that this road is not in use, why shouldn't the court exercise power to compel you to give up this land portion or use for the road?
My lord, this is, the point is well taken, my lords. My first humble submission is, my lord, that the fact that somebody has encroached, lords, is defiance of law.
What about your encroachment of her land, of his land?
Lord, if at all it is his case that for the Mantralayam road, my lords, government has encroached, let him approach the appropriate authority.
ಗೌರ್ಮೆಂಟ್ ನೀರ್ ಬಂದಿದೆ,
ನಾನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ನಾನ್ ರೋಡ್ ಮಾಡ್ಲಿಲ್ಲ.
ನೀವು ಕಟ್ಟಿರೋ ಡ್ಯಾಮ್ ಇಂದ ನೀರ್ ನಮ್ಮ ಮನೆಗೆ ನುಗ್ಗಿದ್ಯಲ್ಲ.
ಡ್ಯಾಮ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಡ್ಯಾಮ್ ಕಟ್ಟಿಲ್ಲ ಯಾರುವೆ. There is no dam.
ಕೆರೆ
ಕೆರೆ ಮೇಲೆ ಮೊದ್ಲಿಂದಾನೆ ಇತ್ತದು.
ಮೊದ್ಲಿನ ನಿಮ್ ನೀರ್ ನಮ್ಮ ಜಮೀನೊಳಗೆ ಬಂದಿದೆ ರೀ.
My lords, I kindly appreciate, my lords, it is not, my lord, but the water has come today, tomorrow it may not be there, my lords.
ನಿಮ್ಮ ನೀರ್ನ ನೀವು ತಕೊಂಡೋಗಿ.
ನಾನ್ ಬಿಡ್ಲಿಲ್ಲ, ಮಳೆ ಬಂದಿರೋದು ಬಂದಿದ್ರು.
ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತು. ಮಳೆ ಬಂದಿರೋದು ಅವ್ರ ಜಮೀನು ನುಗ್ಗಿದ್ರೆ it is encroachment only.
My lords are aware, my lord, in Bangalore when there is, my lord, rain, even apartments, my lords, go beneath the water, my lords.
That is you're saying something, you're comparing chalk with cheese.
My lords.
ಒಂದು ಕೆರೆ ಇದೆ.
My lord.
This property is assessed to tax revenue.
Please, my lord.
1233, 1234 is assessed to revenue.
Please.
Correct?
Please.
The area of these two survey numbers are identified and incorporated in the village map.
Please.
That is okay?
Please.
Therefore, even if one drop of water enters into this survey number, it will be depriving the user of this land.
My lords.
For which you have to comply with Article 31A. You don't have any other option.
In all humility, may I submit, my lord, once he is the owner of the land, my lords, it would be his responsibility, my lords, to see that the land is worthwhile for the purposes of.
ಅದೇಂಗ್ರೆ ಆಗುತ್ತೆ, ನೀರನ್ನ ನಮ್ಮ ಜಮೀನು ನಿಮ್ಗೆ ಅಷ್ಟು ದೊಡ್ಡ ವಾಟರ್ ಬಾಡಿನ ನಾವು ಕಂಟ್ರೋಲ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. Can I control?
If under the provisions of law, my lords, if under the provisions of law, if I am liable, my lords, even my consent would not be required, I'll have to pay, my lords.
But
my lords,
you're glossing over what you see is as reality. ಕಣ್ಣು ಕಾಣಿಸಿದ್ರು ಕಾಣಿಸ್ತಿರಂಗ್ ನೀವಿರೋದು ಸರ್ಕಾರಿ ನೌಕರರ ಒಂದು ಕ್ವಾಲಿಟಿ. ಕಣ್ಣು ಕಾಣಿಸಿದ್ರು ಕಾಣಿಸ್ದೇ ಓಡಾಡುವಂತ ಒಂದು ಕ್ವಾಲಿಟಿ only government officials can do. The court cannot do it.
Well taken, my point well taken.
ಕೆರೆ ನೀರು height increase ಆಗಿದೆಯೋ, ನೀರು increase ಆಗಿದೆಯೋ, we do not know. This land is now submerged under water. If it's submerged under water, buffer zone ನೀವು ಹೆಂಗ್ ಅಪ್ಲೈ ಮಾಡ್ತೀರಾ?
As of now, it's only as per the revenue records.
Revenue records ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ either you have to treat that portion of land which is underwater as buffer zone, which is not going to serve any purpose. Buffers ಇರೋದೇನು, so that people do not access the water body.
And use it any other purpose other than what is permitted, please, my lord.
ಅದಕ್ಕೆ ಸೀವೇಜ್ ಬಿಡೋದು, ಅದಕ್ಕೆ ಕಸ ತಗೊಂಡೋಗಿ ಹಾಕ್ಬೋ, ಅದನ್ನ ಮಾಡಬಾರ್ದು ಅಂತ ಉದ್ದೇಶದಿಂದ ಬಫರ್ ಕೊಟ್ಟಿರೋದು. Now, if the buffer is underwater, you have to compel him to leave 30 meters from the water edge of the water, which will be further entering into his property.
Please.
If you want to do it, should you pay him compensation?
As far as that, my lords, whether we are liable to pay the compensation for the yellow piece of land and also for the buffer zone, I'll apply myself on this, my lords.
Therefore, I'm asking you, if yellow portion badlo, a road which is not in use, if it could be given to him, and because of the water area which has covered the buffer zone, if you want 30 meters again from the water edge to be treated as a buffer zone, you have to compensate him for the 30 meters.
As of now, we are not intending, my lord. We have drawn the buffer zone not as per the water that is standing in the tank now, please, my lord. So this buffer zone, my lords, the only question would be of the yellow land. So now that, my lords, the yellow land in yellow color.
Pink ನೀರೊಳಗೆ ಇದೆಯಾ ಇಲ್ವೋ ಹೇಳಿ?
ನೀರಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ಅದು ನೀರಲ್ಲಿದೆ. Northern portion ನೀರೊಳಗಿದೆಯಾ?
It is marked, no sir, it is in water, sir. From the lake boundary we have taken.
Whatever that lines are there, my lord, that is in water.
Therefore, The buffer is underwater.
Buffer is underwater, please.
You buffer ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ? Where will you provide the buffer?
ಅಲ್ಲಿವರೆಗೂ ಯೂಸ್ ಮಾಡೋದು ಬೇಡ ಅಂದ್ರೆ whatever my lords, the line that we have drawn ಅಲ್ಲಿವರೆಗೂ.
No, you're bound to provide buffer. You're bound to provide buffer. If you are bound to provide the buffer, because the buffer is already underwater because of an act committed by you.
No, in all humility, it's only an allegation that I am a cause. I am not a cause, my lords.
ನಿಮ್ ನೀರು.
Lord, ನೀರ್ ಇದೆ ಅಂತ it's mother nature, my lord, act of God, my lords.
See, if it was a nadi, I can understand. If it was a river, I can understand. Because river, it will flow wherever it wants. But this is a tank constructed by a human being.
But
So you can't call it an act of nature.
I'm not too sure whether the natural tank, it has been there for times immemorial. So, my lords, I'm not quite able to authoritatively say whether it is, my lords, a human intervention because of which there's a tank, or it was already, my lords, a natural tank. My lords, I'm not able to authoritatively say about that at this point of time. I should confess.
ಅದೆರಡು ನಂಗೆ ಹೇಳಿ.
Please, my lord.
Either you tell or we'll appoint a commissioner. If you want a commissioner to be appointed, we'll appoint a commissioner.
Lords, I'm okay, my lords. Your lordships may kindly, my lords, consider appointing the court commissioner, my lords, with.
I would only request, my lord, under the supervision of the court, my lord.
Supervisor ನಾನು ಬರ್ಬೇಕು.
That there be, my lord, somebody independent, my lord, person or
Some
authority.
you please point out who, if there's any lawyer whom you have confidence, you tell me. ಇಲ್ಲ ನಾನೇ ನನಗೆ ಬಿಟ್ಟರೆ ನಾನೇ ಹೇಳ್ತೀನಿ ಯಾರನ್ನಾದ್ರು.
Please,
We will leave it to my lords.
because it requires some issue is bit complicated because, my lord, which requires, my lord, that
I have no skeletons to hide. So any commissioner at any point of time, I'm open, my lord. I have no difficulty, my lords. Ultimately, public interest, my lords, and the directions of your lordships is what I will have to comply.
Or I'll appoint a survey team.
My lords.
ನೀವು ಹೇಳಿ ಯಾರಿಗೂ. If you want a ADLR, we'll appoint an ADLR.
Now, ADLR ಬೇಡ ಅಂತ ಅವ್ರು ಯಾಕಂದ್ರೆ ADLR ಅಂದ್ರೆ again they'll be subject to. I have no difficulty, but it is.
will commit at 2:30, my lord.
ಆಯ್ತು ಬಂದು ಹೇಳಿ.
Please, please.
ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದೀನಿ ನೀವು ತೊಗೊಂಡ್ರಿ ವಾಪಸ್ ಇನ್ನೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದು ವಾಪಸ್ ತೊಗೊಂಡ್ರಿ ಅವ್ರಿಗೆ ಕೊಡ್ತೀನಿ ನಾ ತಗೊಳ್ಳೇನು ಸರ್ ಇದು ನಾ ತಗೊಳ್ರಿ ಇದು ನಾ ತಗೊಳ್ರಿ ನಮ್ದು ನೀವು ತೊಗೊಂಡ್ರಿ
ಸರ್ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಡೇಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ನಿಮ್ಗೆ ನಾ ಕೊಟ್ಟಿನಿ
35
ಇನ್ನೊಂದು ಸೆಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ.
20
ಸೆಟ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಅಲ್ಲ ನಿಂಬಲ್ಲಿ ಅದು ಎಕ್ಸ್ಟ್ರಾ ಇಲ್ಲೇ ಅದ ರೀ
22
73 ರೀಚ್ ಆಗ್ಬೋದಾ? ಅದೇ 21 ಅದ ಸೂಟ್.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದೆ ಸರ್.
ಏನಾಯ್ತು?
Even at the discretion of the court, but one proposal I would like to make before that matter is referred to. May I take lordship a minute's time by referring to layout map? Not on merits, towards the northern portion, now they are claiming the buffer zone, as well as towards the western portion. Western portion, there is no lake. It is, they have shown, no doubt they have shown the buffer zone as per the survey map. Actually, 10 acre 11 guntas, 40% we have to give up to the benefit of the government, which includes open space, garden, and roads. Garden is situated in between of the layout. If that portion 40% amounts to 4 acres. What we are claiming, suggesting that entire portion what we require to give up to in favor of the government, that could be adjusted towards buffer zone and the portion which has already been submerged in the water. What is left out will be 6.5 acres. If they permit us to utilize that 6.5 acres.
We can't violate the law.
Yes.
If some area has to be reserved for a park, it has to be reserved for a park. You can't say park alluk tagolli, you cannot. Park is, there should be a park, there should be an open space in the layout. That you cannot, that will be too much to ask.
At the discretion of the court, any person could be appointed as the court commissioner.
ನೀವ್ ಹೇಳಿ ಯಾರು ಅಂತ.
Technical knowledge. Somebody with technical knowledge, all that I want to pray for.
ಅಲ್ಲ ಅದಕ್ಕೆ ನೀವ್ ಹೇಳಿ ಯಾರು ಸರ್ವೆ
The ADL or DDL or some other.
ಬೇಡ ಬೇಡ.
They should not say our ADL or district court ಮಾಡ್ತಾರೆ ಅವರು provide ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅನ್ಸೋದು ಬೇಡ ಅಂತ.
Now that we have something in black and blue, black and white rather, about the area which is in water covered areas, water spread area.
That road is clearly encroached. Whosoever will give a report, that road will have to be shown as an encroachment.
But a road ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಅಂತ ನಾನು ಕೇಳ್ತೀನಿ. ಅದಕ್ಕೆ let somebody go and give a report. Road ಎಲ್ಲಿಗೆ
If
ಹೋಗುತ್ತೆ?
they could measure even the portion of road which is utilized in our land also, everything will come out. How much they have utilized and why there was a shifting of this.
You please tell us. No, this obviously cannot be done by a lawyer. ನೀವ್ ಹೇಳಿ ಯಾರು ಅಂತ.
Some DDL or some other district could be.
ಇವಾಗ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ DDLR ಇರ್ತಾರಲ್ವಾ? ಇದು ಮಾಡೋ DDLR
DDLR and DDLR, let him not say that the same district, same DC and it has, so justice should be done and things have been done. So some DDLR of some other district lots of his choice, so that this allegation is not there, because I am very sure that what report I have given, nobody else can give any other report other than this. So let there be no allegation tomorrow that it is not a tailored survey report to suit their convenience. So I would suggest that any.
Yes, can we ask the same DDLR to conduct an inspection and find out?
My lord, if I am permitted to make a suggestion, my lord, under the supervision of my lord, district judge, my lord, Raichur, and let them hold any, my lord.
Well, agdire kelsa. What makes you think the district judge is sitting idle?
Any updates?
Mata? How can you say that?
Ultimately, my lord, even the aim of the petitioner is that he does not want to file a fresh application seeking for the new layout plan.
We will not permit him to do it. Tirga ನಿಮ್ಮ ಹತ್ರ ಬಂದು ತಿರ್ಗಾ ಹೊಡೆದಾಡೋದು ಬೇಡ.
That layout plan, not 2 years validity.
So therefore we will say, ಒಂದು a road, should that be compensated towards that yellow portion? The law, if it is not used for anybody or for any purpose.
This will stop now because of the encroachment.
No, where does it lead? See, if the road leads to nowhere, if it leads into the water, there is no point. ಎರಡು ಸೈಡ್ ಇವರೇ ಇರೋದ್ರಿಂದ ಆ yellow portion ಬದಲು ಇದನ್ನ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ಬೋದು. Number 1. Number 2, for the pink portion which is covered by water, he will have to leave a setback or buffer from the edge of the water, 30 meters.
But in summer, there are no, I pray God that it does rain well, there is no rain. That water levels are now indicated in respect to such a level that may not, there may be no water at all. And for the grace of God, if it rains and rains heavily, the entire land will be inundated, or we're not sure. So taking that as on that day, in fact, my lord, I requested my client from the ADLR to get the report from the Google for the past 5-10 years. And I have my lord the printout.
ನಿಮ್ದು minor irrigation ತರಿಸ್ಬಿಡಿ ಎಷ್ಟು ಫೀಟ್ ಇತ್ತು from the last 10 years or 20 years.
Google Maps ಅಲ್ಲಿ ತೋರಿಸಿ
20 years ಇಂದ ವಾಟರ್ ಲೆವೆಲ್ ಎಷ್ಟಿತ್ತು ಅಂತ ಗೊತ್ತಾದ್ರೆ
Google Maps have taken past 5-10 years. It is seen now the allegation is made that I have worked in such a manner that the water has increased. It is not that it has been happening only yesterday or today, my lord. Ever since 10-15 years, I've got the Google Maps to show that the water level, my lord, is decreasing or receding, not in a very uniform manner, because my lord, Mother Nature does not go according to the written script. So there has been no uniformity, but there has been a difference. So to take that yellow line, my lords, and whether compensation has to be given for that extent of land.
Correct, but ಈಗ ವಾಟರ್ ರಿಸೀಡ್ ಆಯ್ತು ಅಂತ ಇಟ್ಕೊಳ್ಳೋಣ, ಕಡಿಮೆ ಆಯ್ತು ನೀರು, ಅವರೊಂದಷ್ಟು ಲೋಡ್ ಹೊಡೆದ್ಬಿಟ್ಟು ಮಣ್ಣು ಹೊಡೆದ್ಬಿಟ್ಟು ಮಾಡ್ತಾರ, ಆಗುತ್ತಾ?
ಪೂರ್ತಿ ಎಂಟೈರ್ ಟ್ಯಾಂಕಿಂಗ್ ಮಾಡಿದ್ದಾರೆ.
Case pending, criminal case.
ನಾನ್ ಮಾಡಿಲ್ಲ.
So I don't want to make any statement against the petitioner. I'll be wrong. But the fact is that there is a to show that the land.
No, we'll do one thing. We'll appoint Mr. Ambekar.
Please.
And one more DDLR. Ambekar and DDLR. Let both of them go on the. Please come, ಮುಂದೆ ಬನ್ನಿ. ಇದು ಕೊಡಿ, sketch ಕೊಡಿ ಅವರು. That survey that you have done with coloring.
I'll give this.
ಕೊಡಿ. ಅಲ್ಲ, whatever that was given, ನಮ್ದು ಕೊಡ್ರಿ.
Same cup.
See, the issue is this. The petitioner is the owner of some 10 acres, 11 guntas in survey number 1233. 1233. He is the owner of 12 acres, 10 acres, 11 guntas in 1233. He had got a land converted, plan is sanctioned. He did not implement the plan and the land is as it is. In the meanwhile, some portion of the land has come under water. There's a tank adjacent to it. A pink portion ಕಾಣ್ತಿದೆಯಲ್ಲ, ಮೇಲ್ಗಡೆ hatched portion.
Northern.
That has come under water. And the yellow portion is also come under water. ಎಲ್ರಿ ಅದು? ಇಲ್ಲೆಲ್ಲ ಇತ್ತಲ್ಲ. ಬಿಡಿ ಆಯ್ತು. It has come under water. Now the municipal corporation is saying that they have to leave 30 meters setback
From the pink line. Yeah, that is the pink portion. Pink. So because it is under water, the southern portion ಇದೆಯಲ್ಲ, ಈ portion water ಇದೆ.
Please, northern portion.
Northern portion. This is identified as a buffer.
A buffer zone.
Buffer zone.
As per any reports.
The yellow portion is also under water.
Please.
So 133 ಇಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ ಇದೆ, ಮೇಲ್ವರೆಗೂ. Now they are saying that you have to leave buffer from the edge of the water 30 meters ಇಲ್ಲೆಲ್ಲ ಬರುತ್ತೆ.
Please.
ಇದೊಂದು ರೋಡ್ ಇದೆ ನಮ್ದು.
Blue road. Right to
Green color.
Mantralaya.
Green color.
Green.
This road apparently divides this 33 and 34.
Please.
But according to the petitioner, ಈ ರಾಯಚೂರು to Mantralaya road ಇದೆಯಲ್ಲ, ಇದು road portion of this 1233 was used up.
Please.
Or acquired or whatever. He says that ಈ road ಇದೆಯಲ್ಲ ಮೇಲೆ green portion, that was given away to him in lieu of this 26 guntas.
Not, it has been adjusted in main road. ಅಷ್ಟೇ.
ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. So now shifted to know where exactly this road leads, the green portion.
Please.
If it leads nowhere, idea is for the land lost here, yellow, this can be given.
Given in lieu of that last.
In lieu of that, now you can give this.
Please.
And we want to know what is the area of this blue portion or the gray portion. The blue portion is
the gray portion.
Gray portion.
This.
ಅಷ್ಟು ನಮಗೆ what is the area ಅನ್ನೋದು ಬೇಕು.
Please.
So the DDLR has framed this, or surveyed this and fixed the boundaries. And the petitioner doubts, so therefore we said we'll have you along with the DDLR.
My one contention, original contention is, my lord, this road as per village map is, my lord, shifted to in the Raichur Mantralayam.
ಆಯ್ತು, first
road ಅಂತ ನಮ್ದು that is my-
we can't do a reverse engineering and find out whether road illit. That we can't do. ಈ road ಎಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಅಂತ ನೋಡಿ. If the road leads nowhere, then we can give it to him. So ಇಷ್ಟೇ. This is the sum and
And
substance.
this western portion buffer zone ಅವ್ರು ಏನ್ ತೋರಿಸಿದಾರೆ ಅದನ್ನು ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ಲೇಕ್ ಇಲ್ಲ.
Buffer portion ಕೊಡ್ಲೇಬೇಕು.
ಅಲ್ಲ?
ಈ ಕಡೆ ಒಂದು 30 feet ರೋಡ್ ಏನೋ ಇದೆಯಲ್ಲ ನಿಮ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ.
ಅದು ರೋಡ್ ಇದೆ, ಅದು ಬಫರ್ ಝೋನ್ ಆಗಲ್ಲ ಸರ್. That is for our benefit. Only buffer zone is towards the north.
ಬರ್ಕೊಳ್ಳಿ. The survey conducted by the Deputy Director of Land Records is pursuant to the order of this court dated order sheet
1912, my lord.
1912. 1912-24 is perused. Next para. The gray portion, gray/blue, na is gray na?
Gray, bluish gray.
Bluish gray. The bluish gray portion marked as number 3 and 4. Sorry, the measurement of the portion marked in bluish gray and identified as number 3 and Roman number 3 and 4, 5 in the sketch is not forthcoming. Full stop. The road marked in green, light green, and identified as Roman 4 does not show as to where it leads to. Therefore, in order to have clarity on these two aspects of the matter, this court felt it appropriate to appoint a commissioner who shall be with the, who shall appoint a commissioner, team of commissioners, sorry, appoint a team of commissioners to submit a report. Accordingly,
Mr. D.P. Ambekar, who was present in the court, was requested to visit the property along with the DDLR and submit a report as to the measurement of the portion marked as Roman 3 and Roman 5, as well as the area of the road and the place where it leads to.
Area of road abutting,
Huh?
the area of road abutting 1233
Area?
of road. So far as the abuts 1233.
The green anta bardide, light green.
Light green.
Full stop. The survey, the commissioners shall execute the warrant. Yavaga? Nearly yavattunta.
Any date? Sunday.
Day after tomorrow.
Day after.
ಅಷ್ಟು ಬೇಗ ಆಗುತ್ತಾ? ಇಂಟಿಮೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? Next Sunday. Next Sunday? Sunday or Saturday? Next Saturday is working.
Saturday is working.
26th Republic Day. Second, huh? Then, madam, executed on 2nd of February 2025 at 11 a.m. Full stop. It is open, huh? It is open for the petitioners and the respondents to be present at the spot and assist the commissioners in executing the warrant. The commissioner's fee is tentatively fixed at. Really?
Discretion of the.
If you leave it to me, it will be.
Commissioner fees.
50,000. Full stop. 50,000 which shall be paid at the spot. Which shall be paid at the spot. Issue appropriate intimation to the Deputy Director of Land Records. Raichur, huh? Raichur. List on Yavatigi. When should it be listed? 11th. DDLR ಇದಾರೆ ಇಲ್ಲಿ? ಎಲ್ಲಿದ್ದಾರೆ?
That office is merged with Deputy Commissioner's office.
ಯಾರು ಇರೋದು ಇಲ್ಲಿ ಆಫೀಸ್? ಸರ್ವೆ ಆಫೀಸ್ ಇಂದ ಯಾರು? ADLR ನೀವು? ಏನ್ ನಿಮ್ಮ ಹೆಸರು? Mr. Bhimraju Havaldar, ADLR, who is present in the court, has undertaken to inform the DDLR about the order passed by this court. Yes. Yeah? ಅವರೇ ನಿಮ್ದೇ ನಿಮ್ಮ ಕೈಲಿ ಏನು ನೀವೇನು ಕೊಡಕ್ಕಾಗಲ್ವಲ್ಲ?
ಒಂದಿರ್ಲಿ ಕಾಪಿ ಜೆರಾಕ್ಸ್
We'll do it. ಇವತ್ತೇ ಆಗುತ್ತೆ.
If that is also considered buffer zone portion, what should happen?
Huh?
Buffer zone, what is utilized? Adraದ್ದು ಏನಾಗಬೇಕು?
ಬರ್ಲಿ ನೋಡೋಣ, ಸ್ವಲ್ಪ ಕ್ಲಾರಿಟಿ ಇರ್ಬೇಕು ಅಷ್ಟೇ, ಇನ್ನೇನು. Yes, Krishna Swami.
My lord, I appeal for petition, my lord. My lord, on 20th December 2024, one memo was filed seeking to dispense with the notice to the respondent number 2 to 4 instead of 1 to 3. My lord, a fresh memo is filed to dispense notice to respondent 1 to 3, my lord.
You want notice to go to respondent number 4?
Yes.
Huh?
Yes, my lord.
Mercoli. The learned counsel for the petitioner submits that he had mistakenly filed a memo seeking dispensation notice to respondents 2 to 4. However, he has filed a memo now seeking dispensation notice to respondent number 1 to 3
Please, ma'am, please.
Stop. The memo is taken on record. In view of the above, the order dated 2012-2024 passed by this court shall not be given effect to. The notice to the respondents 1 to 3 is dispensed. Issue emergent notice to the respondent number 4.
Please.
Counsel for the petitioner is directed to pay the process.
Please.
to issue
Process
notice
is paid, my lord.
Huh?
Process is paid, my lord. I have taken the steps.
I didn't get you. Come again.
My lord, process is paid, my lord.
Then-
To issue notice to respondent number 4.
Good. Next. Brijesh Patil.
Interim order.
Interim order. Next date ತನಕ ಇದೆಯೇನ್ರಿ interim order? ಆ ಥರ ಏನಿಲ್ವಲ್ಲ. There's no interim order granted on 2012-2024 is extended till the next date. ಆ ಥರ ಏನಿಲ್ಲ ಅಂತ till the next date. ಇಲ್ವಲ್ಲ. Yes, next.
Watch out, watch out.
Brijesh Patil.
For respondent in this case, my lord, in view of the order passed by my lord, the amount has already been released, my lord. Therefore, this IA does not survive, my lord.
Yeah, the learned counsel for the respondent submits that IA 1 of 23 does not survive for consideration. The submission is noted and IA 1 of 23 is rejected. Yes.
Much obliged, my lord.
Prabhakar L. Shetty. Prabhakara L. Shetty. ಏನಿದು? IA 1 of 24 for revival. Prabhakara L. Shetty. Yes, who appears for the petitioner? Chit Anand Shetty. There's no representation for the petitioner and the respondent. It's on date. Rajeshwar.
My lord, I appear for the petition, my lord. My lord, I have received a full and final settlement of rupees 70 lakhs, my lord, by way of DD. The memo for that effect has been filed by my learned friend respondent, who is also present along with me, my lord. My lord,
as per my lord, compromise petition, my lord, in its entirety, the amount has been paid to the petitioner.
ಏನೋ details ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರಲ್ಲ ಅದು.
Details along with memo, I have already filed the memo, my lord, with getting the signature of the respondent as well as the petitioner. And yesterday, my lord, it has been filed.
Yes, any objection? Narayan.
No objections, my lord. My lord, it will be credited in another 2-3 days, within 5 days. My lord, the FDP will be withdrawn by my lord within a period of 1 week from today, my lord.
It may be treated, my lord, as a decree, my lord.
Right. This petition was disposed of on 27/11/2024 in terms of a
Joint memo.
as per the joint memo filed by the parties. Full stop. As per the order and the joint memo, the respondent in WP number
6084.
084 of 2024 was bound to pay, had agreed to pay rupees 70 lakhs towards full and final settlement of all claims of the petitioner in WP number 6084 of 2024. Today, a memo is filed stating that the respondents have paid the entire sum of rupees 70 lakhs. 75,
70
lakhs.
ಅದು ಫಸ್ಟ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 17.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ. ಇವಾಗ ಬ್ಯಾಲೆನ್ಸ್ ಕಾಂಪ್ರಮೈಸ್ಡ್ ಅಮೌಂಟ್ 52 lakhs 50,000 has been paid by way of 3 demand drafts.
ಬಟ್ ಇದನ್ನ 75 ಲಕ್ಷ ಅಂತ ಹಾಕಿದ್ರ ಮೆಮೋನಲ್ಲಿ
75% ಅದು
75 lakhs is paid ಅಂತ ಬರ್ತಿದ್ರಪ್ಪ ಮೆಮೋನಲ್ಲಿ. ಮೆಮೋನಲ್ಲಿ 75 lakhs is paid ಅಂತ ಬರ್ತಿದ್ರು.
70 lakhs on 13/1/2025 ಅಂತ ಇದೆ.
ಇದೇನ್ ಮೆಮೋ 19/11/24 ಅದೇನಾ?
ಹಾ ಅಲ್ಲ ಅದಲ್ಲ
No, my lord.
ಅದಲ್ಲ ಮೇಡಮ್ my lord.
15th January 25, my lord.
ಅದು
filed, my lord.
ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿರೋದು ಸರ್.
15 January 25 ಇಲ್ವಲ್ಲ ಮೆಮೋ ಇಲ್ಲಿ.
ನೆನ್ನೆ ಫೈಲ್ ಮಾಡಿರೋದು, ಅದು ಮೋಸ್ಟ್ಲಿ ಫ್ಯಾಕ್ಸ್ ಮಾಡಿ ಕಳಿಸಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ.
Has filed a memo stating that a sum of rupees 70 lakhs.
My lord, balance amount of 52 lakhs 50,000, my lord, has been.
Total amount ಎಷ್ಟ್ರಿ ಬರ್ಬೇಕು ನಿಮ್ಗೆ?
70 lakhs, my lord.
ಹೇಳ್ತಿರೋದು ನಾನು.
Please, I'm sorry.
Entire sum of rupees 70 lakhs as agreed is paid. So in that way of the matter, no further orders are required to be passed in this petition.
Let trial court be directed to my lord pass the final decree, my lord, in terms of the joint memo, my lord, forthwith, my lord.
It is needless to mention that the trial court shall pass appropriate orders in the light of the order dated so and so passed by this court. Yes. Subramanya Bhatt.
I pay for the respondent, man.
I'll keep it on some other day.
Yes, man.
Very well.
On date for the author. Sorry, next. 24th January.
Yes, man.
Manjunath V. Rayappa.
Petitioner, my lord. I appear for petitioner, my lord. The present petition filed the Annexure G, my lord, challenged, my lord. You have filed the application under section 33-34 of Stamp Act, my lord.
Annexure G, na?
Annexure G, my lord.
Page?
Page 37, my lord. Trial court rejected my application, my lord.
Yen Stamp Act ಅಲ್ಲಿ ಏನು ಹಾಕಿದ್ರಿ?
My lord, this receipts, my lord, without franking, my lord, there is a 10 lakhs and 20 lakhs, 30 lakhs receipt, my lord.
What is
Sale
exhibit?
consideration receipt they are mentioning, my lord.
Where is exhibit P1? P1 ಎಲ್ಲಿದೆ? Where is P1?
My colleague Bhimrai in the court, my lord. That is the exhibit P1, my lord.
P1 ಏನಿದೆ? ಎಷ್ಟನೇ ಇಸ್ವಿ P1?
Sale agreement, my lord.
ಭೀಮರಾಯ ಪೇಜ್ ನಂಬರ್ 3 ಪೇಜ್ ನಂಬರ್ 2 ಆದ್ಮೇಲೆ ಬರುತ್ತಾ ಒಂದಾದ್ಮೇಲೆ ಬರುತ್ತಾ? ಕೊಡ್ರಿ ಇದವ್ರಿಗೆ ಸರಿಗೆ ಹಾಕೊಡಕ್ಕೆ. ನೋಡ್ರಿ ಸ್ವಲ್ಪ. ಏನ್ ನೋಡಂಗೆ ಇಲ್ಲ ಏನು?
ತೆಗಿರಿ ಫಸ್ಟ್ ಪೇಜ್ ಆ ಕಡೆ ಹಾಕ್ರಿ.
ಈ ಕಡೆ ಬರ್ಬೇಕು. ಇದು ಫಸ್ಟ್ ಪೇಜ್ ಇಲ್ಲಿ ಬರೀ.
ಕೊಡ್ರಿ ಆಮೇಲೆ ರಿಪೇರಿ ಮಾಡ್ಕೊಡಿ ಆಮೇಲೆ. ಇದೆಷ್ಟು 2006 1st November. ಇದ್ರಲ್ಲಿ ಏನಿದು ವಾಟ್ ಇಸ್ ದ ಟೋಟಲ್ ಕನ್ಸಿಡರೇಷನ್? 80 ಲಕ್ಷ.
18 lakhs, my lord. 80 lakhs, my lord. Firstly, they are mentioning 40 lakhs, my lord. On the bond paper, my lord. 200 stamp paper, 40 lakhs. In white sheet receipts, my lord, 20 lakhs, one receipt, and 10 lakhs another receipt, my lord. That is the exhibit annexure C and D, my lord.
Position is given.
No, my lord.
ಮತ್ತೆ 20,000.
My lord.
200 rupees ಹೆಂಗಾಗುತ್ತೆ? 200
Trial court not applied the.
ನೋಡಿ ಯಾವಾಗಿಂದ ನೋಡಿ 2006 ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? 2006, 2007 ಸ್ಟಾಂಪ್ ಆಕ್ಟ್ ತರಿಸ್ರಿ. 2006 ಅಥವಾ 2007 ಸ್ಟಾಂಪ್ ಆಕ್ಟ್ ತರಿಸ್ರಿ. ನೋಡಿ ಸರ್, ನಿಮ್ಮ ಹತ್ರ ಏನಿದೆ ನೋಡಿ. ಎಸ್ ರಾಯಪ್ಪ, ಎಷ್ಟಿತ್ತು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ? 95. ಎಷ್ಟಿತ್ತು ರಾಯಪ್ಪ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ? ರಾಯಪ್ಪ,
The tact also I don't have, my lord.
ಏನ್ರಿ ಏನ್ ಹಿಂಗ್ ಮಾತಾಡ್ತೀರಿ ನೀವು? .01% ಯಾವಾಗಿಂದ ಆಗಿದ್ರಿ? What kind of argument you are making, mister? ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಳ್ತಿದ್ರಿ ಇನ್ಸಫಿಷಿಯಂಟ್ ಸ್ಟಾಂಪ್ ಅಂತ?
One seek on accommodation, my lord. I will get it ready.
ಅಲ್ಲ, I'll accommodate you, but you pay cost.
1,000
not the way high ಪ್ರಿನ್ಸಿಪಲ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿರುವಂತ ಲಾಯರ್ ಈ ತರ ಅಪಿಯರ್ ಆದ್ರೆ ಹಿಂಗೆ?
Some
And
inconvenience.
that too, you are a government advocate.
Please, my lord. Morning.
Is this the way you come prepared to the court in your personal matter?
Sorry, my lord.
No.
25th.
Private?
25th, kindly have it, my lord.
No. I'll adjourn, but you pay cost.
Please, my lord. I will pay the cost.
ಎಷ್ಟು ಹೇಳಿ? 2,000 rupees you please pay to the registry.
Please, my lord.
The learned counsel for the petitioner seeks time. Since the suit is filed in the year 2012, the request for adjournment is 2012 and the matter is stayed before this court, the request for adjournment is not justified. However, as a last chance, list on next Friday,
25th.
subject to payment of cost of rupees 2,000 payable to the High Court Registry.
Library fund.
2006 ಅಲ್ಲಿ ಇರ್ಲಿಲ್ವಲ್ಲ ಅದು? Article 5 ನೋಡ್ಬೇಕು. Article 5. ರಿಸೀಟ್ ಮೇಲೆ ಬರಲ್ಲ ಬಿಡಿ. ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ದಿ
Trial court has referred to that aspect also in the order.
No, unfortunately, you also do not bring a book 2006 ತರಲ್ಲ ನೀವುನು.
But ಇದರಲ್ಲಿ amended.
95ನೇ ಇಸ್ವಿಲಿ 2006ನೇ ಇಸ್ವಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಹೆಂಗ್ ಬರುತ್ತೆ? So you are also bound to get a 2006 Act. Stamp Act ವರ್ಷ ಚೇಂಜ್ ಆಗುತ್ತಿದೆ. Yes.
Lord, I'm sorry for intervening, Lord, in my.
Yes, Subramani, interim order is extended, yes.
Grateful to Lord.
Yes. K. Ramachandra ಕಟ್ಟಿದಾರಾ?
Kindly grant week's time, my lord.
Huh?
Kindly grant week's time.
ಬೆಳಿಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ.
No, file misplaced, my lord, in the office. Kindly.
ಶೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿದು?
File misplaced, my lord, kindly.
16.
Have it next week and permitted to get Xerox from the court file, my lord, actually.
ಇವಾಗಲೇ ತಗೊಳ್ರಿ. ಈಗ ತಗೊಳ್ಳಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದಂಕ ಯಾಕೆ ಆಯ್ತಾರೆ? ತಗೊಳ್ಳಿ ಇವಾಗಲೇ. Don't wait till next week.
I'll get it Xerox, my lord. So kindly have it Monday or Tuesday. Monday.
Learned counsel for the petition seeks time. List on. ಜೆರಾಕ್ಸ್ ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ, ಫೋಟೋ ತಕೊಳ್ಳಿ. ಮೊಬೈಲ್ ಅಲ್ಲಿ ಫೋಟೋ ತಕೊಳ್ಳಿ.
Please.
No Xerox, will not leave the file outside.
Please.
For the petitioner in this case, my lord, senior instructed that he will come and argue the matter. So kindly short any date, my lord, because due to some personal inconvenience, due to some medical emergency, he went to Bangalore.
Learned counsel for the petition seeks time. List on.
Grateful. My interim order is there.
I spoke so high about your senior, but senior doesn't want to give you the liberty.
No, he has given liberty, madam. Almost all the cases I am arguing the matter, madam. This is the one case because he
Can't help it, Mr. Yes, next.
interim order is there, madam.
Interim order is extended to the next.
Grateful.
And you also don't want to make attempt.
No, madam. Already.
ಓದಿದ್ದೀರಾ ಫೈಲು?
ಓದಿದ್ದೀನಿ, madam.
ಓದಿದಿರಿ? ಕೊಡಿ ನೋಡೋಣ ಹೆಂಗ್ ಓದಿದಿರಿ.
Already taken the citation also, madam.
ಆಯ್ತು, ಓದಿದಿರಿ, ಹೆಂಗ್ ಓದಿದ್ರಿ ನೋಡೋಣ ಕೊಡಿ. Yes. You're a tenant.
Yes, my lord. I am the
So
tenant.
admit the tenancy.
My lord, yes, my lord.
Correct.
Yes, madam.
What is that you want to plead now in your written
My
statement?
lord, in the written statement, my lord, I have pleaded that in the year I have built the school, my lord. In that school, I have constructed nursing college also. So there was a compromise between the two parties, my lord. So it was ended like almost 4 crores was settled. So again, they have come and they said that it was not, no, we are not ready to compromise.
Now you please read the amendment sought for. ಓದಿ. Page number 37.
55, madam.
37 ಅಲ್ವಾ? 6 rule 17.
I'm sorry. May I read, madam? A deed dated 3/6/2003, which is produced by the plaintiff, is created document and is a fraud and a Janata trust, and also on the defendants and also general public and also on the court. The plaintiff in his plaint did not state about in what manner they are representing the suit. They simply state that they are the trustees of the plaintiff trust. Sole trustee of the trust is one Kallur Mallappa, who created and got appointed as a new trustee to the said trust under the trust deed dated 27/2/2002, and one Kariyappa being appointed as a managing trustee. The deed that the plaintiff claiming right as a managing trustee is totally fraud and created one. The plaintiff who filed the suit is not recognized by law, and the trustee dated 3/6/2003, which is also not produced, is created document and is fraud on the trust and also on the defendants. So also the general public and also on the court. The Mallappa Kallur, who was the sole trustee, created a deed named as appointed of the new trustee of Janata Trust on the retirement of his sole trustee. His exercise of power of appointment created and retirement deed on 27/2/2002, which is registered in the office of Registrar Bangalore. The second registered deed is dated so and so, created by the same Kallur Mallappa,
who has no power to create deed, as he is no authority nor is a trustee of the Janata Trust. The trustee deed created on so and so is fraud document and no right are being passed under the deed, which once the sole trustee Kallur Mallappa by retiring himself and inducting 7 trustee into trust by retirement deed dated 27/3/2002 and appointing one Karyappa as a managing trustee is no more a sole trustee. He has no recognition under law to represent once again a sole trustee. The sole trustee got himself retired from the trustee on so and so. He has no authority to retire once again and create a new trustee dated 3/7/2003 and appointing Prabhakar, son of Chikkegowda, as a managing trustee, totally illegal act and opposed to the law. The Kallur Mallappa, who is retired by deed so and so, and he has no locus standi to create one more retirement deed and appointing new trustee and also appointing Prabhakar C as a managing trustee, is totally illegal and opposed to the law. Is liable to be declared by the court that the trust deed dated so and so is illegal and is a fraud created to the public, also to the defendant, also on the court. This fact is suppressed by the plaintiff and not pleading this fact, intending to take the property by illegal menace by following false suit. The filing of the suit by Prabhakar C, posing or designating himself as a managing trustee itself is a fraud played upon the court and also on the public. It is a public trust. The suit filed of the present plaintiff is not maintainable as they have no locus standi to file the suit or to create the lease deed of the properties of the trust. After the death of Prabhakar C, who filed the present suit, is died during the pendency of the suit, and the suit being continued by Rupesh P, by be reconstituted trustee on 1/7/2021 is also void document and no recognition under law is also a void document. The present plaintiff Rupesh P, son of late Prabhakar C, designated himself as a managing trustee, filed his chief examination affidavit as he being appointed as a managing trustee is also opposed to law. The plaintiff are under the impression that the trust is a private trust of their family. They can act as deemed fit is totally wrong concept. On going through the original trustee, the trust is created for the public purpose and its all income will go to the trust and not to the trustees. The original trustee is read over in the public trust and the beneficiaries are the general public. The act of the plaintiff is questionable under law. Till today, they do not keep any account nor the trustee is audited by the auditor. The act of the plaintiff filing the suit is tainted and malified and fraudulent and full of illegality is liable to be determined by this court. And the suit is to be dismissed as plaintiff have no right to file the suit. For the continuation of the suit, a reconstituted trustee dated so and so void number in the office of the sub-register Malleshwaram, Bangalore is also void document have no force under law. The Rupesh P, who filed his chief examination affidavit, is also not having any right under law to continue the suit as the document produced is void document.
So I'm not trying to ridicule you. निम्ना नीचे दिखा के मेरे को कुछ नहीं आता. Have you read the application? You're reading it for the first time now. ನೀವೇನ್ ಹೇಳಿದ್ರಿ 4 ಕೋಟಿ ಕೊಡ್ತೀನಿ, ಅಗ್ರಿಮೆಂಟ್ ಆಯ್ತು, ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು, ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದೀನಿ, ಅದೆಲ್ಲ ಇದೆಯಾ ಇದ್ರಲ್ಲಿ?
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕಂಪೌಂಡ್
ಇದ್ರಲ್ಲಿ ಇದೆಯೇನ್ರಿ ಅಪ್ಲಿಕೇಶನ್?
ಅದ್ರೊಳಗಿಲ್ಲ. ಇದ್ರೊಳಗೆ ಓರಲ್ ಸೆಟಲ್ಮೆಂಟ್
ಈ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ.
ಕರೆಕ್ಟ್.
ಅಪ್ಲಿಕೇಶನ್ ಇರೋದೇನು? ಅವ್ರವ್ರು ಕಚ್ಚಾಡ್ತಾ ಇದಾರೆ. ಟ್ರಸ್ಟೀಸ್ ದೇ ಆರ್ ಫೈಟಿಂಗ್ ನಾನ್ ಟ್ರಸ್ಟಿ ಅಂತಿದೆ. ಅದನ್ನೆಲ್ಲಾನು ಯು ವಾಂಟ್ ಟು ಇನ್ಕ್ಲೂಡ್ ಇನ್ ಯರ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಯು ಆರ್ ಓನ್ಲಿ ಎ ಟೆನೆಂಟ್. Correct.
Yes,
how will this help you in establishing that you can't be evicted?
Kallur Mallappa, my lord, he was the original trustee, my lord. At that time, my lord, that 30 years lease has been given to me.
My dear friend, eviction ಆದ್ರೆ ಟ್ರಸ್ಟ್ ಹೋಗುತ್ತೆ ಪ್ರಾಪರ್ಟಿ. ಕೊಲ್ಲಪ್ಪಂಗ್ ಹೋಗಲ್ಲ, ನಾರಾಯಣಪ್ಪಂಗ್ ಹೋಗಲ್ಲ, ಕರಿಯಪ್ಪಂಗ್ ಹೋಗಲ್ಲ. It goes to the trust. Trustees can fight amongst themselves. Non-trustee, ನೀನ್-trustee, ಅವನ್-trustee, ಅವನಲ್ಲ, ಇವನಲ್ಲ. They can fight. So far as you are concerned, you are a trustee.
Only a tenant.
Tenant under the trust. Trust is a plaintiff. Who drives the trust? You are not bothered. You are not bothered as to who drives the trust. So whether these averments in the written statement are necessary.
My lord, it is necessary.
So please come to the court prepared. Don't come to the court with closed eyes. ರೆಡಿಯಾಗಿ ಬಂದಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತೀರಾ, ಏನೋ ಇದೆ ಏನೋ ಹೇಳ್ತಿದ್ದೀರಾ.
It was a oral settlement, my lord.
So is that the subject matter of the amendment application?
No, it's not.
Then
That's why interim order was granted, my lord. I was about to tell that one, my lord.
The petition is listed for hearing on merits.
Right.
And you are all youngsters, mister. You're all youngsters. You should burn the midnight oil to read at least file. File ಓದಿ. ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋ ಬಿಡ್ತಾರೆ, ಹಾಳಾಗೋಗ್ಲಿ. File ಓದಿ. I don't know why lawyers should be told to read the file. Lawyers should be told to read the file. Yes. List on.
The defendant, my lord, on merits only. The defendant before the trial court, my lord, is the appellant herein.
Suit is for?
Suit is for declaration injunction filed by the respondent herein. The petitioner and respondent are brothers. The case of the respondent before the trial court was that the properties belong to the father of the parties, and the father of the parties has executed a registered gift deed regarding the said properties in favor of the respondent plaintiff. Thereafter, my lord, because the alleged interference of the petitioner or defendant, he was constrained to file the suit for injunction. In that, my lord, I have contested on the ground that father, my lord, was in no position to execute the gift deed. He used to sign everywhere. However, due to advanced age, he was bedridden. The sub-registrar had come to the home and taken the signature. And in fact, he has put his LTM, not in his signature. Therefore, he was in no condition. This is my case. In the suit, my lords, there was an order of status quo till disposal of the suit. Therefore, my lord, everything was peaceful till the disposal of the suit. Kindly may I take page 53, my lords. There was an order of status quo. Actually, 39(1) and 2 was prayed by the plaintiff. The same was modified and so parties were directed to maintain status quo till disposal of the suit. The suit, my lord, it came to be dismissed via the judgment and decree dated 28/2024. Even before we could prefer an appeal within 1 month, the plaintiff, my lord, he obtained a demolition order. Suit properties is a house property and a landed property. And he demolished the house, ancestral house, by obtaining within 1 month. From the corporation, he obtained an order. And before we could even file an appeal and take this thing, he had put a caveat also. Before that, he demolished the entire house. So also, my lord, he started destroying the crops and everything. So that is the case. Therefore, my lord, I was concerned to file an application along with the appeal to stay the impugned judgment and decree of the trial court till disposal of the appeal. The first appellate court, my lord, instead of just staying the impugned judgment and decree, he has passed an order directing the respondent not to alienate the properties for 6 months. My contention is this will not take anybody's case any further. In fact,
no, the building is gone.
Pardon, my lord?
The building is gone.
Building is gone. There is another building in the farm. From there also he is trying to interfere.
You are in possession of that.
Yes, my lord. My contention is
Status quo be maintained.
till disposal there was a status quo.
Now, my lord, he is the adjacent landowner with respect to agriculture land. His wife and his children have purchased the agriculture adjacent to this property of the respondent. Now they are trying to, my lord, disturb and dispose on the basis of.
One building ಹೊಡೆದಾಕಿದ್ದೀರಾ? One building is
Building is, my lord, it is dilapidated.
House property.
Now it is gone. It is raised to the ground. It is demolished to the ground.
As of today, my lord, there is no.
It is leveled. Is there one more building in the suit property?
Farm. In the land, agriculture land, there is one.
The agriculture land, suit property,
There was one house property, one agriculture land property.
Agriculture land building idea.
One building is there. There, it is there. That also is trying to now demolish. It is Alienate is out.
He says that he will not demolish that building.
Please. And so far as crops also, my lord, we have.
Crops ಬಗ್ಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ.
And my submission, respectful submission is matter is posted for final argument on 7/2. On that we will commence the arguments. Trial court can dispose of. Till then, let there be a stay.
Good.
And
No, we'll record his undertaking that he will not demolish the building which is existing in the agricultural land.
may I take instruction, madam? Party.
Dole. Helpful.
The crop they are disturbing, that is the whole purpose of filing the not. Next thing, 20 days of harvesting ಬರುತ್ತೆ.
ಏನ್ ಬೆಳೆದಿದ್ದೀರಿ ಇಲ್ಲಿ? What is raised in the land?
ತೊಗರಿ, ಅರ್ಧ ತೊಗರಿ ಇದೆ, ಅರ್ಧ ಕಡ್ಲೆ ಇದೆ.
ತೊಗರಿ ಎಲ್ಲ ಹೋಯ್ತಲ್ವಾ?
Half of this region ಅಲ್ಲಿ ಅರ್ಧ already ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಆಗಿರುತ್ತೆ.
ತೊಗರಿ ಸೀಸನ್ ಮುಗಿದೋಯ್ತು ನನಗೆ ಗೊತ್ತಿರೋ ಹಂಗೆ ಕಲಬುರಗಿನಲ್ಲಿ.
ಒಂದ್ ಡಿಲೇ ಆಗಿದೆ. ಹಾಫ್ ಏನ್ ತೊಗರಿ ಬೆಳೆಗಳಿದ್ದಾವೆ ಅವೆಲ್ಲ ಡಿಸೆಂಬರ್ ಅಲ್ಲೇ ಹಾರ್ವೆಸ್ಟ್ ಆಗಿದೆ. ಇನ್ನೊಂದು ಅರ್ಧ ಈಗ ಜನವರಿ ಎಂಡ್ ಅಲ್ಲಿ ಹಾರ್ವೆಸ್ಟ್.
ಕಡ್ಲಿ ಇದೆ ಅಂತೆ. ಕಡ್ಲಿ
ಅಥವಾ ಕಡಲೆ ಇದೆ.
ಕಡ್ಲಿ ಯಾವ ಗ್ರಾಮ್ ಅಂತೀರಿ?
ಏನ್ ಕಟ್ರಿ?
ಅದು green gram. Horse gram. Horse gram is still there, crop. And there is a house there. They are living there now because he has demolished the ancestral house. They are living in the house at the farm. That also is now threatening to demolish. And the
dilated building where nobody is residing.
The appellant in RA 121 of 2024 on the file of first additional district judge Kalaburagi has filed this petition challenging an order dated 5/12/2024 by which the trial court directed the respondent herein not to alienate the suit properties for a period of 6 months. Next para. The respondent filed OS number 39/21 for declaration of his title to the suit properties and for perpetual injunction to restrain the appellant herein from interfering with his possession. The suit properties were house bearing number 2-281 situated at Jagat Kalaburagi, comprised of ground floor and first floor, and survey number 9 situated at Naduvinahalli, Kalaburagi Taluk and District, measuring 6 acres 17 guntas. The respondent claimed that the suit properties were gifted to him by his father on
in 2008,
on 22/9/2007. Full stop. Though the suit was contested by the appellant herein, denying that such a gift deed was not executed, the suit was decreed on 20th of August 2024. The petitioner herein filed RA 121/2024, along with which he also filed an application under Order 41 Rule 5 of CPC for stay of the enforcement of the decree. Enforcement and operation of the judgment and decree passed in OS number 39/2021. Full stop. The appellate court, after considering the contentions of the appellant, petitioner and the respondent, disposed of the application directing the respondent not to alienate the suit properties for a period of 6 months from the date of the order. Being agreed by the same, the appellant is before this court. Next part, the learned counsel for the petitioner submitted that the respondent after the respondent took law into his hands and demolished the construction that existed on the property bearing number 2-281 and is now attempting to demolish a house that exists on land bearing survey number 9 of Naduvinahalli. He therefore submits that the appellate court ought to have stayed the operation and execution of the judgment and decree passed by the trial court. He further contends that the first appellate court being the last court of fact, or last court which would appreciate evidence as well as questions of fact, must have stayed the judgment and decree of the trial court. Full stop. In response, the learned counsel for the respondent submits that admits that the building that was existing on the property bearing 2-281 at Jagat Kalaburagi was demolished. He submits that the respondent is in possession of the agriculture land and is also in possession of the house which exists thereon. He, however, undertakes that he would not demolish the house that exists on survey number 9 of Naduvinahalli. Full stop. Next para.
Or we'll change the mutation. He is still standing in name of the father.
Bande.
Father has.
ಏನಾಯ್ತು? Naduvinahalli. Full stop. Next para. Having regard to the contentions urged by the learned counsel for the petitioner and the learned counsel for the respondent, and also having regard to the impugned order passed by the appellate court restraining the respondent from alienating the suit properties for a period of 6 months, and taking into account the submission made by the learned counsel for the respondent that he would not demolish the construction which exists on survey number 9 of Naduvinahalli, this writ petition deserves to be disposed of on the following terms. The order dated 5th December 2024, passed by the First Additional District and Sessions Judge Kalaburagi in RA 121 of 2024 on IA number 1, is modified, directing the respondent not to demolish the construction that exists on the property bearing survey number 9 of Naduvinahalli, Kalaburagi Taluk and District till the disposal of the appeal before the appellate court. He shall also not alienate, encumber, or part with possession of the suit properties till the disposal of the appeal before the appellate court. Anything else?
And mutation is still in name of the father of the parties. That may be maintained till disposal of. Decree agಬೇಕಲ್ಲ.
Any revenue entry, any revenue entry made in the name of the respondent pursuant to the judgment passed by the trial court shall be subject to the appeal. Subject to the outcome of
the harvesting of the crop shall not be disturbed by them.
Shall be subject to the outcome of the appeal before the first appellate court. Full stop. I will leave it at that. You got a judgment of.
Already criminal matter along with my objection.
Judgment ಇದೆಯಲ್ಲ ನಿಮ್ಮ ಕೈಲಿ injunction ದು.
Land owners ಅವರಿದ್ದಾರೆ.
Don't disturb.
ಅಲ್ಲ ಇನ್ನೊಂದು one submission.
Don't disturb the.
ಇಲ್ಲ ಅಲ್ಲ one submission.
ಆಯ್ತು. ಅವ್ರಿಗೂ ಮಾತಾಡಿ ಬಿಡಿ.
One submission. The landed property, my lord, it is still standing in name of the father of the parties. So ಇವ್ರದ್ದು ಬೇಡ ಅವ್ರದ್ದು ಬೇಡ. Let it continue till. ಆರೇ ಆದ್ಮೇಲೆ ಯಾರಿಗೆ?
Somebody has to cultivate, somebody has to harvest. ಅವ್ರು ಮಾಡಕ್ ಬಿಡಿ ಅಷ್ಟು. Don't disturb.
Yes.
Purpose. The appellant shall not disturb the respondent from harvesting the crops grown in survey number 9 of Naduvinhalli, Kalaburagi Taluk, Kalaburagi district, till the disposal of the appeal before the first appeal. Yes. Sudhir Kulkarni. Sudhir Kulkarni.
For dispensation and await notice of the respondents. Other one is interim order. Obliged.
I am appearing on behalf of Ganesh. Assailing the order passed by the trial court on IA number 4, wherein the relief of impleading application was allowed, my lords, and the petitioners were impleaded, my lords. Suit is for suit, partition and separate possession. We are not related to the plaintiffs, my lords. The claim of the plaintiff is that in the year 86, Dadu narrate Madila Swami, that some of the properties were left out during the filing of the plaint in the year 22. Hence, she wanted to file this impleading application. Kindly, my lords, may peruse page 25, my lords. Adralli, may I read, my lords? Petition filed under Order 1, Rule 10(2), for the reasons, for the facts and reasons stated in the annexed affidavit, it is humbly prayed that Honorable Court to allow the petition by adding proposed persons as defendant number 10 and 13 in the top noted case in the interest of justice. My lords, affidavit alli ಏನು ಬರೆದಿದ್ದಾರೆ ನಾನು ಓದ್ತೀನಿ sir. Kindly, my lords. I am the plaintiff in the above suit, hence I know the defendants and facts of the case. It is craved to leave the Honorable Court to read the plaint and documents filed by me as part and parcel of this affidavit for the sake of brevity and repetition. I was forgotten to add 2 more properties in the plaint schedule. The suit properties are ancestral properties and joint family properties of us. Hence, the said properties are transferred in the name of proposed defendants by sale. My lords, without adding these properties by, without changing the prayer, my lords, amending the prayer, they have only included my names, my lords. And the trial court, without considering my objections, my lords, the alienation was done in the year 86, my lords. In the year 86, the alienation has been done, my lords. And my mother's vendor has purchased sold it to my mother in the year 86, my lords. Illa Swami, adralli illive illa Swami. There are around 47 suit schedule, 37 suit total properties, my lords. She claims to have forgotten and want to add extra Antama Swami. Without seeking the cancellation of those sale deeds and gift deed executed to by my mother, my lords. The trial court also doesn't consider those aspects, my lords. It will lead to multiplicity of proceedings, my lords. Again, they will have to file applications and applications. I'm not against my impleadment, my lords, without seeking the cancellation of sale deed and subsequent deeds. But nam sale deeds cancel agde hang ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. 86 ಅಲ್ಲಿ someone has alienated the suit property. That's why. The trial court has to look into that, my lords, before passing the order, my lords. Swami, without seeking, now related illa Swami, the plaintiff is not related to me, my lords. Yes. Yes, my lord. ನಾನು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. Yes. Who is also not related to plaintiff, my lords. That is why I am a grievance, my lords. And they should seek comprehensive relief, even in IM also. They should seek cancellation of the sale deeds. Obliged, my lords.
In the just matter, serial number 42, my lords. Inform the other side. ಅದು house, farm house ನಲ್ಲಿ ಇವರೇ ಇದ್ದಾರೆ. They have no other house. They are living in the house which are demolished. Thereafter, they are shifted there. They are living there.
Not for vacating. Latest order, they have been taking advantage of this
every time, my lord, when we visit the land, my lock is broken, they put a lock.
Yeah.
The house, the two shops type of the shutter is there. Adu farmhouse agi adu mane kattidide. Now nobody stays there. My equipments are kept, agricultural equipments. Now they want to take, because my lord, I have asked for not disturb.
That's why, my lord, I just see that there was a order of status quo. There was till the entire trial that's taken place. There was no complaint about any grievance or anything. Let the same thing continue. Next 7th, I will start my arguments. Let there be a stay then. Other decree. Yes. Stay then. Yes. That is still open. First appeal is continuation of the suit. That's why just a stay would be suffice, my lord. Stay of this thing. Yes, ma'am. That is a subject matter of appeal. Till then a stay, if that is a stay. Otherwise, we are in possession of the house. Actually, we have cultivated the land. Yes. Pardon? I will complete it. Well, the building, my lords, let it be maintained in as it is. Demolition, we are inside now. Adu hotandre will be nowhere. Adu hotandre will be on the streets. Till building, let it be maintained as it is. Because if he changes the mutation, if he gets please. Obliged.
Appear for the petitioner in this matter. Petitioner is challenging the order on IA, my lords, of amendment, my lords, IA number 5. Suit for possession, my lords. The matter was set out for reply argument, my lords. The application for amendment was filed, my lords, to change by the plaintiff, my lords, to change the boundaries, my lords. It was set out for the reply argument, my lords. Argument was concluded by the plaintiff. Memo of citation was also submitted by him. When the matter was set out only for the reply, my lords, this application was filed. Please, my lords. Please. 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 Plaintiff. Please, my lords, oblige. Lords, this is the appear for the petitioner, my lords. This is the defendant's writ petition, my lords, wherein in the appeal, my lords, an application for amendment was filed, my lords. That has been rejected, my lords. Amendment, my lords, to plead regarding the delay and laches, my lords, and other aspect regarding court fee, my lords, was to be amended, my lords. My submission, my lords, any application for amendment or the additional documents, my lords, it has to be heard along with the main appeal, my lords, as held by this honorable court, my lords. Because, my lords, if any, yes, my lords. It, along with the main appeal itself, my lords, if the application is deserved to be allowed, my lords, it can be allowed and remitted back before to the trial court, my lords. Amendment regarding the suit is barred by limitation, my lords, and another aspect regarding court fee, my lords. The plaintiff ought to have paid the court fee, my lords. These two aspects I have prayed in the amendment application, my lords. Lords, the contention is to be there in the written statement, my lord. Subsequently, yes, yes, my lord. Because another aspect, my lords, the acquiescence of waiver is also involved. Reason behind the plaintiff, my lords, have relinquished their right in the property, my lords, way back in their 1998, my lords. That is the aspect, my lords, I wanted to incorporate in my written statement, my lords. Partition separate position. Decreed, my lords. Defend number 1, my lords. Defendants, both defendants have filed. Para 9, my lords. So also court fee, my lords.
Please.
I am appeal for the petitioner, my lordship. The petitioner has challenged annexure IA number 12, my lordship. Annexure G, my lordship. The respondent number 1 to 4 have filed the claim petition before the on account of the death of the petitioner's wife. G, my lordship. Page 61, my lordship. The IA number 12 filed by insurance company, my lordship, that is allowed on application under order 16 rule 4, my lordship, to summoning the person, my lordship, the petitioner to the evidence of the before the tribunal. My lordship, the earlier the petitioner challenged the false involvement against the my vehicle that has been before this court, my lord, challenged the criminal proceedings that has been caused by the against the petitioners, my lordship. I produced the copy of the annexure C, my lordship, page number 23, my lordship. Yes, my lord, page number 61, my lordship. Order dated 24/9/2024, my lordship. The petitioner absent, no representation on behalf of petitioner, hence objections to IA taken as not filed, heard and perused. The evidence of the proposed witness is necessary to respond number 2 to prove his defense, hence IA is allowed, my lordship. That I am the summons witness, my lordship. The petitioner is a summons witness. Earlier, my lordship, on the basis of the respondent number owner of the vehicle statement, my lordship, the charge sheet against the police have filed against the charge sheet. The false involvement of vehicle against the petitioners, my lordship. That charge sheet has been filed before this honorable court. My lordship, the charges against the petitioner is already discharged, my lordship. Annexure C, my lordship. Again, my lordship, the come to the court again, witnesses have stated, my lordship. Allah, the vehicle involvement, again, matna witness band here, it is very difficult to, my lordship. The owner is very, my lordship, the annexure C, my lordship. I am rushing to the, my lordship, the petitioner. Allah, already criminal cases, my lordship, again, charge sheet filed again. Allah, therefore, the police have challenged the charge sheet, my lordship. The charge sheet has been quashed before this court, my lordship. Now involvement again to come to the court, my lordship, give the evidence to the my lordship, before the respondent to insurance company, my lordship. My lordship, the already my charges against the my vehicle is, my lordship, there is my lordship, the I produced the copy of the annexure C, my lordship, the the court on tribunal has also IO has been summoned, my lordship. The IO has filed this.
My lords, the yesterday's matter wherein in the previous writ petition, a stay has been granted against the no confidence motion, and that writ petition is still pending. Under that circumstances, my lords, any number of no confidence motion can be moved, subject to 3 restrictions. The first one is initial 15 months, it can't be moved. Second one, when once an attempt is made, when there is no quorum, then 6 months they can't move. The third thing comes to me, that is, when the matter is pending before the court and when there is an interim order, what is the procedure that has to be followed? It is mentioned in rules. Rule 3, subclause 2, provided. Yes, yes. Provided that, my lords, rule 3, 2, second paragraph, sub rule 2, second paragraph, provided that
where the holding of such meeting is stayed by an order of a court, an assistant commissioner shall adjourn the said meeting and shall hold the adjourned meeting on the day not later than 30 days from the date on which he receives the intimation about the vacating of the stay. After giving to the members a notice of not less than 15 clear days of such adjourned meeting. So here, a meeting is called, it is stayed. Unless it is adjourned or it is attended a finality, there can never be a second meeting. The same is also my case. Under that circumstances, I pray the Honorable Court to stay the proceedings. Yes.
Previous petition is infectious, has become infectious, madam. That's why they have, again, they have done the another notice, madam. And VK Salgar.
Yes.
Yes, madam. Gram Panchayat. Twenty-one, 25, madam.
Yes, 11. Twenty-eight, 11.
28.
Further, it was extended.
2056.
The meeting is adjourned. The restriction is not to the members. The restriction is to the assistant commissioner. May I pray to get the copy for further? Yes. By evening. Yes.
Lord, this writ petition is filed by the defendant number 6. The respondent number 1 herein filed a suit for my lord partition and separate.
Please. Yes.
Defendant number 6, my lord, wherein the plaintiff has filed a suit for my lord partition and separate position. Lord, may I permitted to pass on, my lord, the genealogy for the reference purpose.
ಇಲ್ಲ ಇಲ್ಲ ನಮ್ದು ಇವತ್ತು ಲೀವ್ ಮೇಗಿದ್ದಾರೆ.
Lord, the one Sugan Gowda is the my lord main propositor. Lord, his wife name is Sugama. Both are dead now. Lord, he has my lord the 4 sons and 2 daughters. That is the D1, D2, D3, and one my lord Sahib Gowda is dead. And plaintiff is the Hampama is the daughter, and one Sharama is the D4 my lord is the daughter. So totally 4 sons and 2 daughters my lord. Now this Hampama has filed a suit for my lord partition and separate position. Now my lord, this defendant number 11, 12, the dispute is that this Vishwanath Reddy has made Vishwanath Reddy wife and 2 daughters has made a party in the suit as defendant number 11, 12 and 13. I filed an application in the written statement also have taken contention that I am the my lord son of defendant number 1, Venkat. I am the defendant number 6, my lord. We have filed a written statement taking contention that
this defendant number 11, 12 and 13 are not the daughter, wife and Lord, and they are the wife and children of Vishwanath Reddy, but that Vishwanath Reddy is not the son of Lord Sahib Gowda. Because Sahib Gowda, according to us, the Sahib Gowda died issueless without married. Yes, my lord. Hampamma is the, they say that, my lord, they are the Hampammas, my lord. In the plaint, what she claims that this Sahib Gowda not died issueless, he got a son Vishwanath Reddy. Vishwanath Reddy also died. Not for my lord, stay some time, my lord, because they are really. No, already issue has been disseminated. Now, further proceedings, no, because they are. Trial cannot conclude Akbar. Trial concludes, my lord, that. Yes. Yes. No, suit is the now setting for, my lord, evidence of dependents. Not made a part of it. No.
Lords, plaintiff. The present petitioner is plaintiff, Lords. He filed a suit, she filed a suit for Muller's declaration of easementary rights regarding easement of necessity to pass over the suit schedule pathway. Lords, it's that stage of arguments were posted. The subsequently IA was filed for recalling application. This honorable court, Lords, observed and dismissed the IA. Then they filed the application. This honorable court order is not annexure D, page number 39, my lords. When this honorable court has dismissed, observing that the trial court has observed that from last 6 months they not commenced the arguments, then they filed an applications for producing some documents. That was dismissed, not on the ground that they filed it belatedly after the arguments. Our contention, what they are saying is, my lords, there was an encroachment of the Gram Tana. They did not say, my lords, if they are saying that there was an encroachment by the plaintiff over some of the properties of the Gram Panchayat, they would have, my lords, claimed a separate suit. They can't, my lords, now by virtue of these proceedings. And present IA prima facie, my lords, is dilatory tactics because earlier this court has observed and dismissed their application. Defendants. How? The application is at page number, not annexure. page number. House. And in the cross examination, they have admitted that my lords, we have not encroached the property, and the plaintiff and defendant are residing there as per the sale deed schedule. At page number 58, cross examination is. Obliged.
My lord, in this, the respondent has filed the complaint against the petitioner under section 138 of NI Act, my lord. Petitioner agreed to pay the 3 lakh of check amount by compromise at joint memo, my lord. And at the time of compromise, they paid the 50,000 amount, my lord. Then, and they agreed to pay the remaining amount in 2 settlements, my lord. Now, if they failed, they have to pay double amount. They have compromised, my lord. Now, by inconvenience of amount, they have not paid. They are ready to pay the remaining total amount, 2,50,000, my lord. Compromise order. Yes, my lord. The respondent has filed the execution petition, my lord. Yes, my lord. Yes, my lord. Party is also present, my lord. Next date is 28/1/28, my lord. They're ready to pay some amount on that day, my lord. Yes, my lord. Due is 2,05,000, my lord. Yes, my lord. On 28, he ready to pay. 28, sorry. 50,000 he ready to pay on to. Within 1 month, he will pay remaining all amount, my lord. 1 lakh ಕೊಡ್ಬೇಕಂತ 28 ತಾರೀಕು. 2 months ಅಲ್ಲಿ ಎಲ್ಲ ಪೇ ಮಾಡ್ತಾರೆ ಅಂತ ಮೇಲೆ 28. Yes, madam. Obliged, madam.
Sir. Vice Chair. Senior appearance.
Your lordship's mic seems to be off, my lord. This is a similar matter. Similar matter, the Gram Panchayat is Honali. Lord, the notice is dated 13th of December. And my lord, it is served on 19th of December.
What is the date?
Lord, 13th December is the date of the notice. And my lord, it is served on 19/12.
Yes, madam.
Yes, your.
When is it served?
19/12/2024.
Burkol AG is directed to accept.
Yes, CGP.
HCGP is directed to accept notice for respondents 1, 2, 3. Issue emergent notice to respondent number 4. Next
tomorrow,
one, the notice of no confidence issued by the respondent number 3 is though dated 13/12/2024. 24,
24.
24.
Hmm.
But the same seems to have been served on the petitioner, on 19/12/2025,
Sir, why?
24.
2024. And the meeting of the members is scheduled on 30/12/2024. Which is 24,
15 months.
yeah, the other
Contract.
annexure F. What is annexure F?
Milord, that is the election which is declared, Milord, for a new Upadhyaksha, Milord. Adhyaksha and Upadhyaksha. That is for tomorrow, Milord. It is scheduled tomorrow.
Full stop.
Meeting fixtures. Conducting a meeting.
The other petitions were disposed of, or?
No, it is kept on 23rd. AGA was directed to give the information.
Which is within the mandatory period of 15 days prescribed. Which is within the mandatory period of 15, which is within 15 days. And therefore falls foul of the provisions contained in Rule 3(1) of the Rules 1994. Now that the respondent, the respondent number 4 has issued a notice dated 9/1/2025 to hold elections to the post of president, the said elections scheduled on 18/1/2025 deserve to be stayed. Accordingly, the elections to the post of president or vice president?
Vice
Vice
President.
president of Yadu Honnalli Gram Panchayat, Sindigi Taluk, scheduled on 18/1/2025 is stayed. List this petition on 23rd.
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 But one correction, Milord. It is Rule 3(2), not 3(1).
Rule 3(2) of the Rules 1994.
My lord, hand delivery may be.
Yes, next.
Obliged.
Okay, KM Gate.
Take instructions.
Next to appear for petitioner. Petitioner has called in question Annexure E, my lord. The
Annexure?
notice issued by the Assistant Commissioner for convening a no confidence motion meeting as against the petitioner who is Adhyaksha, my lord. The representation was said to have been submitted by the respondents 4/2/23 on 1/1/2025. And the notice was issued by the Assistant Commissioner on 3/1/2025. It is served on the petitioner on 14th, my lord. On 14th.
14(1).
Yes, my lord.
What is there to show that?
Pardon?
What is there to show that it was served on 14th?
Well, immediately, they have not taken any specific acknowledgement, but it is the statement made by the petitioner.
Doesn't matter.
And here what
Produce
happens, my lord,
ಮಾಡಿದ್ರೆ,
no,
only if you produce some document to show it was served on 14th, I can consider.
no, it is there, only my submission. What has happened here? The persons who were supposed to move a representation before the Assistant Commissioner, my lord, they should be present in person, my lord. But I have made a statement in my written statement that the respondents, para number 11 of my petition, my lord, the respondents 5, 10, 11, 12, 13, 17, 19, 20, 21, 22, 23, who are the women elected Gram Panchayats, my lord, members, they have not put their signatures and they were not present before the assistant commissioners. my lord.
ಏನ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಸೈನ್ ಮಾಡಿದ್ರಲ್ಲ ಏನ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಓದಿ ಅದೇನು ಹೇಳ್ತಾರೆ?
Yes,
ಇಂದು ದಿನಾಂಕ 1/1/25 ಒಟ್ಟು
yes, my lord. That's
ಆರು
what-
ಆರು ಸದಸ್ಯರು ಖುದ್ದಾಗಿ ಹಾಜರಾಗಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
Yes. The presentation regarding all the members, my lord, either it is 2, 5, and that is not explained, 49(1). The present members' presentation is before the assistant commissioner is stated, my lord. So my humble submission, the women elected members of this Gram Panchayat member, they were not present before the assistant commissioner and they were not intending to have a motion of no confidence. But however, it is by the other respondents. One
Yeah.
submission, my lord, one submission. I have raised a specific ground that the para number 11 and 12, in the para number 12, my lord, I have stated, since all the women members were not present before the assistant commissioner, so it was by force, the other members have managed to file the representation.
ಅದನ್ನ ನೀವು ಮೋಸ್ಟ್ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಇದ್ ಮಾಡ್ಕೊಳ್ಳಿ.
It is there, my lord.
ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
That's what I have sought, my lord. Let the assistant commissioner be directed to produce the CC footage of his office on 1/1/2025. How many persons were present?
No.
Whether any woman member was present before the.
ಎಲ್ಲ ಆಗಲ್ಲ, ನೀವು ಅಲ್ಲಿ ವರ್ಕೌಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಲೆಕ್ಷನ್ 15 ದಿನ ಟೈಮ್ ಇದೆಯಲ್ಲ
Yes,
ಹೆಂಗೋ.
this is one ground. The other ground, 49 subsection 2 is now omitted. But the rules made thereunder 2018 with regard to receiving the representation and making inquiry to that effect, my lord. So those rules have been maintained as it is.
So that is if there's an allegation.
Yes, my lord.
There's no allegation.
No. Here, my lord, what happened that subsection 3 subclause 2 nulli, that provision which was made later on by the year 2018, by Act of 2020, that is not taken out, my lord. That procedure is still made available. So I submitted, my lord, there are no allegations as such.
Workout.
49(1). So therefore, my humble submission, my lord, on 3 counts, my lord, the representation submitted by the respondents was not required to be attended by the assistant commissioner.
The Adhyaksha of Chikli U Gram Panchayat, Chikli U Gram Panchayat, Kamlanagar Taluk, Bidar
Kamalnagar.
district, is before this court challenging a notice dated 3/1/2025 issued by the respondent number 2, proposing to hold a meeting of the members of the Panchayat to consider a motion of no confidence on 22/1/2025. Next para. The learned counsel, it is contended by the petitioner that though 15 members had allegedly submitted a representation to the respondent number 2, expressing lack of confidence in the petitioner, many of the female members, lady members, many of the lady members,
Yes, my lord.
many of the lady members were not present. Many of the lady members had not signed the representation and had not submitted it before the respondent number 2. She contends that these lady members were forced to claim that they had submitted a notice of representation. Therefore, he contends that the respondent number 2 was bound to verify whether the representation submitted was in fact by all the members or whether any of them were forced to submit such a representation. Full stop. She also contends that there is no allegation against the petitioner. The representation filed by the members. Full stop. Thus she contends that the impugned notice issued by the respondent number 2, proposing to hold a meeting of the members on 20,
22,
on
1, my lord.
22/1, 2025.
2025.
Deserves to be interfered with. Next, learned counsel for the petitioner reiterated the above contentions and contended that in addition to the above, the state government has not repealed the rules framed under section 49(2) of the rules, and therefore, the representation filed by the members ought to have been considered in the light of the rules. And the members ought to have made specific allegations in the representation requiring either expressing their lack of confidence, expressing the reason for their lack of confidence in the petitioner. Next para. The learned HCGP submitted that the requirement of the rules of 1994 is that two members signing the representation should appear before the assistant commissioner and submit the representation. She contends that the representation produced by the petitioner itself shows that out of 14,
15.
out of 15 members who had signed the representation, 6 had appeared personally before the assistant commissioner. She therefore contends that this was sufficient compliance of Rule 3(1) of the Rules 1994. She further contends that Section 49(2) of the Act has been repealed, and therefore the rules also die a natural death, and the petitioner cannot take advantage of the existence of the rules on the statute book to contend that the representation must be in accordance with the rules. Next, I have considered submissions of the learned counsel for the petitioner and the learned counsel for the respondents. Next para. The contention of the petitioner cannot be accepted for the following reason. Number one, there is nothing to show that the lady members who had submitted the representation had not signed the representation or had not consented for moving the representation, or that it was obtained forcibly from them. Full stop. The assertion made by the petitioner is without any basis, and therefore the proceeding scheduled on the meeting scheduled on 22/1/2025 cannot be stopped at the on the basis of an unsubstantiated statement of the petitioner. Full stop. As regards the ground that the rules framed under Section 49(2), rules framed to consider a request for non-confidence moved under Section 49(2) is not repealed, and therefore the representation of the members should be considered in the light of the rules, also is liable to be rejected, as Section 49(2) is no longer on the record book, and thus the rules framed thereunder are born still. Full stop. Are stillborn. Under the circumstances, the petitioner cannot contend that the representation has to be considered in the light of the rules framed to consider a no confidence motion under Section 49(2) of the Act. On all counts, the writ petition lacks merit and is dismissed. Yes, sorry, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಇದು.
Yes, ma'am.
Skadaganchi.
Yes. Lord's meeting is called on 32nd day.
13?
Second day.
ಯಾವತ್ತು?
Yes, ma'am.
30th is the notice.
On 21st.
30th December is the notice. 21st first. ಯಾವತ್ತು representation ಯಾವತ್ತು?
Representation ಕೊಟ್ಟಿದ್ದು 21/12.
21?
12,
ಎಲ್ಲಿದೆ?
24.
ಎಲ್ಲಿದೆ?
Page number 16.
Page number?
16, 16.
21/12.
Yes.
21/12 ಅಂದ್ರೆ 10 days ಅಲ್ಲ ಆಯ್ತು.
11 days, my lord, from the date of receiving, 21 has to be counted.
Huh?
21 has to be counted
21 ಯಾಕೆ ಕೌಂಟ್ ಮಾಡ್ತಾರೆ?
from the day, ಅದು ಬಿಟ್ಟರು ಕೂಡ 31 days.
30 days from the notice ಅಂತ ಇರೋದು.
Of the
30
service of
days from
notice.
the notice.
From the
From the date he receives the representation.
Read it again.
Yes, ma'am.
On the date of his election.
The Assistant Commissioner shall thereafter convey a meeting for the consideration of the said motion at the office of Gram Panchayat on the date appointed by him,
He
which
received
shall not be later than 30 days from the date on which the notice under subsection 1 was delivered to him.
from the date ಅಂದ್ರೇನು?
From the day he has received the notice.
That day also has to be counted? ಅಲ್ಲ, just
Yes,
tell me.
ma'am. Yes, ma'am. Because from the date that has to be counted. Even if not, it becomes 31 minutes here. Representation 21/12.
Hmm.
Meeting is on 21/1/25.
21/1,
25.
so that is also 31 days ಆಗುತ್ತೆ.
Yes.
ಬರ್ಕೊಳ್ಳಿ. AGS, HCGP is directed to accept notice for response 1, 2, 3. Issue emergent notice to respond number 4 to
4 to 16.
full stop. The private respondents had submitted a representation under Rule 3(1) on 21/12/2024 to the respondent number 2, 3, respondent number 3. Full stop. Therefore, the respondent number 3 was expected to hold a meeting within 30 days therefrom, that is by or before 20th of January 2025. However, the meeting is scheduled on 21/1/2025, which will stop. Rule 3(2) mandates that the Assistant Commissioner shall hold the meeting which shall not be later than 30 days from the date on which he receives the notice under sub-rule 1. In view of the above, the notice dated 30/12/2024 issued by the respondent number 3, proposing to hold a meeting of the members of the respondent number 4 on 21/1/2025 to consider the no confidence motion is state. Yes.
I pray for hand delivery since it is on Monday.
Yes, next.
And also
Ah.
serial number 48 ಅಲ್ಲಿ operative portion.
I'll release the judgment itself.
Because ಇಲ್ಲ judgment 4 ಆದ್ಮೇಲೆ ಆಯ್ತು ಸ್ವಾಮಿ, ನಾನು ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಕ್ಕಾಗೋದಿಲ್ಲ.
ನೀವು ಆನ್ಲೈನ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ. ಅಪ್ಲೋಡ್ ಮಾಡಿ.
Yes.
There is zero pendency after 15 days. Hello? Zero pendency. Yes. Shivanand Patil.
ಏನಾಯ್ತು ಕೇಳಿಲ್ಲ ನಾನು.
Indudar P. Jadhav. Ready?
Yes.
ಏನಾದ್ರು
One suit, my lords, was instituted by respondent number 1,
ಏನಾಯ್ತು ಅಂತ.
suit for partition in the year 2005. Suit came to be decreed, my lords, and respondent number 1 was granted 1/6 share in the suit properties. Notes in the earlier suit properties, notes at page number 38, suit properties 1 to 7 were earlier mentioned as suit properties.
Page number?
38, internal page, read petition. Notes after 11 years, my lord.
38 ಅಲ್ಲಿ, no?
38 only 7 properties, my lords.
Yes.
Thereafter, my lords, after 11 years, FDP was filed by respondent. In FDP, my lords, he includes 7 other properties. That is at page number 45. Suit properties from 8 to serial number 8 to 14.
Yes.
Yes. Lords, my submission is there is no preliminary decree in respect of suit properties 8 to 14. That apart, Lords, the court below has held that subject to inquiry, Lords, these suit properties, Lords, could be
Okay.
entertained. That my other submission was, Lords, in respect of the pecuniary jurisdiction of the court to entertain, Lords, in respect of these suit properties. Since, Lords, I have also produced the receipts of the sub-register where market valuation value of these suit properties were determined at as per annexure D series. Wherein, Lords, this particular court would not have jurisdiction, Lords, to entertain other suit properties or the present final decree proceedings. The suit valuation, Lords, in respect of these properties runs beyond 5 lakhs. So the appropriate court would be the senior division to entertain such final decree proceedings. That apart, Lords, even these suit properties are standing in the name of
Other side, Indudar Jadhav. Ganesh Naik,
Ganesh Naik is a formal party, Lords. He is representing
Indudar Jadhav. There is no representation for the respondent number 1. As a last chance list on.
Lords, may I request for an interim order because ಇದರಲ್ಲಿ final orders ಅಂತ ಇಟ್ಟಿದ್ದಾರೆ FDP ಅಲ್ಲಿ. That there was no stay and, Lords, there is no representation.
Interim stay of further proceedings before the final decree court in FDP
FDP 03 of 2016.
03 of 2016,
Much obliged.
pending before so and so.
Much obliged.
A. Ramachandra. There is no representation for the petition and the respondent list on. Shivanand Patil.
Lords, this, Lords, application under 26 rule 9 was sought by the petitioner. Suit for injunction simpliciter, Lords.
Suit is for injunction.
Injunction simpliciter. Evidence was commenced. It was the only claim of the respondent that, Lords, respondents, that, Lords, there is an alleged encroachment of 8 feet by 4 feet by the petitioner. Lords, the respondent got, Lords, surveyed the property and as per the surveyor, a report was filed alleging that, Lords, there is an alleged encroachment of 8 by 4 feet. Subsequently, Lords, the surveyor was cross-examined and, Lords, wherein the surveyor has admitted that there were 2 other surveys, Lords, prior to the report submitted by him. Since there was, Lords, a suspicious matter that, Lords, the alleged survey was conducted, Lords, upon the.
Yeah, why do you want another survey?
Lords, it is not upon, Lords, the direction of the court. It was in fact an application which was made by the respondent himself.
Was that report rejected?
No, Lords, I have denied the report, Lords.
So whether the report was rejected or not?
That was taken into consideration. The court below has held that, Lords, already there is a survey being filed.
Hello, Mr. Order 26 Rule 10 ನಲ್ಲಿ whether the court has accepted the report of the survey?
Yes, Lords.
Illiದೆ.
In the main order itself, Lords, it has taken into consideration the survey report.
Illiದೆ page number?
My impugned order, Lords, page 59 ಅಲ್ಲಿ. May I read the relevant portion, para 7 ಅಲ್ಲಿ? After going through the materials available on record, already the city surveyor was examined as CWN and also advocate for plaintiff. Shri NSS advocate at length fully cross-examined the said surveyor. The defendant produced the survey documents and those documents were marked. Already the city survey authority has surveyed the property as per the application given by the defendant and already the material documents were placed before the court. At this stage, there is no necessity to appoint the court commissioner in inspect the suit property.
ತಪ್ಪೇನಿದೆ? What is the mistake?
Lords, it is in the cross-examination, Lords, it is specifically stated that there were 2 other, Lords, surveys being conducted prior to, Lords, this report which was filed. In which, Lords, he states that
This
Allah.
man is examined before the court. CW1 is examined before the court.
Yes, my lords, in the cross examination also, he has stated that there were two other surveys, my lords, which were conducted. Ivaga, notes that comes
Two
to-
other surveys, but he is not before the
But,
court.
my lords, that was only in respect of the defendant's property. I mean, that is the respondent's property. He had surveyed only property number, survey number, no, property number, plot number 309/94, which is
Hmm.
the respondent's property. That is not in respect of, my lords, the petitioner's property.
Hmm.
ಇದು page 29 ಅಲ್ಲಿ cross examination ಇದೆ.
Other side yaru?
Other side Sanjay Patil sir.
Sanjay Patil.
Yes.
Sanjay Patil. There's no representation for the respondent number 1 to 3. As a last chance list on
Interim order may be extended.
interim orders extended to the next date.
Let's
Liaquat Farid Ustad. Shivanand Patil.
Appearing for petitioner, my lords.
Ready?
TPC.
Ready?
Yes, my lords. Suit for partition in separate portion, my lordship. I am the defendant number 7. I filed the application under order 14 rule 5 of CPC for framing the additional issues, my lordship.
Who are
The-
you, a member of the family?
Yes,
is
my
the
lord.
purchaser.
I am the purchaser, my lordship.
Yes. ಏನ್
The-
additional issue ಏನು?
The trial court has rejected the applications, my lordship.
ಏನ್ additional issue ನಪ್ಪ?
ನಾನು ಖರೀದಿದಾರ ಇದ್ದೇನೆ.
What is the additional issue?
Yes, my lordship. Ink page number 22, whether the defendant number 7 proves that he is the bona fide purchaser of the suit scheduled property, my lordship. My application is reject, my lordship. Hence this petition.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಿದೆ? Page 24 ಗೆ ಬನ್ನಿ.
Yes, my lordship.
ದಾವೆಯು ವಿತ್ತೀಯ ನ್ಯಾಯಾಧೀಕರಣದಿಂದ ಹೊರತಾಗಿದೆಯೇ?
Yes.
ಹಾಗಿದ್ದಲ್ಲಿ ದಾವೆಯು ನಿರ್ವಹಣಾ ಯೋಗ್ಯವಾಗಿದೆಯೇ? ದಾವಾ ಆಸ್ತಿಗಳಲ್ಲಿ ವಾದಿಯು ತನ್ನ ಕುಟುಂಬಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಎಲ್ಲಾ ಆಸ್ತಿಗಳನ್ನು ಸೇರಿಸಿರುವನೆಂದು ಸಾಬೀತುಪಡಿಸಬಲ್ಲನೆ? ನೀವ್ ಹೇಳ್ಬೇಕು.
My lordship, ಇದರಲ್ಲಿ ನಾನು ಖರೀದಿದಾರನಾಗಿದ್ದು ಆ ಇಶ್ಯೂನ ಇದರಲ್ಲಿ ಫ್ರೇಮ್ ಮಾಡಿಲ್ಲ. ಹಂಗಾಗಿ ನನ್ನ ಹಕ್ಕು ವೈಲೇಷನ್ ಆಗ್ತದಂತ ಆ
ಇಶ್ಯೂ
ಕಾರಣಕ್ಕೆ.
ಫ್ರೇಮ್ ಆಗಿದೆಯಲ್ಲ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 23.
Yes, my lordship.
ನಿಮ್ಮ ಐಎ ಇರೋದು ಅಲ್ಲಿ.
Annexure D, my lordship, ink page number 23.
ಓದಿ.
ಅಂತಿಮ ಅರ್ಜಿ ದಿ ಪ್ರಸನ್ನ ಆದೇಶ 14 ನಿಯಮ 5ರ ಅಡಿಯಲ್ಲಿ ವೆಂಕಟರೆಡ್ಡಿ ಸೊ ಅರ್ಜಿದಾರ ವಿರುದ್ಧ ಬನಶಂಕರ್. ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅರ್ಜಿದಾರ ಪ್ರತಿವಾದ ಸಂಖ್ಯೆ 7 ತನ್ನ ಲಗತ್ತಿಸಿರುವ ಶಪಥ ಪತ್ರದ ಮೂಲಕ ವಿನಮ್ರವಾಗಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದ್ರೆ, ಸದರಿ ದಾವೆಯಲ್ಲಿ ಕಾನೂನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿವಾದಾಂಶಗಳು ಕೈ ಬಿಟ್ಟಿರುವುದರಿಂದ ಸದರಿ ವಿವಾದಾಂಶಗಳನ್ನು ಸೇರಿಸಲು ಅರ್ಜಿದಾರರ ಪ್ರತಿವಾದಿಯು ಕೋರುತ್ತಿರುವನು ಮತ್ತು ಈ ವಿವಾದಾಂಶಗಳು ದಾಯ ಸ್ವರೂಪ ನಿರ್ಧರಿಸಬಲ್ಲವಾಗುವುದರಿಂದ
ಈ ವಿವಾದಾಂಶಗಳ ರಚನೆ ಅತ್ಯವಶ್ಯಕವಾಗಿದ್ದು ಸದರಿ ವಿವಾದಾಂಶಗಳನ್ನು ನ್ಯಾಯಿಕ ಹಿತಾಸಕ್ತಿಗಳಿಗನುಗುಣವಾಗಿ ಹೆಚ್ಚಿಸಬೇಕೆಂದು ಪ್ರಾರ್ಥಿಸುತ್ತೇನೆ.
Yes, my lord. ದಾವೆಯು ವಿತ್ತೀಯ ನ್ಯಾಯಾಧಿಕರಣದಿಂದ ಹೊರತಾಗಿದೆ.
ಏನಂಗಂದ್ರೆ ವಿತ್ತೀಯ ನ್ಯಾಯಾಧಿಕರಣದಿಂದ ಅಂದ್ರೆ
ಅಂದ್ರ ಜುಡಿಡಿಕ್ಷನ್, my lord.
ಏನ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್? ವಿತ್ತೀಯ ಅಂದ್ರೆ ಏನು? ವಿತ್ತೀಯ ಅಂದ್ರೆ ಏನ್ರಿ? ಹಾ ಮತ್ತೆ ಓದ್ ರೆಡಿ ಅಂತೀರಾ?
ಪೆನಿಕ್ಯುರಿ ಜುಡಿಡಿಕ್ಷನ್. ಎರಡನೇದು
ಟೆರಿಟೋರಿಯಲ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್, ಪೆಕ್ಯುನರಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್. ವಿತ್ತು ಅಂದ್ರೆ ಏನು?
ವಿತ್ತೀಯ.
ಹಾ
ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ನೆಕ್ಸ್ಟ್.
ಹಾಗಿದ್ದಲ್ಲಿ ದಾವೆಯು ನಿರ್ವಹಣಾ ಯೋಗ್ಯವಾಗಿದೆ. ಮೂರನೇದು, ದಾವಾ ಆಸ್ತಿಗಳಲ್ಲಿ ವಾದಿಯು ತನ್ನ ಕುಟುಂಬಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಎಲ್ಲಾ ಆಸ್ತಿಗಳನ್ನ ಸೇರಿಸುವನೆಂದು ಸಾಬೀತುಪಡಿಸಬಲ್ಲನೆ.
ನೀವೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನೋ ಹೇಳಿದಿರಾ ಇಂತಿಂತ ಆಸ್ತಿಗಳನ್ನ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ? ಮತ್ತೆ ಹೆಂಗೆ ಇಶ್ಯೂ ರೈಸ್ ಆಗುತ್ತೆ? ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
My lordship, in page number 17, annexer B,
ಓದಿ.
page serial number 5.
ಓದಿ.
ವಾದಪತ್ರದ ಪ್ಯಾರಾ 5ರಲ್ಲಿ ವಾದಿ ಹೇಳಿರುವ ಅಂಶಗಳು ಅಗತ್ಯವಿರುವುದರಿಂದ ಕಂಡುಬರುವುದರಿಂದ ಈ ಪ್ರತಿವಾದಿಯು ನ್ಯಾಯಯುತ ಖರೀದಿಯನ್ನು ಅಲ್ಲಗಳೆಯುವ ಉದ್ದೇಶದಿಂದ ದಾವಾ ಆಸ್ತಿ ಕ್ರಮ ಸಂಖ್ಯೆ 2ರ ಸುಳ್ಳು ಮಾಹಿತಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಿರುವನು. ಆದ್ದರಿಂದ ಈ ಪ್ರತಿವಾದಿಯು ಸ್ಪಷ್ಟ ಪುರಾವೆಯನ್ನು ಬಯಸಿರುವನು.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ಬೇರೆ ಆಸ್ತಿಗಳನ್ನ ಸೇರಿಸಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Lordship, in page number 18, ವಾದಪತ್ರದ ಪ್ಯಾರಾ 8, ಇದು ಅಸತ್ಯದಿಂದ ಕೂಡಿದ್ದು ಈ ಕುರಿತಂತೆ ಪ್ರತಿವಾದಿಯು ಸ್ಪಷ್ಟ ರುಜುವಾತನ್ನು ಬಯಸುತ್ತಾನಲ್ಲದೆ ಮತ್ತು ಈ ಪ್ರತಿವಾದಿಯು ದಾವಾ ಜಮೀನಿನ ಖಂಡಿತ ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಂಡಿರುವ ಸಮಯಕ್ಕೆ ಮಾಡಿರುವ ಖರ್ಚು ವೆಚ್ಚಗಳು ಮತ್ತು ದಾವಾ ಜಮೀನಿನ ಕುರಿತಂತೆ ಪ್ರತಿವಾದಿ ಸಂಖ್ಯೆ 1 ಈತನಿಗೆ ನೀಡಿದ್ದ ದೊಡ್ಡ ಮೊತ್ತದ ಹಣವನ್ನು ನುಂಗಿ ಹಾಕುವ ದುರುದ್ದೇಶ ಹೊಂದಿರುವಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡು ಬರುತ್ತದೆ.
ಎಲ್ಲಿ ಹೇಳಿದೆ?
ಇಂಕ್ ಪೇಜ್. Denying the all averments filed by the plaintiff, my lordship.
Please read the last sentence in that para, page 18 ಅಲ್ಲಿ.
Yes.
ಓದಿ. ಸದರಿ ಪ್ರತಿವಾದಿ ನಂಬರ್ 6 ಹೊಂದಿರುವ ಮಾದ್ವಾರ ಸೀಮಾಂತರದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 174/A ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 174/E ವಿಸ್ತೀರ್ಣ 3 ಎಕರೆ ಇದು ಕೌಟುಂಬಿಕ ಆಸ್ತಿಯಾಗಿದ್ದು ಇದನ್ನೂ ಸಹ ವಾದಿಯು ಕೋರಿರುವ ಪರಿಹಾರದಲ್ಲಿ ಅನುಗುಣವಾಗಿ ಸೇರ್ಪಡೆಗೊಳಿಸುವುದು ಅಷ್ಟೇ ಅವಶ್ಯಕವಾಗಿದ್ದು ಒಂದು ವೇಳೆ ಸದರಿ ಆಸ್ತಿಯನ್ನು ದಾವೆಯಲ್ಲಿ ಸೇರ್ಪಡೆಗೊಳಿಸದಿದ್ದಲ್ಲಿ ಕೌಟುಂಬಿಕ ಆಸ್ತಿಗಳಲ್ಲೂ ಈಗಾಗಲೇ ವಿಭಜನೆಯಾಗಿದೆ ಎಂಬುದನ್ನು ದಾವೆಯ ಉಳಿದ ಎಲ್ಲಾ ಪಕ್ಷಗಾರರು ಸಾಬೀತುಪಡಿಸಿರುತ್ತಾರೆ. Yes, Mr.
In fact, plaintiff is the master of the suit. So insofar as the respondent.
Partial partition is raising a
Yes,
contention.
lords, that apart he is only the purchaser of the suit property. One of the suit properties. That apart he is not having any knowledge regarding the properties which are concerned to the
He
joint.
can non-suit you. He can non-suit you by taking a contention available in law. ಇವಾಗ ಫೈನಲ್ ಡಿಗ್ರಿ ಆದ್ರೆ ಈಕ್ವಿಟೀಸ್ ಹೆಂಗ್ ವರ್ಕೌಟ್ ಮಾಡೋದು? ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿ ಸೇರಿಸ್ತಾ ಇದ್ರೆ.
Please, I leave it to the court.
ಬರ್ಕೊಳ್ಳಿ. ಓದ್ಕೊಂಡ್ ಬನ್ರಪ್ಪ. Please prepare yourself, mister.
Please.
The defendant number 7 in OS number so and so on the file of so and so is before this court. Challenging an order dated so and so by which an application filed by him and order 14 rule 5 of CPC was rejected. Next para. The suit in OS number so and so was filed for partition and separate possession of the plaintiff's share in the suit shell properties. Full stop. The defendant number 7 was a purchaser of item number
Please, madam.
Suit number, suit.
item
number.
number ಯಾವ್ದಪ್ಪ?
OS number 30 of
Property, suit property.
suit property.
purchaser of one of the items of the suit schedule properties. Full stop. The defendant number 7 contested the suit
Item number 2 is not
and
secure.
claimed that the plaintiff had
Item 2.
not included all the properties of the family and had also set out that survey number 174 bar A and 174 bar E measuring 6 acres was not included in the suit for partition. He also claimed that the value of the suit properties was beyond the pecuniary jurisdiction of the trial court. Full stop. ಯಾವ ಸ್ಟೇಜ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು?
To commencement of
On these contentions,
Evidence is.
the trial court framed issues and set down the case for evidence. At that stage, the defendant number 6 filed an application under Order 14 Rule 5, suggesting the following issues. Small Roman 1, whether the suit is barred by pecuniary jurisdiction. Number 2, whether the suit is maintainable. Whether the plaintiff proves that all the family properties are included in the suit schedule. The trial court, in terms of the impugned order, rejected the application on the ground that the application was filed at the stage when the suit was set down for evidence of the defendant number 7. It held that the plaintiff had valued the suit at a sum of rupees 6 lakhs and had paid maximum court fee of rupees 200. And therefore, the defendant number 7 could not claim that the suit was barred by, could not claim that the trial court did not have the jurisdiction to try the suit. Consequently, it rejected the application in terms of the impugned order. Being agreed with the said order, the defendant number 7 has filed this petition. Next, the learned counsel for the defendant number 7 contended that a specific issue was raised by the defendant number 7 in the written statement that certain properties that belonged to the family in the name and which stood in the name of the defendant number 6 was not included in the suit for partition, and therefore a suit for partial partition was not maintainable. He thus contends that the trial court must have framed an additional issue as to whether the suit for partial partition was maintainable. Full stop. The learned counsel for the plaintiff did not dispute that the defendant number 7 had raised a contention that certain properties that stood in the name of the defendant number 6 was not included in the suit for partition. He, however, contends that the property that stood in the name of the defendant number 6 was not the property of the joint family and therefore was not available for partition. Next paragraph. If the defendant number 7 has raised a contentious issue in the written statement, then certainly the question will, an issue as to whether a suit for partial partition was maintainable or not would arise for consideration. Full stop. Since the defendant number 7 has raised a contention that certain properties that stood in the name of the defendant number 6, which belonged to the family, was not included in the suit for partition, the trial court must have framed an issue and must have imposed the burden of proving the said issue on the defendant number 7. Full stop. To that extent, the application filed by the defendant number 7 merits consideration. Consequently, the following order is passed. The writ petition is allowed in part. The impugned order passed by the trial court rejecting IA number 9 filed by the defendant number 7 and Order 14 Rule 5 of CPC is allowed in part. The trial court is directed to frame the following issue. Whether the defendant number 7 proves that the suit filed by the plaintiff is for partial partition and therefore not maintainable. Question mark. Since the suit is filed in the year 2000,
Sixteen.
16, the trial court is requested to dispose of the suit as early as possible. And in accordance with the Karnataka case flow in subordinate court rules 2005. Yes. Great. Deepak Barat, Mohammed Vikaruddin, Jairaj Bukka, Manvendra Reddy, Bandila. He is not here. Deepak, Mohammed Vikaruddin Ilwala. There is no representation for the respondents in serial number 62. Hence list as a last chance list on DP Ambekar, Manvendra Reddy.
Defendants before the trial court are the petitioners.
Defendants.
Defendants before the trial court. Respond one herein is the plaintiff before the trial court. Respond two is the defendant number 3, pro forma party. The case of the respond number 1 before the trial court was, he claims that this thing, creditor in interest of the defendant petitioners herein, has entered into an agreement of sale for a total consideration of 14 lakh, out of which 8 lakh was paid, balance 6 lakh was due. That agreement was entered in the year 2009. In the year 2013, suit was filed. Peculiarly, suit was filed for declaration of title and for mandatory injunction for directing the defendant to take the balance amount and execute a sale deed. Actually, it should have been one for specific performance.
Right.
So now, my lords, after the trial has almost ended, petitioner side has been closed. I filed an application to dismiss the suit as not maintainable.
On what ground?
On ground that it is a prayer is not maintainable at all.
Prayer.
Prayer itself. Kindly, my application is Annex Reddy, page 41.
Substance alva.
Pardon?
It is a substance, not the form.
But Supreme Court judgment is on the Atmaram next date. It is clear that the mandatory injunction cannot be. And in fact, even into Specific Relief Act, where any relief can be obtained by any other prayer, we can't seek injunction for that.
41.
Order 41, that is the bar.
Correct, but ಇಲ್ಲಿ mandatory injunction ಕೇಳ್ತಾರೆ ಏನಂತ to execute the sale deed.
To receive the balance amount and execute the sale
Official
deed.
pleadings.
Pardon?
Official pleadings.
Everything is.
ಏನ್ ಮಾಡೋದು? What to do?
ಅದೇ ಇದೆ.
What to do? Declare that the plaintiff is entitled to the suit properties by virtue of the agreement of sale and consequently to mandatory injunction to execute the sale deed in favor of plaintiff.
Yes. After I filed an application to dismiss the suit, they filed another application as counterblast to rectify the prayer to one of specific performance. Trial court has passed an order that it has clarified that amendment will not relate back to date of complaint. That has clarified, thereby protecting interest of the defendant also.
Your application rejected.
My application rejected, their application allowed. My application to dismiss the suit was rejected. Their application to amendment.
Wrong.
Pardon?
It is wrong.
I leave it to the court.
Substance.
I understand. In fact, protect to Madidare.
Yeah.
My interest is also protected.
ಏನಂತ?
It will not relate and that is clarified. That is the law.
The defendants 1 and 2 in OS number 11/2013 on the file of so and so are before this court challenging the correctness of an order dated so and so by which an application filed by them under section 151 to dismiss the suit was rejected. Next para.
And also another application filed by plaintiff also.
The defendants are also aggrieved by an order dated 2/6/2022.
Yes.
By which an application filed by the plaintiff to amend the prayers for in the suit was allowed. Next one. The suit in OS number 11/2013 was filed for the following reliefs. Copy now. A and B.
The one, the original plaint is on prayer, is on page 14.
14.
14,
Page
amended plaint is buried there.
Full stop. The defendant contested the suit. Defendant number 1 contested the suit. Sorry, defendants 1 and 2 contested the suit. Inter-alia contending that the suit in the contending that inter alia denying the entitlement of the plaintiffs, denying the entitlement of the plaintiff for the relief sought for. Full stop. When the suit was set down for, any evidence ka?
Plaintiff add-ons closed.
When the suit was, when the evidence of the plaintiff was adduced, was concluded, comma, the defendants filed an application under section 151 of CPC to dismiss the suit as the relief sought for was not in accordance with section 10 of the Specific Relief Act, but was for a declaratory relief and for mandatory injunction. Full stop. Soon thereafter, the plaintiffs filed an application under Order 6 Rule 17 to amend the relief sought for in the suit and to incorporate the following.
In
IA.
IA is
To
not at
incorporate the
page
following reliefs
Page 20, 47.
47 minutes, Annexure F.
and to incorporate and to substitute the suit reliefs by the following, with the following.
Please,
Page 47, 48.
Page 48 ಅಲ್ಲಿ ಇದೆ.
please 48.
Full stop. The trial court, in terms of the impugned order, rejected the application filed by the defendants and allowed the application filed by the plaintiffs and plaintiffs. However, it held that the amendment shall not relate back to the date of the suit, but shall be with effect from the date of filing the application. Being agreed by the said orders, the defendants 1 and 2 are before this court. Next para. The learned counsel for the defendants 1 and 2 contended that the defendants, that the plaintiff had sought for the relief of mandatory injunction to direct the defendants to execute a sale deed. He contends that under section 41 of the Specific Relief Act, comma, if the plaintiff was entitled to seek for relief under any other enactment,
Any other provision?
any other
Provision.
provision of law, comma, is prohibited from seeking for mandatory injunction. Full stop. He therefore contends that in the contents that the relief sought for by the plaintiff was not maintainable, and the trial court must have allowed the application and dismissed the suit. He also contends that long after the suit was filed and after the defendants pointed out to the mistake in the plaint prayers, the plaintiff filed an application under Order 6 Rule 17 of CPC to amend the prayers. He contends that the proviso to Order 6 Rule 17 mandate that no application for amendment can be entertained after the issues are framed. Thus, he contends that the trial court committed an error allowing the application filed by the next para. Per contra, the learned counsel for the plaintiff contended that the relief sought for in the suit were essentially for the relief of specific performance, though it was not properly worded. He contends that the basis of the relief sought for by the plaintiff was the agreement of sale executed by the defendants 1 and 2. Thus, he contends that he further contends that it is the substance and not the form that has to be looked into while considering the application filed by the defendant 1 and 2. Besides this, he also contended that under Order 7 Rule 14, 7 Rule, Order 7 Rule,
11, rejection of.
Order 7 Rule 14,
Okay.
7 Rule 7, comma, the court is always at liberty to mold the relief. Mold the relief. Mold the relief. Therefore, he contends that the trial court was right in rejecting the application filed by the defendants 1 and 2. He also contends that the amendment sought for was necessary so as to liquidate the grounds urged by the defendants in their written statement that the suit was not maintainable. He contends that this amendment was allowed by the trial court with effect from the date of the application and thus protected the interest of the defendants 1 and 2, did not prejudice them in any manner whatsoever. Therefore, he prays that therefore prays that the petition be dismissed by confirming the order dismissed and confirm the order passed by the trial court. Next paragraph. I have considered the submissions of the learned counsel for the plaintiff and the learned counsel for the defendants. Next paragraph. A perusal of this relief sought for by the plaintiff in the suit. In a perusal of the amendments made in the plaint would establish that the plaintiff was enforcing the agreement of sale dated 25/11/2009. Therefore, the plaintiff must have been diligent in claiming the reliefs properly as provided under section 10 of the 10 and 16.
10 to 22 of the specifically.
10, 16 and 20 of the specific relief act. Be that as it may, as rightly contended by the learned counsel for the plaintiff, it is only the substance and not the form that the court must look into. Full stop. The trial court was therefore justified in not entertaining the application filed by the defendants 1 and 2. Full stop. Insofar as the amendment of the suit, insofar as the application filed by the plaintiff for amendment of the plaint to suitably modify the relief sought for in the suit, this did not prejudice the defendants in any manner whatsoever, notwithstanding the fact that the application for amendment was filed after the issues were framed in the suit. Full stop. The trial court has sufficiently taken care of the interests of the defendants by holding that the amendment shall be with effect from the date of the application and shall not revert to the date of the suit. In that view of the matter, no interference is warranted with the orders passed by the trial court. Hence, both the petitions are dismissed.
Only one. One written ಎರಡು.
Sorry, hence this petition is dismissed. ಸಾಕು ಎರಡು ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಿದೆ ನಿಮಗೆ ಬೇಡ ಮುಂದೆ
ಇನ್ನೊಂದು ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆ ಶಾರ್ಟ್ ಮ್ಯಾಟರ್ ವೆರಿ ಶಾರ್ಟ್.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಂಗಿದ್ರೆ ಬೇಡ.
ಇಲ್ಲ ಅದೆಲ್ಲ ಹೋಗುತ್ತೆ.
ಬೇಡ ಬೇಡ.
ಅಲ್ಲ ದಟ್ ಈಸ್ ಅಲೌಡ್.
Don't want to embrace you again and again.
ಇಲ್ಲ ಅದೇನು goes with.
All right.
71, my lord, may I request for a date? Serial number 71, appearing for the respondent. Election petition matter, my lord, I have filed the review petition. The court has not considered court commissioner report anteli.
ಯಾವತ್ತು ಬೇಕೋ ಅವತ್ತು ಹಾಕ್ಸ್ಕೊಳ್ಳಿ.
Not any day.
64 there is an interim order, my lords.
Interim order is extended till the next date.
Next date. 64 ನೇ ಮಾಡಿ. 64 ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆ.
ನಿಮ್ದು ಅಷ್ಟೇ ಅರ್ಜೆಂಟ್ ಆಗಿ ನಮ್ದು ಅದ.
ಮೇಡಮ್
ಅಸ್ವರ ಮಾಡಿ
ದೋಸೆ ಮೇಡಮ್
ಕರೆದಿಲ್ಲ
ಕರೆದ್ರೆ ಬಿಸ್ನೆಸ್
ಕರೆದಿಲ್ಲ ನಾನು ರೆಕಾರ್ಡಿಂಗ್ ನೋಡಿದೆ 71 ಹೋಯ್ದೆ ನೀವು ಫಿಸಿಕಲ್ ಓದ್ತೀರಿ ಅದೆಲ್ಲ ಹೇಳಿದ್ರ ರೆಕಾರ್ಡ್ ಆಗಿ ನೋಡಿದ್ರೆ
Hello. 69 tender but
1 minute sir, 1 minute line per hour 1 minute
tender then 27
71
70 entry ಮಾಡಿದ್ರೆ entry ಮಾಡಿದ್ರೆ
कल आ रहा हूँ हेलो वही कल 9:30 को आते डेट फिक्स 1 मिनट हाँ जल्दी ಬೇಕು 71 जल्दी ಬೇಕು थोड़ा मैं भी करता हूँ 2 मिनट 71 ನಾ 70 ಜಲ್ದಿ ಯಾವತ್ತು 30ನೇ ತಾರೀಕಾ
ಅಲ್ಲ 2 weeks 72 respond ಎಲ್ಲಿ ಇದು ತಪ್ಪಿಸೋದು 33 ಅಲ್ಲ
31
rectification deed of